Good morning, everybody. Welcome back. Everybody have a good day off yesterday? A little bit of a surprise. Can't say I was complaining. We had some work to do in the chicken enclosure. We are moving the chicks into the adult area. So there's like a merging of the flocks, but you have to be a little bit careful with it because the big birds can be mean, man. Chickens can be freaking vicious. And so you got to make sure they got little safe places they can get to and stuff like that. So the big chickens can't necessarily bully them around and stuff. Went ahead and took the afternoon off yesterday to start getting that taken care of. So just make life a little bit easier for everybody, and getting those little babies incorporated into the better, new and improved adult grown-up chicken scene. So didn't mind that one bit, but I do hope if it was Karen that was sick yesterday, whoever was sick yesterday is recovered and doing well. Have not heard any indication that we are not having court today either. So I am keeping my eyes out, but at least at this point in time, far as we know, everything is back on track, just the way we expect it to be. Well, I saw something yesterday that just gave me joy inside. It made my heart sing. So I'm going to share it with you guys. It's this order. This order from the First Circuit. I'm going to blow it up nice and big so that we can all enjoy it. Remember yesterday, we looked at Mark Randazza's latest filing to the First Circuit dealing with the buffer zone. So to recap, last Friday, the First Circuit Court of Appeals said, yes, Mr. Randazza and your clients, you are correct. This order establishing the buffer zone is exceeding the bounds of what the First Amendment permits as far as intrusion into a constitutionally protected activity. So you need to revise it. If folks want to engage in quiet, not loud, but just quiet protests that won't disrupt the trial proceedings by, for example, having things written on their clothing, holding signs, etc., they are allowed to do that. This is a traditional public forum, protected place for constitutional activity. So send it back down to the district court to say, look into modifying this order. And then the district court apparently also just turned around, sent it back down to Judge Canoni, said, here you go. Here's the instructions that you received from the First Circuit. The order needs to be modified. Please take care of it. Well, so as of Monday, that hadn't happened. And so Mr. Randazza filed a motion in the First Circuit Court of Appeals pointing out, hey, your decision was made. It's been several days. Nobody has modified it. Filed that declaration from somebody who showed up in a Norfolk County is run by criminals sweatshirt and was hassled by police over that in the buffer zone. And so asked for kind of some further oversight and instruction from the First Circuit about exactly how this is going to be addressed. It's been found to be a violation. Nothing seems to be happening. Could you maybe do something, crack the whip a little bit? And lo and behold, they did. It gives me such joy. It's not a long order that they entered, but it just makes me feel so good, and we'll talk about why. The court is in receipt of plaintiff's appellant's emergency motion for clarification and to enforce this court's May 9, 2025 judgment, parentheses, the motion. Defendants' appellees shall respond to the motion within 48 hours of the issuance of this order. In their response, defendants' appellees are directed to address specifically what steps the prosecution in Commonwealth versus Reed, Norfolk Superior Court Department docket number, case number, has taken, if any, in response to the issues raised in the per curiam issued May 9th, 2025, particularly in light of the fact that the challenged state court memorandum of decision and order was adopted in response to the Commonwealth's motion for buffer zone. By the court, Anastasia Dubrovsky, clerk. Filed yesterday. This gives me joy. Why does this give me joy? They have put the responsibility squarely where it lies on the defendant appellees. The trial court, Judge Cannoni, the MSP chief, the Dedham police chief, and of course, Michael Morrissey. You guys wanted this order. You guys presented the order. You guys signed the order. You guys have been enforcing the order. So you guys have to explain what you're doing to comply with the First Circuit's decision and direction to modify the order. I love this. It gives me so much satisfaction because, I mean, all the way back to some of the earliest days in the courts, getting the court to enforce an order is often one of the trickiest parts of it. Getting a judgment is fairly easy. Collecting a judgment can be a nightmare. Look at Ron Goldman. This came up as well. We talked about it in Depp v. Heard. Get that judgment, but how exactly do you collect it? There's no like automatic siphon into a person's bank account. How do you force them to pay what they owe? And this comes up a lot on appeal too. I'll go through a case. It'll take, maybe a year and a half, 2 years, win the case. Something's supposed to happen. My client's supposed to be resentenced. They'll do less time. Maybe they'll even be released because of it. And the appeal is resolved. It's sent back down. And what happens? It sits. It sits. Because the people who are in the position and should have the responsibility to carry out that order, they just don't do anything about it. They just don't do anything about it. And so, it ends up kind of being the job of the person who wants the court to do something to keep pushing that rock up that Sisyphean hill. Trying to get attention, trying to get it taken care of. I had a client spend like an extra month in jail once. See, what happens in Washington is once the appeal is done, the appellate attorney is also done. We have this kind of different division between, you represent people in the appellate court versus you represent people in the superior court. So once the appellate process is done, the case is sent back down to superior court, the appellate attorney is done. So what's supposed to happen? Court is supposed to get directions from the Court of Appeals, decide, hey, part of the instructions you get in Washington from the Court of Appeals is put this on your next docket to carry it out. And so, normally that's what happens. They get it on. And one of the very first things they'd need to do for a resentencing is reappoint a superior court level attorney, trial attorney for that person. But if they don't, then the case has a nasty little tendency to just fall off the radar. Just falls off the radar because appellate counsel's out. It's not your case anymore. You're not monitoring what goes on superior court. You can't do anything in superior court because you don't represent them there. They just forget to appoint a superior court attorney. Prosecutor just forgets to put the case on the docket for, revision of the order or whatever it is. And it just sits there. Nothing happens. So it's just, is it intentional? I don't know. Maybe sometimes it's just another way to get the little pound of flesh. Sit on it until somebody is going to force you to do what you don't want to do. And sometimes it may, it's, probably most of the time, I don't think most prosecutors and stuff are, malicious like that. It's a little high risk to do that anyway. You get caught and not going to be in a very good position. But it's just not a priority, so nobody pays attention to it and, doesn't get corrected. So I had a client spend a whole extra month in prison once because it just sat there. Nobody did anything. Nobody followed up. Yikes. Finally, the client's contacting me because there's, nowhere else to go. They don't have an attorney. The court has ignored the mandate from the Court of Appeals, not done anything about it. Client finally gets a hold of me. I'm able to go kind of rattle some cages and get it taken care of. But that's why this gives me such great joy, is because, the responsibility for modifying this order, it's on who asked for the order and who signed the order. It's you guys. It should not have to be these plaintiffs' job to force the court to do what the appellate judgment says. They shouldn't have to be in the position of, compelling correction of the order. You guys wanted it? You guys can fix it. So 48 hours, that means tomorrow. Tomorrow. This is not quite on the level of like a show cause. It's not quite on the level of a show cause. So an order to show cause is the typical way that a court will pursue a contempt proceeding. They've issued an order. You haven't followed it. An order to show cause is a direction to come into court and explain yourself. Show me why I should not hold you in contempt because you did something I told you not to do, or you didn't do something I directed you to do. Come in and show me why I shouldn't hold you in contempt. That's the order to show cause. This isn't quite at that level, but it's got a real similar flavor, doesn't it? Doesn't it? Explain yourselves. Explain yourselves. Because Mr. Randazza made the very excellent point that every day that the order continues unmodified, the First Amendment rights of the folks there in Dedham are being violated. It's ongoing and continual. So explain yourselves. And the thing is that I feel pretty confident that most legal folks reading this order, they understand that the only really good explanation that is going to be available here is, my bad, here's the modified order. I fixed it. Here it is. Okay, we're busy. We're in trial. No, not going to fly. That is not an explanation. That is you ignoring the court's order. That's you kicking the can down the road. That's you continuing to violate the First Amendment rights of the protesters. So really the only good explanation is going to be, here's the modified order. Here's the revision that we came up with. And if that isn't their explanation, well, then the instructions might get a little more direct. They might get a little more strict. They might be a little less patient. 48 hours should be plenty of time. Should be plenty of time to go back and tweak this, considering this was already entered 4 days You already had 4 days from the time that the decision came down. So by the time you need to explain it, you've had nearly a full week to get this fixed. So it gives me joy. I like seeing accountability placed where it belongs. And in this particular situation, the accountability belongs squarely in the laps of the folks who want to restrict the First Amendment rights of the community. And so for the First Circuit to recognize that and to lay it where it lies, come explain yourselves within 48 hours. Explain yourselves. Show me you're taking this order, this judgment seriously. It does. It gives me such joy. I complain sometimes quite a bit about how defense attorneys, it's the shit rolls downhill kind of scenario. Often the ones that get blamed, the outsiders, just easy to point the finger at them. Even if there's a problem, like somebody gets wrongfully convicted, what's the most common way to fix it? Oh, it was a defense attorney that messed up. Ineffective assistance tends to be the pathway to fix a lot of problems, because they just prefer that to saying, the judge got it wrong or the prosecutor did something unethical. So seeing the responsibility placed squarely at the feet of those who deserve it just makes my heart sing a little bit. I also saw this morning, speaking, this is a little bit of a side point, but Mr. Randazza filed a notice of appearance down in Florida in the Tate case. Andrew and Tristan Tate are suing Jane Doe and some other folks for defamation. It's not a good case. Terrible case in many ways. The complaint's out there. A few different folks have it. If you're interested in that, it's definitely available. But so he's just filed his notice of appearance in that case I saw. So that's interesting. It's not one I followed super closely, but I am definitely aware of, kind of around the periphery. For me personally, not knowing anything about the Romanian legal system, kind of hard to follow, hard to give commentary on. I don't know what's going to happen there. I have no idea how Romania does things. I have no idea what the meaning of different actions there is. I had a hard enough time trying to figure out UK stuff with Depp v. Heard, and we have a relatively similar legal system as the UK. Different in so many ways, though. So many unexpected ways. So yeah, trying to figure out the Romanian legal system to follow that case has not struck me as a particularly valuable or just the type of action with a high likelihood of success. So I haven't done that, but I am aware of that case around the periphery. Kind of interested in it. Interested to see how it plays out. Maybe someday it'll go to trial. I don't know. We'll see. So we have a live stream out of the courtroom today. Just a fan so far, but that at least is something in the positive direction. Looks like we are going to be having court today, so that's good. Hopefully the sickness is resolved for whoever was suffering from that. Guys, another quick aside. I didn't watch the Murdaugh case, but I know a lot of you watched the Murdaugh case. But news coming out about the former clerk Becky Hill being charged with some different crimes, apparently being ordered to surrender to authorities. 7:30 this morning Eastern, so should have already happened. I think it was a perjury charge. Oh, what a train wreck that whole situation was. I didn't follow the trial. I had other stuff going on at the time, so I wasn't really able to. But I did notice the aftermath. There was challenge to the conviction based on the court clerk. having some potentially improper communications with jurors and things like that. Court found a way to justify it, say, no problem. Didn't really affect the trial outcome. But nevertheless, there's some criminal stuff there. So not necessarily a great look for the court. And I know some of the folks who are watching this case are familiar with that because this has come up a couple times when we had the motion for a new trial here in Karen Reed's case. And one of the questions being raised is the jury, the interactions with the jury. It's sad when people lose faith in the institution. You can't trust the institution anymore because so much of its operation depends on us being able to trust it. I've seen so many questions people have about the juror notebooks. For example, the juror notebooks, they're confidential, right? Nobody's reading them. Well, they're not supposed to. They're not supposed to, but yeah, the court has to keep custody of it. The court is supposed to, one of the court officers is supposed to collect the notebooks at the end of the day. They're supposed to secure them somewhere where nobody can access them. And then they're supposed to give them back to the jurors when the jurors are back in court the following day. And of course, nobody reads them in the meantime. That's what's supposed to happen. And we're supposed to be able to trust the court that is in fact what's happening. But the problem is when you don't trust your court, then all those steps that are necessary for this process to be functioning smoothly, kind of hard to take those on faith too, isn't it? So when questions were raised in the motion for a new trial in this particular case about were there some issues with the court security and their access to the jurors, because Massachusetts State Police is running the whole security for the whole trial, the in and out of the courtrooms, the in and out of the courthouse, et cetera, including Lieutenant Fanning. Lieutenant Fanning, who reports to the judge that he's gotten some information about a juror allegedly going to, what was it, an American Legion Hall? VFW, something like that, American Legion Hall, and supposedly talking about the case. They had a short colloquy with the juror where the juror's like, I don't know. No idea what they're talking about. And judge says, well, she didn't deny it, so we're booting her off the jury. All source back to Trooper Fanning. And, they're in charge of the total security. Surely there has to be some interface between the court officers who Judge Cannoni insists these are the only people that have any contact with the jury, and they are representatives of the court. So nothing improper happening there. No need to even inquire. But surely there would have to be some interaction between the overall court security and the very specific detail assigned to the jurors. Why? Because if part of the point here is to protect the jurors as they come and go, then the people securing the outside and the rest of the courthouse would need to know, when are they going? Where are they going? Where will they be exiting? Where will they go after that? There would need to be some kind of coordination. But, the judge was highly incurious about all that. So I know folks were interested in the Murdaugh case because it is a very rare example of a situation where, they don't always do what they're supposed to do when it comes to following the rules. We expect that. But the faith in the institutions, it's really at a low level right now. We're supposed to have faith in the folks out at the crime lab. for example, just another example, another cog in the wheel of the justice system, that they are ethical and responsible and doing things the way that they're supposed to. They are running the tests they're supposed to be running. They are treating the evidence with the integrity, preserving the integrity of the evidence and so forth. And yet all around the country, you get story after story after story. Folks in the crime lab that are helping themselves to the drugs that get sent in as evidence. Folks in the crime lab that are making up test results, not actually even running the tests that they claim they're running, just making up a result, dry labbing, they call that. So much of the system depends on the trust that we're supposed to be able to have in the public officials that we appoint, we authorize, we empower to operate these parts of the system. And it's just a question of how many times can you be confronted with, indication that they don't deserve that trust before you just stop giving it to them. So it's very, very alarming what Becky Hill did, got caught doing, and is now apparently being, criminally charged. She'd gotten some criminal charges before. I didn't quite follow and see what happened with those, but now it looks like perjury, I think is what I'm seeing. Getting charged with perjury. I mean, the clerk of the court being charged with perjury. It's wild. It's wild. And everybody wants to think, oh, these are just isolated problems. Happens there doesn't mean it happens in other places. No, but if it can happen there, it can happen anywhere, can it? What's our guarantee that a court clerk in your community or my community isn't just as problematic as Becky Hill? We don't know. We don't know. So, sad state of affairs. We want to be able to trust the courts. We want to be able to trust the employees and all the different cogs of the system. But it's human nature. You get let down so many times. It can be a little bit hard to preserve that. So it looks like we have a report from Ted Daniel this morning. Good morning from day 15 of testimony in the Karen Reed trial. Reed said she is feeling better as she walked into the courthouse a short time ago, according to my former coworker at Molly Line FNC. So good. It was, if it was Karen sick, reports make it sound like it was. She is better today. She is present at the courthouse. That is a good sign. John O'Keefe's niece and nephew are here, parentheses minors, and could testify for the prosecution today. Court officers just reminded us of the order that prevents any recording or streaming of their testimony. So that's what we are going to get today, perhaps. I don't think that they've been here in court any other day. They did testify, of course, in the first trial, similar types of rules. It was not allowed to be live streamed. They were not on video. Testimony wasn't recorded. However, folks were allowed to stay in the courtroom and to report it. It's still a public proceeding. You don't get to close the courtroom just because the person testifying is a minor. Don't get to close the courtroom. So we did get information about what the testimony was. Remember last time, it really wasn't a popular decision to put them on the stand. And I'm not sure that's going to be different this time. Not sure that's going to be different this time. It's a very significant choice to put a child on a witness stand in a court proceeding. These particular kids have been through a lot of trauma as well. Lost both of their parents in short succession. Established this new, bond with John O'Keefe. Establish at least some level of a bond with Karen, and then that is suddenly, gone as well. And I think most people's tendency is to try to protect children from adult things, adult realities, adult situations. Uh, it's not their responsibility and really shouldn't be their place to kind of be in the middle of adult conflict. They're not supposed to have to choose, for example, are you on one parent's side or the other parent's side? But when you put a child on the witness stand, particularly, let's again go back to, we haven't even talked about this, I don't think, since like week 1, maybe beginning of week 2. Guys, at its heart, this is a domestic violence case. That's the allegation. That's the allegation that Karen Reed intentionally murdered her domestic partner with her car. Her romantic partner. Okay, maybe she didn't live there all the time, but all accounts are she spent a lot of time with there. She took on this caregiver role for the children, babysitter with or without benefits. So she assumed that kind of role. Now she's accused of intentionally killing him, domestic violence, and you're going to put the kids in the middle of that. It's an adversarial system, and you're going to make them go in and testify against a former caregiver. It's not very protective of these children. And so most times in criminal cases, you don't do that unless you absolutely can't avoid it, unless it's absolutely necessary. Looks like they are coming in now. So we will...
Amy?
They did, Your Honor.
Okay. Why don't I see Counselor Sidebar?
Of course, they're going to go straight to Sidebar. Of course, they're going to go, straight to Sidebar. Most criminal cases, domestic violence cases, especially domestic violence, is damaging for children to be around. Okay. It's rare if you're talking about somebody murdering their domestic partner. It's rare that that is just happening in a vacuum. Rare that that's happening in a vacuum. There's other indications of abuse in the relationship. It doesn't just come out of nowhere. There's other problems. And that's a very toxic, very damaging environment for children to be in. So you're typically talking about kids who were already damaged. Kids who were already, supposed to be able to love and respect and rely on and look up to and be molded by both parents, both caregivers. And so when you put them in a position where, you got to choose, you got to pick sides, very damaging for kids. So it was not a popular decision for them to testify in the first trial. Don't love it here. There was nothing that came out in the first trial that seemed especially necessary for them to be able to make, for the Commonwealth to be able to make their case. As I recall, there was some testimony about Aruba and what happened in Aruba, and some general testimony about the relationship. Like we already know, we read the text messages. We already know that there were issues in the relationship. To bring kids in and put kids in the position of judging the relationship of the caregivers and testifying about it. I don't think it's a good look. I don't know what the jury's going to think. I remember Ronnie, the juror from the first trial, uh, was not impressed with that decision. I don't think most of that jury, as he reported, was particularly impressed with that decision. So it to me does reek a little bit of desperation by the Commonwealth. Why would you do this? It's adding little to nothing to your case. If all you can do is try to continue to characterize the relationship, try to smear Karen, try to turn this into a who's a good guy and who's a bad guy type of decision making process, when the reality in abusive relationships is often quite a bit more nuanced than that, often quite a bit more complex. If you're going to do that, you better be getting something really significant out of it. And that didn't happen in the first trial. Oh yeah, the only other thing that Karen sometimes used the desktop computer in John's house, something like that. They're really trying to pin the lost Ring camera footage on Karen. But we've already heard from a couple of sources, certainly from Bukhenik in this trial, he just testified to it. They never developed any evidence that Karen had any access to the Ring camera footage. And we know from the first trial, it's because the only way to get to it was through John's phone. They didn't have a way to get into Ring in the laptop or in the desktop computer, the one that she had access to. So they never had any proof that she accessed the Ring video. They're continuing to, try to make that implication. That was one of the things, I think it was the son, the nephew, that they elicited in the first trial. Still trying to make that point. Guys, the phone was in your custody. And the discrepancy between what Ring says they sent you and what you claim to have, that's also on you. You investigators. And that little note from DeChico, where he's identifying the timestamp of footage that, according to Proctor, according to Bukhenik, they simply never received it from Ring. Then why would he be talking about that particular date and timestamp of footage that he is reviewing if you never received it? So that's what they're bringing these kids in to try to protect against. Is that they're using children. They're putting children in a traumatic situation, a setting that is adultified. Okay, you're supposed to be able to be kids, but now you're going to have to come into court and swear an oath in this very adult context here. Why? To cover up for Proctor. To try to cover up for Proctor. They're using the kids for that. And I hope that if that is the direction that this goes, I don't know any other reason why the niece and nephew would be here today. I don't know of any other reason why they'd be here today. They're not coming to court. They're not sitting in the courtroom. They're not observing any of this appropriately because they're kids. So if that's where they're going and that's what's going to happen, it's not a good look. It's not a good look. I do wonder how that's going to land with the jury. Didn't impress them last time. To cover up for Proctor. We could be finally talking about what sort of proof there is that John O'Keefe was hit by a car. pretty critical element of the charge that needs to be addressed, that causation element. How exactly did Karen cause the death of John O'Keefe? One of the fundamental aspects of the case that needs to be established. We could be getting into that. But there seems to be a reason why we aren't. Well, if they are going to do that, then we are probably not going to, have a live stream this morning. I mean, in the sense we won't have a video feed. I'll have to shut off the camera, but we'll see, of course, what exactly is going to happen. Ted Daniel now further clarifies we are prohibited from posting the testimony of the minors live as it happens, but we can take notes. Prohibited from posting the testimony of the minors live as it happens, but we can take notes. So they're not allowed to live tweet the testimony, but they can take notes and report about it as soon as it's done. This does not make a lot of sense to me either, guys. This is a get. This is a prior restraint on speech.
All right, to the court, please.
Bringing the jury in, it looks like. This is a restraint on speech. And I don't understand how this is narrowly tailored and what interest it's serving. I understand, minors in court because it is traumatic and it is adultified and it's an experience they should not have to be subjected to unless there is an extremely good reason for it. I can understand the limitation on the cameras and the recording of their voices and things like that. But the content of their testimony, you can't live tweet it. What interest is that serving? And how is it serving that interest by permitting the reporters to go in and report it after the fact, like in bulk? Okay, they're off the stand. And then they can tell us what was said. What interest is being served by that restriction? I really don't get it. Nobody's going to do anything about it. It's not like, somebody is going to run to the Massachusetts Supreme Court, right now and try to get that changed. But if you're going to restrict speech, particularly a prior restraint on speech is presumptively unconstitutional, you must have a compelling government interest, particularly if it's content-based. And this is content-based, the testimony of the children. You're going to restrict their ability to speak on a certain subject. You must have a compelling government interest, and your restriction must be narrowly tailored so that it is neither over-inclusive nor under-inclusive. It fully protects the interests that you are seeking to protect, and it does not bleed over into restraining other speech that is valid. That doesn't implicate that interest. How is that served here? How is this narrowly tailored? You can't live tweet it, but you can report it after the fact. What interest is this serving? I really don't get that. Might be if it's the kids testifying that we are just going to stare at this fan all day, at least until they're done. No sound. Not sure, guys. We'll give it a few minutes to see. Perhaps somebody will update us. Certainly taking a little bit longer than usual to come off of the fan if all we're doing is bringing the jury in for the day. So that is my guess and my expectation, I suppose. If they are there and they're testifying, then that may be what is going on now. And we are potentially just going to be staring at this while it's all going on. I'm going to go ahead and take us off the fan, guys. If they can't live tweet it, then we are just going to sit and wait until they're done. Hopefully it will be quick. Brennan doesn't have that issue with having to explore every single corner of the issue that Lally had. I think when Lally had the kids on, he had them on for like the whole afternoon, or at least a good chunk of the afternoon. Hopefully that won't be the case here. But okay, it looks like Sue is just reporting a 5-minute recess. Sue O'Connell, sorry. Also apparently in the courtroom today. Also states a reminder that if John O'Keefe's niece and or nephew testify today, there are very strict rules that both counsels agreed to about covering their testimonies. We will not be broadcasting their testimony or posting about it on social media during the testimony, and we will not be sharing their names or other personal information. Most press members will be taking notes on their phones or paper. A reminder, these are minors who are witnesses. It's nice that the counsel agreed to them, but counsel doesn't have standing to waive the First Amendment rights of the public. That is not their role. They don't get to waive the First Amendment rights of the public. But nobody's fighting back on this. Nobody has. So I guess it is what it is. Well, hey, I see we've got a few comments and questions in the queue, so might as well take those up and give us something to chat about while we continue to wait for something more interesting than the fan. Jason McClellan, witnesses like Sergeant Bukhenik, Jen McCabe, Proctor's dodgy behavior, no nudes, and the R word, shows bias, Sallyport video, Higgins's links, bad forensics, and phone data, can't ask for a no case submission. No, they can't, because the burden for the case to get thrown out after the Commonwealth rests is so extremely low. And it can't be based on the evidence is so weak that she shouldn't, be convicted. No reasonable jury would convict her, for example. That's not the standard. That's not the standard. The standard is essentially, if you look at all of the evidence the way that the Commonwealth wants you to look at it. So you believe all of their witnesses, all of their explanations. Jen McCabe said she forgot about those three phone calls that she made right before she talked to the FBI. She forgot. You accept that. For purposes of this standard, that's true. She's credible. Bukhenik's credible. Their investigation is credible. Everything was done with the highest honor and integrity. That's the lens that you look at the evidence through to decide if the jury looked at it that way. Is there enough to prove each of the elements of the case beyond a reasonable doubt? Well, we haven't got to the causation yet, but there's probably enough just with the taillight. They say you can infer circumstantially, even if they rested right now. You could infer circumstantially that she said I hit him. They got taillight. You can infer circumstantially that means she hit him with the car. There's your causation element. You look at everything in the light that's most favorable to the prosecution. And that's all you're asking. Just is there enough, if we buy it, without weighing anything, without making determinations that their witnesses lack credibility, without holding potential problems with the chain of custody of evidence against them. We look at all of that in their favor. We resolve all of those potential problems in the Commonwealth's favor. And then you ask, is there enough, looking at it in that light, to establish all the elements of the case? And very rare not to meet that bar. Just very rare. And so most of the time when you do see it, it's because of something like a witness has recanted. A witness hasn't shown up. Sometimes, rarely, but sometimes there can be a total failure of evidence on one of the elements. I've mentioned before a case where I had this come up. I had it on appeal, but it's a very technical step. Washington. Looks like they are going to come back. It's getting some sound. If you want to charge somebody in Washington with fleeing a police vehicle, it's a very technical statute. There's a lot of very specific things you have to prove. The vehicle had lights on it. They were activated and a siren. The officer was in uniform, et cetera, et cetera. And so if you forget to mention the fact that, like, the officer was wearing a uniform, your case could be thrown out at halftime.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God
So
save the
that
Commonwealth of
can happen
Massachusetts.
sometimes, but
Court
it's
is now
just
open.
very rare.
You may be seated.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, James. So a couple of things. We appreciate your patience this morning. Remember, I told you the other day that we're trying to cut back on sidebar conferences. So we took some time now to address issues that we would have otherwise had to do that way. So we do appreciate your patience. And also, I really appreciate your patience and understanding about yesterday. Sometimes during trials, things come up that are completely unavoidable. And I tried to cancel you as soon as we could so you wouldn't even have to come to court. So I appreciate that. I do have to ask you those questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were last here? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation on this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here the other day? Everyone said no or shook. All right, can we have our next witness, please?
All right, may I?
Yes.
The Commonwealth seeks to introduce two clips.
Okay.
The first clip the Commonwealth would seek to introduce and show the jury is clip 20.
This Amy window here, that you guys has really been going at it. And this was sort of had like a last date element to it. Was that going on?
That was not going on. Don't get it clear to me. I'm never breaking up with you. Not never that we're in this good or bad, but you're the best person I've ever.
I can't really hear that.
Commonwealth would ask to show clip 19.
So this is his intro to the kids. Not breaking up with you.
I don't think, I don't see how John would know about my text with Brian. And I'm not sure if he knew he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong.
Thank you.
Sure. All right, Ms. McLaughlin, who is your next witness?
Your Honor, our next witness is a juvenile by the name of Miss Kaylee Furbish.
They weren't supposed to say that, but I guess that's over now. So I'm expecting that will just be the fan. Just be the fan on the stream. Sometimes you get the caption that comes up that even though you can't hear what's being said, the like closed caption picks it up. Don't know if that's going to happen. I'll keep an eye on that. That was the lead-in to the kids. Yeah, I'm going to talk about how bad the relationship was. Put them in that position. Put them in the middle of what the Commonwealth is alleging is a domestic violence relationship and make them take sides. They're actually going to do it. It was a bad call last time. I think it's a bad call this time. It just is not a good look. You need to have a very good reason to put a kid on a stand in a case like this. Something unavoidable. The kid has seen something that nobody else saw. The kid has personally experienced something that nobody else can testify to. Something critical, not these guys fought sometimes. I do not think that this is going to go over very well. But I guess we'll see. Hey, Debbie Dobles. Good morning, beautiful Andrea and followers. Good morning to you too, Debbie. Thanks everyone for being here. Hopefully this is going to be quick with the juveniles on the stand. I don't believe they were cross-examined last year. Something to be done with kid gloves, if at all. If it's done, you must be very sensitive to the circumstances. The Commonwealth isn't, but you have to take the higher ground on this one. So very difficult to cross-examine the kids if you do it at all. So hopefully this will be quick, but we'll see. We'll just spend a little time together. Chit chat about some of your observations. Starry Dust is gifted 10 memberships. Thank you so much for that, Starry Dust. Thanks on behalf of everybody who got one of those. Sabina D, as a Romanian, for public persons, justice is highly politicized. So the outcome of that relies heavily on who is going to win the current elections, unfortunately. I love this chat. Thank you, Sabina. This is a great insight. See, I know, like I said, little to nothing about the Romanian justice system, how it works, what to expect vis-a-vis the Tate case we were talking about just very casually earlier. Happened to see Mark Randazza appeared in the one in Florida. Justice is highly politicized. You know, we'd love to say, oh, that's a shame. Oh, poor Romania. Imagine having a system like that. Yeah, look at ours. You think justice is a little bit politicized here in Massachusetts? What do you guys think? It's a shame that things depend so much on who wins the election, but that's no different. That's no different than we saw here. Didn't we just see a mayor in New York? Prosecution dismissed shortly following an election. Haven't we seen a local investigation potentially by some federal officials here in Massachusetts. Ostensibly be concluded, be stopped, be over with the change of an administration. Unfortunately, politicized justice is something that we are very familiar with here in the US as well. So unfortunate to hear that, but surprising, maybe not. Summertime, what happens when a judge is found to have lied? Well, I mean, I'm just going to get a banner up here real quick so folks know what's going on. What happens when a judge is found to have lied? So who makes this finding? How is it found? In what context is it found? Can make a very significant difference. All of us thinking a judge has lied doesn't necessarily achieve anything at all. If the judge hasn't been found to have lied in some type of formal process, a court has found the judge to have lied, a judicial ethics commission, kind of, the folks that are responsible for judicial discipline, they've made a finding that the judge has lied. If those types of things happen, then yes, you would expect there would be, at the minimum, some kind of discipline on the judge. How much? Well, that's a great question. Maybe should be. You shouldn't be a judge. Maybe should be that strict, but is it always going to be that strict? I'd be surprised if it was. I'd be surprised if it was. Little gray area situation can be a judge's case goes up on appeal, and the appellate court isn't perhaps real enthusiastic about a judge's explanations for things that happened or stuff like that. Maybe even says so in their opinion, but they're not really in charge of making findings. Appellate courts aren't in the business of making findings. It's not what they do. They're not a trial court. They are a reviewing court. So you could have like a gray area situation where you get an opinion from an appellate court. It's like, hey, the judge, gave this explanation for, I don't know, an ex parte communication, but it's contradicted by evidence that was presented. So the finding, the trial court's finding that the trial court did nothing wrong is reversed. It would be opaque. It would be a little bit oblique like that. What happens? Nothing. Unless somebody refers it to a place where judicial ethics are reviewed and discipline is handed down, nothing happens. Nothing happens. So, judicial discipline, not very common. Yeah, they have these bodies that exist that are there to review and investigate and vet complaints against judges, make findings, impose discipline if it's appropriate. But how often do they do that? And how enthusiastically do they do it? Not very. Not very. You have to be pretty over the line as a judge before these organizations tend to do anything real serious about it. So what happens? Chances are pretty decent. Nothing will happen. But a lot could just depend on the details. The Traveler, not sure if Murdoch clerk is dumb or corrupt. Where is the line between the two? There's often no line between the two. There's a reason why criminal masterminds are very few and far between. Very few and far between. In fact, pretty much anytime I hear a case that is a criminal mastermind theory of a case, I discount it. There are not many criminal masterminds out there. One of the reasons I'm very, very skeptical of the case so far against Brian Kohberger, at least based on what is publicly known of the evidence. It requires a kind of criminal mastermind type of theory. No, I'm already skeptical of this theory. By virtue of committing crimes, making that decision, you're already putting yourself in a class, so to speak, that just tends to have poor impulse control, poor judgment, inability to plan well and stuff. Of course, Kohberger is that situation I've pointed out before. You have to be both the most genius criminal mastermind and also the biggest idiot to make some of the mistakes, right? It's got to be both at the same time. Because you're smart enough to know how to not transfer any DNA, how to get in and out of this house and commit 4 murders without being detected within seconds with your bare hands, with a knife. Somehow, no screaming, no alert being raised, nothing, in and out without any DNA transfer, without leaving a blood trail, nothing like that. You're that smart, but you're dumb enough to drive your own car and bring your phone. You got to be both at the same time. And oddly, the guy who is the specialist, his focus in criminology was cloud-based forensics. Cloud-based forensics. What's that? Well, it's the stuff that your phone uploads to the cloud and stores. Well, your computer does it too, but your phone does quite a lot of that. So of all things to be alert to, the phone. You'd think the guy would be alert to the phone. What information you could get off the phone, and you would just leave your phone at home. Wouldn't you just leave your phone at home? You would understand. Create an alibi. You don't have to turn your phone off and then, drive places with it. You would leave your phone at home. Create yourself an alibi with the phone. Isn't that what a criminal mastermind who's focusing on cloud-based forensics would do? No, so then it's got to be distorted into some kind of theory where it's a criminal mastermind, but deliberately making mistakes, right? Because he kind of wants to be caught, but it's all a cat and mouse game. Oh, I have a very hard time buying this theory, which is why I'm waiting for trial to see what the evidence is. So, criminal masterminds, I'm pretty much always skeptical of this theory. There is a massive amount of overlap between dumb and corrupt. Massive amount of overlap. If we look at this particular case, okay, Karen Reed's case, the corruption that's being alleged in this case, the cover-up, the frame job, okay, planting the taillight pieces. What are some of the things that we've looked at as like dumb mistakes? Dumb mistakes. Well, they can't keep track of the timeline. They can't keep track of the story of the investigation and how it evolved to the point where we are planning to tow Karen's car before we arrive in Dighton, meaning we're relying just on the information that we've been provided. And what, John's body? Really? Everybody says John's body is not a giveaway. Not a giveaway for, for car accident. Not conventional vehicle pedestrian collision injuries. But they have to explain it because that's what they did, because they were not being criminal masterminds at the time that they're going out to Dighton. They've already planned to seize her car. And then they don't have a very good explanation for why. The taillight pieces. We got a little problem with these massive, dinner sites, at least dessert plate sized pieces of glass that are being found in the yard 2 weeks after the snow melted? That's not criminal mastermind stuff. You just you were winging it, and you realize you had too much plastic still. Too much time has gone by, and you still have too much plastic. You can't just keep busting it up into little small pieces for you and Bukhenik and Berkowitz to find on different days. You still got these big chunks left. You got to somehow get it into evidence. So you found it all on February 18th, 2 weeks after the snow was melted. According to the testimony, it was raining on February the 4th. The very least by February 10th, almost no snow left, according to Bukhenik. And then, of course, the intelligence to be texting about all this stuff, putting it in writing with your group chat friends, with your superiors on their phones. This is not smart, okay? People's mouths are what get them into trouble. Significant amount of the time. Having co-conspirators and talking. What gets people caught? They just can't not talk. People just can't not talk. That's a dumb thing. That's not a criminal mastermind move. Criminal mastermind's going to shut up and not say a word. Probably not have other people involved. So even in this particular case, you can see the line between corrupt and dumb is there's a lot of overlap. There's a lot of overlap. Now with Becky Hill and what she's accused of, I don't know the details of the current charge. I just see that it's perjury, but I don't know what that's based on. What lie did she tell? When? At what point? About what? My guess, if I'm hypothesizing, just given the context, is it's about her report of her interactions with the jury. When they had that post-trial motion and they're trying to sort out what did you say to them, what was communicated, because some of the jurors had reported, well, she was saying things like just basically making it clear that she thought he was already guilty. I don't remember the exact words, but making clear that she thought he was guilty. Probably something to do with that. Well, it's not very smart to lie about something like that because there are witnesses to it. There's always two people involved in a conversation at least. So is she dumb or is she corrupt? I mean, it's both. I think most of the time it's both. Even if you're corrupt, you're not trying to show everybody that. So you're trying to keep it quiet. You're trying to keep it concealed, undercover. But you're probably not a criminal mastermind because almost nobody is. So you end up doing dumb stuff. A lot of overlap. AK, are they allowed to take jury notes in another language than English? And why can't they bring the notes home when they are trusted to not read or talk about the case at home anyway? What's the reason? That's actually, that's a good question. I never really thought about that before. Why not be able to take their own notebooks? Probably just for security reasons. You got your notebook in your car, you forget to lock your car, somebody breaks into your car, steals your car. Now your notebook has been stolen and it's out there. Something like that. You bring it home, you leave it on the nightstand. Can you guarantee your spouse isn't going in and reading it? Your kids coming in, not coming in and reading it. It probably just has to do with that type of security. It's not so much about trust as much as, does every juror have a locked safe at home that they could put the journal in, type of thing, put the notes in? Probably not. So that would be my guess. Is it just has to do with keeping them secured and the court knowing, or at least being the one with firsthand knowledge, supposedly, of who has or would have access to those notes. Can they take jury notes in another language? Absolutely. They can take whatever notes, however they want to. They don't have to take notes at all if they don't want to. They can sit up there and draw. They don't have to write down a single word. They could draw stuff that reminds them of what the testimony was that they heard. It's just there to be a memory aid. It's not there to be a memorialization, like the way that a transcript is. It's not meant to be that. It's just there to give them a reminder of what it is that they heard, and they'll be instructed. I think they might have been at the during the preliminary instructions, but I think it also gets repeated at the end that the notes are not a substitute for their memories. It's their memories that they are required to rely on in the jury room, and so if there's a conflict between their notes and their memories, they're supposed to go with the memory, and they're supposed to go with the collective memory of the jury. So notes can be anything. They could be in any language. They could be writing. They could be cuneiform. I don't think you could probably do that with paper, but yeah, good question. Z, Melanie's stream yesterday, her guest, Tom, Massachusetts criminal defense attorney, said if perjury in a murder case, person can face life like defendant. Thoughts? Yeah, let's see if I can find the Massachusetts perjury statute. See what it says. It says the penalty for perjury, this is just from the AI overview. I'm going to try to find the link here. The penalty for perjury depends on whether it occurs on the trial of an indictment for a capital crime or in any other case. Where's that from? Here is the perjury statute. Okay. I'm going to go ahead and might as well take a look at that, because why not? Is this visible over here? Whoever being lawfully required to depose the truth in a judicial proceeding or in a proceeding in a course of justice willfully swears or affirms falsely in a matter material to the issue or point in question, or whoever being required by law to take an oath or affirmation willingly swears or affirms falsely in a matter relative to which such oath or affirmation is required shall be guilty of perjury. Whoever commits perjury on the trial of an indictment for a capital crime shall be punished by imprisonment in the state prison for life or for any term of years. And whoever commits perjury in any other case shall be punished by imprisonment in the state prison for not more than 20 years, or by a fine of not more than $1,000, or by imprisonment in jail for not more than 2.5 years, or by such fine and imprisonment in jail. That's the statute. So here's how I understand that. I don't believe this is a capital crime. Capital typically means it's eligible for the death penalty. Second degree murder is not eligible for the death penalty in Massachusetts. I understand Massachusetts state doesn't have the death penalty anyway, right? But that doesn't typically change the distinction between a capital and a not capital crime. It's just whether it could if you had a death penalty. Washington, we also don't have a death penalty, but we still have a distinction that is all the way back into the Constitution between capital crimes and non-capital crimes. So I'm not sure in this particular case that potentially being punished up to life is going to apply, because I don't think this is a capital crime. And it's life is the max. Life is the max. Or it says very specifically punished by imprisonment in the state prison for life or for any term of years. So they could impose something less even in that situation. But since it's not a capital crime, I think we're dealing with this second part, any other case, imprisonment for not more than 20 years or not more than 2.5 years. What's the difference between those? I don't know. They don't say. I'm assuming it's like a misdemeanor versus a felony perjury, or maybe it's these two different types. If you willfully or swear or affirm falsely on a material issue versus just a matter relative to it Is that the distinction between the whether you get 20 years or whether you get 2.5? I don't know. But those are all maxes. Those are maxes. And so it's very rare for people to get the max. It's very rare to get the max. I don't know. We're still staring at the fan over there. I don't know. I kind of remember going down this rabbit hole during the last trial, but it never really came up because she didn't get convicted. So we didn't really have to look at sentencing and how sentencing works in the state of Massachusetts. But the general sense is if there's a maximum, there may or may not be a minimum. But the judge then often will have some discretion to decide what the appropriate sentence should be. And there's often, I don't know if restraints or, guidelines on the judge's description, the judge's discretion that are imposed based on things like what type of criminal history does this person have? Is this offense particularly egregious compared to others of the same type? Those types of things can factor into what the actual sentence ends up being. So you have somebody that commits the worst type of perjury, but they don't have any type of criminal history. The presumption is they would get a lighter sentence than somebody who commits the same type of crime, but has a long criminal history. And that's just because the nature of the person and the person's past indicates that they probably are less likely to be rehabilitated if they have a long criminal history than if they don't. And so that just speaks to what is the length of punishment that's likely to be needed to serve rehabilitative goals. There are some limits on this based on federal constitutional law as far as what a judge can find in order to increase somebody's sentence or to exercise their discretion within the range that's allowed. But that's generally how the sentencing process works. So it looks like there is a possibility in a capital case for there to be a sentence of up to life. But I don't think this is a capital case, so I don't think that applies. And the reality is if the judge has discretion to impose less, they almost always do. Almost nobody gets the max. When you read a article about a case or you hear about it on TV and it's like, somebody just got charged and they could face up to, 100 billion years in prison. They're telling you the max, and almost nobody ever gets the max. Even, I mean, take plea bargains out of it and stuff like that, agreed resolutions, even that aside, even if you go all the way through trial and get sentenced, rarely do people get the max. Ryan Bibbs, am I wrong in thinking that they should still air audio testimony for the minor witnesses in the name of public access? I'm not going to say you're wrong. There's a lot of ways that they could do it. You could, if the concern here is privacy, privacy of the minors, you can do like AI disguise their voices. Having a chunk of the trial singled out for separate treatment when it comes to public access. Yeah, I think that's problematic. I think that's problematic. Now, there's a distinction between right of public access and televising or publicizing what's going on in the court. No right to have TV cameras in there at all, right? No right to have audio recordings, microphones, live feeds, etc. No right to any of that at all. Now, we can argue about whether that maybe should be different too. Should have a camera in every courtroom in the US. The reality is we do have a camera in every courtroom in the US now because COVID kind of required that to be the case. The court is going to function. They had to have remote court availability. And so, every court in the country. If there is a court out there that is not equipped for Zoom court, and you know about it, let me know. Let me know, because I would love to find a court in the country that's not equipped, at the very least, for Zoom court with cameras. But there is, as the law stands right now, no right to have proceedings televised. So the public access right is being satisfied by the fact that the courtroom doors have not been barred to those people who have been able to get seats there. The representatives of the press and the people in the audience who are able to get seats. The fact that they're allowed to be there is kind of the bar for where public access is established. And the rest of us, we just get to rely on what they see and decide to tell us or not tell us about what's going on in there. We are dependent on them. That's where the institution of the media is supposed to serve that goal by conveying that information to us, while we're talking about institutions that have lost a lot of public trust. Cannot forget about the media. So I'm not going to say you're wrong, because I think, yes, in general, we should be erring on the side of transparency. And to the extent there's a concern about the privacy of the minors, seems like that can be alleviated in ways that do not limit our ability to know what evidence is being presented in court. Because we do have an interest in that. The outcome of the trial is what we want or what we don't want. We have an interest in knowing what was that outcome based on. What did the jury hear? And so if we don't get to hear it, we don't get to know, we rely on people who may or may not be reliable to tell us. I don't think you're wrong for thinking this. Summertime, who is left on the Commonwealth's witness list? ME Forensics. Well, let me pull it up. We did look at this yesterday. I will go ahead and get it up again. This is the not the witness list itself, but it is the compilation that somebody put together of who is on the witness lists for both sides, who's on the Commonwealth, who's on the defense, and then who's on both. So we went through all this yesterday, and there are a massive amount of people on this list that have not been called. What did we get? Only like 6 out of 31 that are on both witness lists that have been called. Who's been called so far? Not Brian Jr., not Caitlin, not Chris, not Colin, not Julie, not Nicole, not Evan Brent. Okay, Yuri Bukhenik has been called. Paul Gallagher has been called. Heather Maxon's been called. Jen McCabe's been called. Ryan Nagel's been called. Carrie Roberts has been called. 6 people out of 31 that are in common on the witness lists. You go through the Commonwealth's witness list, they got 57 people on here. They've called, almost none of them. Okay, Jason Becker they called. Go down. None. Michael Camerano's been called. Gary Fowler, Anthony Flamati, Robert Gilman, Nicholas Guarino, Christina Hanley. Now I'm like spacing on whether Christina Hanley got called. Did she get called? I don't think she did. I'm totally forgetting though. Jessica Hyde. Okay, now we know KF is being called. Hannah Knowles, Sarah Levinson, that's 10. Katie McLaughlin, Bridget Meehan, we're at 12. Timothy Nuttall, Kevin O'Hara, Margaret O'Keefe, we're at 15. Charles Ray. Ian Whiffen. Daniel Whitley. 18 people out of 57 that have been called. That's where we're at on the witness list. So, I mean, who knows? Who knows what's left? Yeah, I mean, there's a lot of ME in forensics that are left on the witness list. There's a lot of other people too. don't know what their strategy is. So some of these people seem pretty important. Andre Porto, for example, he's over there on both witness lists. He's the guy from the state lab that did most of the DNA testing. He seems pretty important. The defense wants him because he's the one that found the mixed male profiles on John's clothes. Multiple male contributors to DNA on John's clothes. Defense wants that in. But the Commonwealth is going to want in John's DNA is on the taillight. John's trace DNA is on the taillight. So got to think something there is coming. We haven't heard anything so far about the accident reconstruction. We haven't heard anything so far about John's injuries. So we have to expect that. But as far as the rest, I mean, who knows? They've called only a small proportion of who they have on the list. A lot of this seems prudent to me because it reflects editing. In the case, Lally's case very badly needed to be edited. You know, there's a lot that we didn't need to hear. But there's always going to be trade-offs with editing because then who you call and who you don't call, that can in itself be an issue. So, for example, the Commonwealth now doesn't call Officer Seraph, Officer Mullaney, Matthew Kelly, both three of the first responders who were on scene, the initial first responders on scene when John was there, when, everybody, Karen and Carrie and Jen are there. And we're in this process of getting John into the ambulance and getting him off to the hospital and stuff. Those three people who did not hear, I hit him. Oh, and Good too. We can't forget about Good. He's the one, according to Katie McLaughlin, that Officer Seraph overheard Karen Reed saying, I hit him, said, go get Goody. Go get Goody. Not according to the first trial. Not according to Officer Seraph. None of that happened. So you don't call those people. Okay, four of the people that are supposed to be squarely in the middle of I hit him. And if called by the defense, will establish, presumably, like they did in the first trial. Nope, never heard it. That didn't happen. Didn't hear it. Now you've kind of opened up reasons for the jury to question the integrity of what you're presenting. You want me to think she said, I hit him. And so you selectively edited out these people that tended to contradict that. Instead of dealing with the bad fact, okay, the fact that the account of I hit him is different from every witness who has given it so far. Doesn't add up with each other, doesn't add up with the video camera, and doesn't add up with the other people who were present, including the ones that are supposed to have been involved in hearing it and dealing with it, responding to it, etc. If that's the only way you can make your case, that's maybe not a very good case. When you edit the case too much, you open up room for too many of those kinds of inferences. But that said, what do we need? What do we need Mrs. Camerano for? I don't know. I don't know why she would be necessary. She's a good one to edit out. Do we need Kurt Roberts? Now that we already heard from Michael Camerano about what was going on at CF McCarthy's, do we need Kurt Roberts? I don't know that we do. You didn't have anything particularly compelling to add in the first trial. So it clearly needed some editing, but might be scratching off a little bit more than is prudent, given just the likely implication that will have if the defense chooses to go in and call those witnesses instead. The medical examiner, if the Commonwealth doesn't call the medical examiner, the Commonwealth doesn't call Proctor, it's just not going to look good that they didn't do that, because it is almost certain that the defense is going to. Dejan Lujic, almost 9,000 viewers, but less than 300 likes. Come on, people. Acknowledge. I love that. Acknowledge the stream. Just like Sergeant Bukhenik. Thank you for that. Appreciate the encouragement. TB85, agree totally. The recent arrests of judges won't help with those trust issues at all. A judge bundling illegal aliens out the back door. Judges do get arrested from time to time. Corruption, there have been more than one like pay to play kind of scandal around where you can kind of buy your outcome from the judge. There was one very high profile one where the judge was getting kickbacks from a private juvenile like detention facility to basically be extra hard on kids in the juvenile system. Locally here where I am, right in the county courthouse right here, there was a judge, a prosecutor, and a defense attorney who all got busted for having a scheme where you could pay them off to achieve certain outcomes. It's just not that unheard of. Very unfortunate because we depend on these folks to have trust in the institution, and the more stories like that you hear, the more you question if that trust is well placed and well founded and deserved. And if you don't have trust in the institution, then we're in a rough place because we depend on these institutions to help us stay organized and peaceful and get along as a community. We give up that monopoly of violence to the police and to the government. Give us justice for us, and we won't go do it ourselves. So if they fall short on the job, it's not a good place to be. Not having faith in the institutions, but it's just unfortunate. Atheist Ant. So would it behoove the defense to not cross the minors? Better optics. They're going to have to make that decision. I've seen some folks, suggest or hypothesize, well, what if the kids change their testimony from the last time? We know generally what the kids testified to last time. What if they change it? What if they say more damaging things this time? So one of the problems with kids being witnesses is because kids are very suggestible. Kids can be influenced very easily. This is one of the reasons why, when I mentioned yesterday, we were talking about the read technique and the police's ability to lie to people, and how there have been some states that are pursuing or trying to adopt legislation that may limit some of the consequences of that. And a common one is to make it illegal to lie to minors, juveniles in interrogation. And one of the reasons for that is because juveniles are particularly susceptible to being led by police, to develop these internalized false confessions where this is an authority figure. The authority figure is telling them, we have you on video, and the evidence, the juvenile is thinking, well, I know I wasn't there. I know I didn't do it. But if you defer to this person's authority, or you believe them, you don't realize that they would lie to you, that can cause you to question your own reality. And then that opens up the door to a situation where you entertain the possibility that your memory is wrong and what the police are telling you is correct. This is almost, it's not actually gaslighting, right? It's just lying to you and getting it, but it's very similar, very similar type of effect. You think to yourself, I must be crazy. I must be crazy because I don't remember it, but they're telling me that this thing happened. So kids in general can be very suggestible, and that's a risk when you have kid witnesses. If you have kid witnesses in an environment where we already know what Peggy O'Keefe thinks of Karen. We already know. We've heard testimony about it. What's she doing here? How could you just left him there? Yeah, you dropped him off at a party, grown ass man, just left him there. That's a problem. Not real receptive to Karen being back at the house, being very judgy, about Karen being back at the house. So the kids are in that environment, and that's a suggestive environment. Kids are typically not going to, resist the emotions of the authority figures in their lives and the caregivers in their lives. You tend to be influenced by that. Now, doesn't mean kids never think their parents are wrong or their parents got it wrong or something like that. But usually that kind of thing develops when you're more mature. You have more adult judgment and insight, the ability to reflect back and just look at things through different eyes than you do when you're a kid. So they're in an environment where we already know, Karen is not, they're not fans of Karen. And so does that have the potential to maybe distort their testimony, distort their memories? Yeah, kids are very suggestible in general. So maybe their testimony will change from the first time. They've had a whole new year to steep in this. And maybe they'll paint a worse picture than they did in the first trial. So what do you do with that? Any other witness, they change their testimony, you've got it. You're going to cross-examine them about that. Do you do that with these kids? You got to be very cautious. You got to be very cautious if you're going to do it. One, you have to do it, with kid gloves. You have to do it gently. You have to do it respectfully. Of course, you don't attack the kids, but sometimes you do have to cross-examine children, and sometimes you do have to point out, this isn't what you said before. Do you acknowledge that this isn't what you said before? Alan Jackson's argumentative approach would be particularly ill-suited to this kind of cross-examination. But it also better be real significant. It better be important. If it's just their testimony changed over something that doesn't really matter, it's probably not going to be worth it. But if their testimony changes on something material, something that really matters, if suddenly the kids now hear Karen saying, I hit him, you're probably going to have to address that. And so, yeah, there are ways to do it. It's not fun. Nobody likes it. Nobody likes cross-examining kids. But you got to do it sometimes, and you figure out your method to do that. Oh God, kids that are making false accusations, it's not fun. It's not fun, but you got to do it sometimes. And personally, just my own experience in having to deal with those types of situations, you have to, I think, bear in mind that you have to kind of have truth as your ultimate value, because you're kind of doing somebody a favor if you are not just enabling them in being dishonest, being even just mistaken, believing something that's incorrect. You're actually doing a kindness to people to point out the truth. So you have to just kind of have some faith in that. Imagine if you're a kid and you've been manipulated, you've been in a toxic environment, and you've been, for example, turned against a parent. Your parents have a nasty divorce. Your mom says all kinds of nasty things about dad. Dad left us. Dad hates you. Dad, whatever. Your mind is poisoned by this parent against the other parent. And maybe it's even suggested to you that parent did something bad. That parent was abusive to you, and you're a child. And you're suggestible, and you start to believe it. Isn't it a kindness to free a child from a false belief like that? No, actually, it's not true. It didn't happen. Your father did love you. And what happened is not your fault. And your adopting this belief system was not your fault either. You're the child. Fault lies squarely with the parent who didn't act like an adult, the parent who put their own selfish interests above the best interests of their child. Isn't that a kindness of the child to help free them from that? That's kind of how I always saw it. So very difficult to cross children. I would expect they're not going to do it unless it is something that is that's really important. If it's just like a small inconsistency, you would just let that go. It doesn't. If it doesn't matter, and all indications from the last trial are that the testimony of these children really didn't matter, then you just let it go. Ethan Morgan, if kids testify to Karen Reed's access to the desktop, I feel the defense closing should include that the only video that was deleted seems to be the one that would show she got to Meadows in 6 minutes from 34 Fairview. The time of her arrival back at 34 Fairview, that one is missing. The one that supposedly shows her showing the taillight to Carrie and Jen, that one also is apparently missing. The video of her leaving One Meadows the very next day, the afternoon after she gets out from the hospital, that one seems to be missing too. The defense, I think, would need to highlight what's missing, but also, as I recall from the first trial, there wasn't access to the ring footage on this desktop. That was pretty sure it was Guarino, because Guarino did most of the digital forensics. Pretty sure that came out from him. She could not have accessed the ring footage from the desktop because the desktop didn't have access to the ring system. So I think that, yeah, they can handle that by just eliciting other facts from other witnesses. You don't have to, for example, cross-examine the kids on that or anything like that. I don't think you would do that. But yeah, the closing, who did it, who had access, who had opportunity. What are the indications as far as what was available to law enforcement from the ring video originally versus what do we have here now at trial? I would expect all that stuff to be developed. Melissa Garcia, have you been reading the jury reactions? Seems like they like the defense team. Do you think that gives them the high ground? Also, Jeff is so lucky. I've read some of Jess Machado's, and in particular, when she's in the courtroom, I like, she gives very detailed observations, and she puts it just in terms of what she's observing. I like that because the problem is that, just like we talked about with the video yesterday, how maybe counterintuitively you think, oh, it's on video, that's going to be great evidence. Often it's not. It just becomes something that you can project your expectations and your theories onto. Juror reactions can be like that too. Juror reactions can be a very easy place to project what you think is happening, what you think the right reaction is. It's a playground for confirmation bias. I think it's ridiculous, so I might laugh. So therefore, that juror laughing means that they are seeing this the same way that I am. But you don't know that. They could be laughing about something completely different. So I always hesitate. I really do. I hesitate to try to get in the minds of the jurors based on the physical manifestations of what they're doing there in court. But it's hard not to. We are human, and we're trying to make sense out of the limited information that we have provided to us. So I would agree that some of what's described does sound positive to the defense. Does sound positive. They're like chuckling at some of Bukhenik's explanations and things like that. Like, sounds like they think it's ridiculous. They think it's absurd, whatever. But we don't know. We don't know. It's very hard to say, and you can lose a lot of money betting on what you think a jury is thinking. So often it's something completely different than what the lawyers expect. Lisa, Andrea, can you expand on why it's important to show public testimony, First Amendment? It's not just because it's amendment, it's for truth verification. It's part of us being able to have trust in our institutions. That's the whole point, is for there to be transparency, that we can see what's happening. We can see, okay, the courts are supposed to perform this role of providing us with justice, vindicating when people harm us in criminal ways, restoring us when there are, civil wrongs, providing a platform for disputes to be aired and decided. Okay, and this all exists so that we don't do that by ourselves in the streets using our own methods, because that would be chaos and anarchy and insecure and dangerous. This is why I mentioned Ghetto Side. Wonderful, wonderful book by Jill Iovine. Really enjoyed it. This is a lot of what she's talking about. She's looking at South Central LA and the vacuum in a lot of these communities. The vacuum that is created when people lose trust in police and in the institutions to provide these things for them. Because, police don't care about certain crimes. Police don't care about certain victims. And unfortunately, there's a long, long history of that. So if there's a vacuum, the vacuum will be filled by something. And so in a lot of these communities, that's gangs. That's gangs come in and provide some kind of structure, some kind of system of justice. And it's a different one than what you get from the courts. But there's a logic to it. It's just the problem is it, might not be perfect. People get caught in the crossfire, quite literally. So that's why we have these systems, so that we trust them to do it for us. And we don't have to. We don't have this vacuum that gets filled by, some other authority, some other group that, purports to provide that to us. So being able to see it is an important part of maintaining the trust in it, so that we know it's working the way it's supposed to. If all court happened behind a closed door and we have no idea what any of the evidence is, and all we get is the decision of the judge, all we get is the outcome, and we're supposed to just take that on faith. Now imagine you have a situation where the judge is found to be corrupt. The judge is taking bribes from somebody. The judge is, in cahoots with one party over another party. Now imagine that happens. And now you have that loss in trust in the institution, and it's magnified because now you can't trust anything that judge did. If the process is transparent, we can at least go back and, monitor the other cases. Be like, okay, well, this one was bad, but this one, they pretty clearly had good evidence in that guy, against that guy. So it's not going to shake the whole foundations of the justice that's coming out of that court. That's the goal that transparency serves. This government exists for us. And so it needs to be responsive to us, but the only way it can be is if we know what's happening. I think a lot of times with government and the First Amendment, we focus on the president and the legislature, the people adopting the laws, and we tend to forget the courts. The courts are essential government. They also need to be responsive to us. If they are not working the way we expect them to do, we have the power to change that. And so The only way that we can know if good decisions are coming out of the court is if we know what those decisions are based on. So that's my spiel on court transparency. It's critical to have any kind of trust in the institution, to be able to monitor whether it is doing what it's supposed to do. And so every time you yeet the public out of the courtroom, you are requiring them to take on faith that you're doing it correctly. Trust us, bro. Trust us, bro. And it just may not always be a very good gamble. If people's faith in the institution is lowered, they may not be willing to give you that benefit of the doubt. Z, sanction for Commonwealth letting Carrie and Jen for say kids' names. I mean, I don't know. It first wasn't objected to, wasn't clarified, no curative instruction, no attention drawn to it whatsoever. I don't recall if it was part of the order, one of the motions in limine. It was, wasn't it, to only refer to them by initials? And so it's the Commonwealth's responsibility to make sure that their witnesses know what are the parameters of your testimony. If there's things you're not supposed to say, it's the Commonwealth's job to make sure that you know that. So if their witnesses, volunteer stuff that they're not supposed to, that is arguably on the Commonwealth. But at the same time, things just happen. Jen McCabe is not herself the Commonwealth. The fact that Jen McCabe says the name doesn't in and of itself mean that the Commonwealth didn't tell her, don't say the name. People just forget, or people can ignore those types of instructions too. Oh, we're not supposed to talk about harassment. Let me make sure to mention harassment a few times, for example. So not clear to me that just saying the name is going to prove that the Commonwealth is in contempt. It happens. Nobody's supposed to talk about the last trial, and yet 3 people have done it. I think at least 3. It's been several people now that have slipped, let that one out. So really not a secret to the jury at this point what that prior proceeding from last year was. So no, I doubt there's going to be any kind of sanction. I doubt it. I'd be shocked. Marcelo, the Lieutenant Fanning issue and how Bev handled it rubbed me the wrong way. The chain of information was unknown to Fanning, to court officer, to Bev, yet the judge was like, okay, bye, juror. I expected you anyway. Yeah, this was a big problem. The only factual basis for her to have yeeted this juror was the colloquy that they had with the juror, where she's like, did these things happen? And the juror's like, no. And then the juror's like, I don't know. What are you talking about? And so Judge Bev's conclusion, well, the juror didn't deny it. Therefore, we're going to find her. So not denying something is not the same as proving that something happened. Okay. It's not the same as having evidence that something happened. But it also, not clearly not a denial. Oh, it looks like they're coming back now. Who is this sitting in the witness stand? So I agree. I think there were a lot of problems with this. She did take it on faith.
Mr. Lally, whenever you're ready.
Never questioned her.
Good morning, sir.
Good morning, sir.
Could you please introduce yourself to the jury and spell your last name for the court?
My name is Zachary Clark. My last name is spelled C-L-A-R-K.
And what do you do for work, sir?
I'm a sergeant with the state police, sir.
And how long in total have you worked for the Mass State Police?
Approximately 7 years.
And in what capacity do you currently work?
I currently work for the Norfolk District Attorney's Office.
In the detective unit, is that correct?
That's correct.
And how long or when did you begin working with the Norfolk County SPDU?
February of 2023.
And you're a sergeant currently within the state police, is that correct?
That's correct.
And when you initially joined the Massachusetts State Police, did you undergo any training?
Yes, I did.
And can you please describe to the jury, generally speaking, what that training consisted of?
Yes. I attended the 83rd RTT, or Recruit Training Troop, with the state police, hosted in New Braintree. It's approximately 6 to 7 months in duration.
I don't remember this
Included
guy from
criminal
the
law,
first trial.
criminal procedure, motor vehicle law, defensive tactics, emergency vehicle operations, etc.
Now, when you initially joined the state police, where were you assigned?
I was originally assigned to the State Police Sturbridge Barracks, or C5.
And how long were you at the Sturbridge Barracks at C5?
Approximately 2 years.
And where
And
did
why
you go
does
from
this
there?
matter?
From there, I transferred to the Crime Scene Services section
Oh,
in
crime scene
2020,
services.
and I spent 3 years in that unit.
And what specialized training did you receive in relation to that work with the Crime Scene Services section?
Upon entry to that unit, troopers assigned are put through an in-house training program hosted by the state police. It's the lion's share of a year. Begins with the history of the study of fingerprints, biology,
Is he the
morphology.
forensic photographer?
It progresses
perhaps?
to supervised casework, processing techniques, evidence collection, and culminates in a competency exam for any of the disciplines that the trooper is assigned.
Now, when you're working for the Crime Scene Services section, how are assignments made typically within that unit?
Typically, troopers work on an on-call schedule. They're given advance notice, and they're on call for 24-hour periods. Most often, if a call is received or a request is made for crime scene services during that call period, the trooper assigned responds.
And sort of geographically, as far as the on-call trooper is concerned, how is that sort of divvied up?
So I was assigned to the Maynard Laboratory. The Crime Scene Services section is organized by crime labs. Maynard encompasses a large area, upward of 50 cities and towns. Some of the more northern towns would be Lowell and Billerica, and it goes all the way down to Canton and Stoughton. The trooper on call for that 24-hour period covers that entire region.
Now, sir, were you working with the State Police Crime Scene Services section on February 1st, 2022?
Yes, I was.
And where were you requested to go on that date?
I was requested to respond to the Canton Police Headquarters.
And approximately what time did you arrive at the Canton Police Department?
Approximately 9 in the morning.
And who did you meet upon your arrival there?
I was met by the requesting officer, Michael Proctor.
And what was the purpose, or what was described to you initially as the purpose of you responding to that location?
The request was made for me to assist in documenting a search warrant that was being executed on a vehicle housed at the police department.
And who do you recall being present during your time at the Canton Police Department and during that search warrant execution?
Trooper Proctor was present. There was a forensic scientist from the crime lab, Maureen Hartnett. There were various members of the Canton Police Department. There were members of the State Police Crash Reconstruction Section, Trooper Joe Paul, to name one. There were members of the Norfolk SPDU as well.
And if you know, in addition to Michael Proctor, how many other members of the Norfolk SPDU were present during the search warrant?
I'm aware of at least 3.
And what was it that you were asked to document at that location?
Namely, it was Karen Reed's vehicle.
And where was that vehicle located within the Canton Police Department?
It was in the garage bay.
Now, can you describe to the jury the process of your documentation or memorialization of that vehicle that morning?
Yes. Typically, upon arrival, I would consult with the requesting officer to determine the scope of the search warrant. In that case, it was Michael Proctor. He described that the vehicle was being searched for a variety of things, to include biological evidence, communication devices, alcohol containers, receipts, infotainment center data, etc. He asked me to document the vehicle with digital photographs. I then consulted with the forensic scientist who was present as well to determine the order in which the vehicle would be documented and processed. I began by documenting the vehicle's exterior with photographs prior to any manipulation or movement, and then proceeded to document the interior and its contents.
Now, any items that were seized during the execution of that search warrant, how were they photographed prior to being seized?
They're photographed in place prior to being moved.
Now, what kind of instruments or tools do you use typically while photographing items for crime scene services?
The main piece of equipment we would use is a digital camera. We wear protective equipment, namely gloves and a mask typically, often a scale so that the images can be calibrated to true size upon examination later. Sometimes placards or ruler tape we placed on items of interest or items that will be collected.
Now, on this occasion, you mentioned Maureen Hartnett from the crime lab was present there as well.
That's correct, sir.
And what did you observe her doing as far as any sort of documentation with relation to certain things or items or areas of the vehicle?
My recollection is that she was chiefly concerned with the exterior of the vehicle, namely the rear right corner, and she was looking for DNA and trace evidence, I believe.
And as far as, was there any delineation that you saw her place on the vehicle with respect to certain areas of the vehicle?
Yes, she marked various locations on the vehicle with ruler tape.
And is that something that you would photograph both prior to and afterward when she would place those stickers or labels on the vehicle?
The area would be documented during my overall photographs prior to her placing any placards or ruler tape. And then once those placards are placed, they would be photographed again.
Now, in addition to the photographs, what else did you do with respect to the vehicle?
I was also asked to process the front right passenger compartment of the vehicle for friction ridge impressions.
Now, what is a friction ridge impression?
A friction ridge impression is it's a replica or an impression of the friction ridge skin on the hands or the feet. Friction ridge skin is an evolutionary adaptation on human beings that allow for better grasp of objects. What makes it unique and significant to policing is that that friction ridge skin has unique patterns. They're formed through ridges and furrows or hills and valleys, and they're unique to every individual. In the hundreds of years that fingerprints have been studied, no two individuals have ever been determined to have the same fingerprints. Analysts are trained to examine these patterns, more importantly, the individual ridge events, and conduct examinations that can lead to identifications or exclusions.
Now, just briefly, can you describe for the jury that process of how you do that?
I would document the vehicle with photographs first, and then determine what medium would be used to process the vehicle. In this case, white fingerprint powder was selected. The particular area processed was relatively small. It was the front passenger compartment, interior and exterior. I focused on surfaces that were more conducive to friction ridge impressions. Certain surfaces are far more conducive than others. Typically, non-porous surfaces like glass, polished metal, dash surfaces are better for impressions, are more likely to yield impressions than porous surfaces, which is items like paper or unfinished wood.
Depend on the dash material?
The area was processed with white fingerprint powder, examined, and no impressions of value were determined to be present.
Now, just briefly, Trooper Clark, when you say no impressions of value were determined, can you explain to the jury a little more, expound upon what that means?
Terrible
Analysts
question.
are trained to determine during the analysis phase if an impression is of value for comparison. What that means is whether or not the impression, if any, has enough quantitative and qualitative detail where it could be compared to a known impression or an exemplar and make a finding. In this case, there were no usable impressions.
Now, upon that initial documenting of the vehicle, were you asked to go anywhere else?
Yes, I was also requested to respond to 34 Fairview Road in Canton and take overall photographs of a scene.
And when you say overall photographs, can you describe to the jury what your understanding of that term is?
Overall photographs are essentially just like they sound. They're typically taken from a distance. They're not examination level photographs. They're general area photographs.
What just happened? What just happened? No photographs, no fingerprints on the Lexus, but the live stream has just been yeeted by YouTube. Let's see if somebody else has it. Okay. Okay. One crime does seem to have it, so let me although I'm not sure. Let me go ahead and bring it up. He's a little behind.
Just like they
and
sound,
so
they're typically taken from a distance. They're not examination level photographs. They're general area photographs. This particular case, it was an outdoor scene. I was directed where to focus my attention, and I took a series of photographs of that area.
Now, did anyone go with you there?
Not that I recall.
And when you say your area, your attention was directed to certain areas, where were you? Where was your attention focused?
The requesting officer explained that upon my arrival, I would see an area in the front lawn or close to the street at that address where a significant amount of snow had been partially cleared away near a flagpole. He asked that I take overall photographs of that area, given the lighting was preferable, and to focus on the front of the residence, that cleared area, and the street around it.
And Trooper Clark, what do you recall in reference to the snow accumulation on the area of the lawn near the flagpole at 34 Fairview Road on that date of February 1st?
My recollection is that there was a significant amount of snow present. Snowbanks were apparent from what I presume to be plowing. There was an area that it did appear to be cleared and heavily trodden by footwear and tires. Still, even in that area, there was a significant amount of snow with certain spots of grass showing.
Now, while you were there, sir, did you or
Why don't you
anyone
show
else
us
do
your
any sort of
photos?
excavation of that front lawn area?
No.
Now, following that, where did you go?
I returned to the Canton Police Department.
And why did you return to the Canton Police Department at that point?
I had finished my assignment with 34 Fairview, and I was asked to return. I believe the forensic scientist was continuing to process the vehicle. At that time, I would re-encounter her and determine if there was any additional photographs required.
Now, in addition to the photographs that you took initially at the Canton Police Department, what else did you memorialize with reference to the vehicle that day?
They took general photographs of the vehicle, the contents. At one point, a bag was presented to me with evidence by one of the Canton officers.
Let me ask it this way, sir. At some point, you mentioned there was a reconstruction trooper who was present at the Canton Police Department, correct?
That's correct.
And so what, if anything, did you document with respect to that reconstruction trooper outside of the Canton Police Department?
Trooper Joe Paul asked while I was there to document a series of brake and acceleration tests with digital video that he was performing with the same vehicle. I was also asked to take photographs and video of the vehicle's backup warning system, which was activated as they performed some tests.
Your Honor, may I approach?
Yes.
Trooper Paul has now made his entrance. The jury's heard about him. Are they going to call him, or will they wonder, why didn't we hear from Trooper Joe Paul, reconstructionist?
Do you recognize that?
Yes,
Or what do you recognize that to be?
this is the crime scene photos.
And what's contained on that disc, is that a fair and accurate portrayal of what you observed both inside and outside the Canton Police Department with respect to Miss Reed's vehicle, as well as the scene at 34 Fairview on February 1st?
I presume it is.
Presume it is.
Almost introduced in the minutes of next exhibit.
I'm assuming that that's all that's on the disc, and if that's the case, then we have no objection.
You've seen it.
I haven't seen that particular disc. We have received the photos in discovery. I'm not concerned about that.
Okay. Oh, that'll come in.
Thank you, Your Honor.
Exhibit 133.
Oh, are we gonna lally? Are we gonna lally the photos? We're gonna look at every
Yes.
single photo of
With
the
the court's permission, if I could just
unhelpful
publish a few of
fingerprints.
those photos to the jury.
Okay.
Oh, just a few. He's gonna edit.
I'm sorry, Your Honor. May I approach the witness just
Yes.
briefly?
Sorry, my bad. Wrong disc.
Sir, I'm presenting you with 3 photographs. Do you recognize what's depicted in each of those 3 photographs?
Yes, I do.
And what do you recognize depicted in each of those 3 photographs in general?
I would describe these as mid-range and a close-up photograph of the vehicle's dash area.
And Your Honor, separately, may I Commonwealth seek to introduce and admit as the next 3 exhibits?
All right, but I'd like to do it as one exhibit.
ABC?
Please, yes.
Yes.
Why are these photos not on the disc? It's like he's put in the disc to try to show the jury he's being comprehensive.
134A through 134C.
He doesn't show everything. But then why do you have photos that are not on the disc?
And my apologies, Your Honor. With the court's permission, may I now publish some of those photos?
Yes.
Thank you. Ms. Gilman, if I could have photograph 2616.
Or are they the same and we just have duplicative stuff here? It's bizarre.
And Ms. Gilman, if I could ask you to zoom in on the steering wheel just above the L for the Lexus sign. And Sergeant Clark, do you see what's depicted up on the screen?
Yes, I do.
And from this photograph, just above the steering wheel on the right-hand side, what do you observe there?
Vehicle's odometer reading.
And is that what the odometer read as far as when you took this photograph outside of the Canton Police Station on February 1st?
Yes, it is.
And Ms. Gilman, if I could have 2617.
You couldn't tell if that last number was a 5 or a 9,
And again,
or at
Ms.
least
Gilman,
I
if you could
couldn't.
just zoom in a little on the center of that photograph. And again, Sergeant, if you could describe for the jury what we're looking at in this photograph.
This is a mid-range photograph of the vehicle's display screen, the center console, with the what I would describe as the backup warning system activated as the vehicle approaches a pedestrian.
And lastly, Ms. Gilman, the next photograph, which is 2618. And again, Sergeant, what are we looking at in this photograph?
More or less the same as the last photograph, sir.
Closer up image than the prior photograph, is that correct?
That's correct.
Thank you. Ms. Gilman, you can take that down. Thank you, sir. I have nothing further
Matter a
to
lot
finish.
between 5 and 9.
Yanetti?
Thank you, Your Honor.
So they edited and they kept this guy. Oh, Lord.
Good morning, Trooper.
Good morning, sir.
Your earliest involvement in this case was on February 1st of 2022.
That's correct.
You ended up, and by the way, at that time, you were a trooper assigned to the crime scene services section,
That's correct.
and that was in which town in Massachusetts?
Where I was assigned, sir?
Yes,
Maynard.
Maynard, okay. About a year later, you actually joined the Norfolk CPAC unit or the Norfolk Detectives Unit, correct?
That's correct.
And when you joined the Norfolk CPAC unit, Lieutenant Brian Tully was the supervisor of that unit, was he not?
Yes, he was.
You are still with that unit, correct?
That's correct.
So you've been there for approximately 2 years, a little bit more than 2 years.
That's correct.
And so you were there when Lieutenant Tully was removed as the supervisor of that unit, correct?
That's sustained, and folks should to disregard that.
Now, if I could request an instruction.
Jurors, pay no attention to that question or answer. That is not properly before you with this witness.
Is Lieutenant Tully still the supervisor of that unit?
Yes.
I'm going to see you at sidebar for just a minute, please.
Why can't he testify to it? What's the problem here? He would know. Wouldn't he know who his boss is? Wouldn't he know who his supervisor is? Do they think like this is not coming in because what the Commonwealth isn't calling Tully? The defense can call him and get it elicited. Isn't this one of the disciplinary actions that was taken as a result of all of the fallout from this investigation and the last trial and so forth? Tully doesn't run the Norfolk County District Attorney's Office Detectives Unit anymore. I don't know why he couldn't testify to that. He would seem to have personal knowledge of whether his boss is still his boss. I can't believe they're editing their case and yet we're still bringing in this guy to make sure we see that terrible photograph of the odometer that doesn't make it clear whether it's 12,665 or 12,669. Looked like it could have been either of those given the script is not the right word, but just the font the numbers appear in. Couldn't really tell what it even said. Surely that matters. Yeah, I don't know why this is off limits.
Okay, so going back to February 1st of 2022, you learned that Michael Proctor had called your unit, resulting in your involvement in this case on that date, correct?
That's right.
And Michael Proctor had requested that you go to the Canton Police Station?
That's correct.
At the time, were you aware that the Canton Police Station, or the Canton Police Department, I should say, had a conflict of interest with this investigation?
Objection.
Rephrase it.
Well, were you aware when you were called out on this case that John O'Keefe had been found mortally wounded on Brian Albert's lawn?
No, he didn't know that.
I was advised of that fact upon my arrival.
Okay. And you were you advised of the fact that Brian Albert's brother was a Canton police detective?
I did not know that.
All right. Still, it was the Canton Police Station and not a state police barracks where Michael Proctor instructed you to go, correct?
That's right.
Was he there before you, or did you arrive there before him?
He was there before me.
When you got there, where did you see Michael Proctor within the Canton Police Department?
Inside the garage bay.
And is that also called a sally port?
Yes.
And when you got there, was Michael Proctor the one to direct you to the Lexus SUV?
Yes.
And when you got there on February 1st, that was the first time that you laid eyes on that vehicle, correct?
Yes, it is.
There was no other investigator from the State Police Detectives Unit or the CPAC unit there with the Lexus SUV except for Michael Proctor, correct?
There were other investigators from the Norfolk District Attorney's Office present that morning.
In any case, you had no personal knowledge prior to your arrival of how long Michael Proctor had been with that SUV before you got there, correct?
That's right.
You have no personal knowledge about whether anyone was monitoring Michael Proctor while he was near the vehicle before you got there?
That's correct.
And before you got there, you had no idea how much access Michael Proctor had to that vehicle, right?
Correct.
Your assignment was to take photographs and to process the passenger's compartment in particular for fingerprints.
Correct.
And you
did
found
that.
none.
Yes, I did.
Bless you. About a year and a half after that, on July 18th of 2023, you participated in this investigation again, did you not?
Yes, I did.
And that was because, in part, you had now joined the Norfolk CPAC unit, correct?
Correct.
And you participated in an interview of Colin Albert at the Norfolk DA's office, right?
That's right.
You knew at the time that Colin Albert was the nephew of the homeowner, Brian Albert?
Objection.
I'll allow that. Did you know that at the time?
Could you rephrase the question?
Sure. At the time that you were called in for this interview and told that you would be participating in an interview of Colin Albert, you knew that he was Brian Albert's nephew, correct?
I was advised that prior to the interview, yes.
You conducted that interview along with Michael Proctor, correct?
Correct.
At the time, Michael Proctor was a state trooper in that unit, correct?
Yes, he was.
And you knew he was also the lead investigator on the case, correct?
He was the case officer, yes.
Case officer. That's okay. Those are equivalent.
At the time
Just
of that
told us those are
interview
equivalent.
on July 18th, before you began questioning of Colin Albert, had Michael Proctor revealed to you his connections with the Albert family?
Objection.
Sustained.
Will you approach?
Go on to the next area and see if you can come back.
Did Michael Proctor reveal to you that he and Kevin Albert had socialized together by drinking alcohol in his cruiser?
Sustained and jurors, I'm going to ask you to strike that question. Disregard.
I need to be heard at sidebar.
I will hear you.
So we asked for the first sidebar and she wouldn't allow it. And now he's trying to get into the drinking with Kevin Albert. It's one of the reasons why he got the boot, wasn't it? Now, Kevin Albert's own sustained findings were not admissible. His own discipline that he received was not admissible, as I recall. But Michael's discipline, in part, was because of this incident that involved Kevin Albert. So he's got a good faith basis to ask about it. It's evidence, even though it doesn't have to be admissible. Michael Proctor's findings are admissible, aren't they? We've certainly been hearing about them. So why can he not ask if this witness is aware of that? The witness may not be aware of that. But he might. And so when did he become aware of that?
A good time to take our morning recess. We'll see you in about 20 minutes.
Taking that morning recess. I don't know if they're going to discuss this more. They're going to argue it after the jury is out. It's kind of what it maybe sounds like, but not totally clear. Yeah, that incident where Kevin Albert got so loaded with Trooper Proctor that he lost his gun somewhere, left his badge in the car. Proctor had to go stick it. Did he stick it in his mailbox? I don't remember exactly all the details. But they had worked that case together out on the Cape, following up on a cold case. Spent the evening getting all loaded, driving back. Lost the gun. Looks like maybe we're just on recess. I'll give it a minute, I guess. We'll see. Why didn't she allow the sidebar the first time? She You just let him have the sidebar. Now he's going to keep trying. Surely you know David Yanetti by now. He's going to, and the fact is, you've set it up so people have to try to read your mind to understand the basis for the objections. And a lot of times it's to form. A lot of times it's to foundation. So what's he going to try to do? He's going to go try to correct the form or to add more foundation. If it's not clear that this is off limits, then you should have a sidebar and explain that. Kind of normal that he would keep trying to cure the problem when nobody is a mind reader as to what you up there are understanding the problem to be. So doesn't want him asking all this stuff about Michael Proctor's discipline through the back door. I guess it's similar to what she did with Bukhenik, right? They had that voir dire to ask, are you aware of any of this stuff? He's not aware of it. So is that the issue? Does Yanetti need to have a good faith basis that this particular officer is aware of it before he's allowed to ask? I mean, maybe that's where she's drawing the line. That seems to be a little more stringent than it needs to be. He just needs to have a basis that it happened and that he's going to be able to get it in. Somebody's going to testify to it. Then he can ask if people are aware of it. I don't know why she's being so stringent about that, like this is some sort of secret. Some sort of secret? No, I think that jury's going to hear about it. Well, hey, if we are on the break, I'm going to look into here we go. We have a little bit of an update about the testimony from this morning, so I am going to go ahead and bring that up. We can take a look from Ted Daniels. The testimony of John O'Keefe's niece is complete and media restrictions lifted. The prosecutor did not call the nephew this time. Niece testified that Karen Reed and John O'Keefe's relationship deteriorated after New Year's Aruba trip. Some quotes. I remember hearing him say the relationship was good, but it had run its course. She was very upset by it. She was yelling louder than JJ. She said Karen Reed woke her up at 4:30 a.m. on 129. Quote, the defendant came into my room. She told me my uncle never came home. So now even the child has adopted calling Karen Reed the defendant. Even the child now has adopted this. She was very frantic. The defendant was asking what could have happened and asking, could I have done something? Got hit by a plow. Later that same day at One Meadows, she just said to myself and my grandfather that she thought she was living in a nightmare. On cross, so they did cross, niece told David Yanetti Karen Reed watched her play sports, took her to visit a private school, and helped her plan her birthday in 2021. David Yanetti, Karen would help you with school projects. Niece, a couple of them, maybe, yeah. And then ADA Adam Lally calls MSP Sergeant Zachary Clark. So that's what that was for, guys. That's the value, putting the kid in the middle of the adult relationship to testify about it. Now we've got her calling Karen Reed the defendant, person she previously had a good relationship with. That's where they're at now. That's so necessary. That's so necessary that justifies calling a juvenile into court as a witness about adult matters witnessed as a child. Not to me. Not to me. Well, who knows what the jury thinks of it? Guess we will have to wait and see. Hey, look at Summertime's question right here in the queue. Should the defense cross the children's testimony? Apparently they did. Limited cross. And simply going to eliciting Karen's own close relationship with the children back at the time. Helped them with school, helped at the birthday party, etc. Can't believe you bring a child in to talk about, oh, their relationship deteriorated. You're not even supposed to really be aware of that. You're going to put the kid in the middle of that. I don't like it at all. Miriam, I love you. Thank you for everything you do. Looking hot as always, though. You're too kind. You're too kind. Getting closer to 50 every day. Hot is long in my past, but I appreciate you. I appreciate you giving me that little boost. Can't help you, Rhonda. Good morning, AB. Did the defense cross the children in the last trial? No, I don't believe they did. My memory, chat can correct me if I'm wrong. My memory is that they didn't ask any questions on cross, but it is possible. Possible. I'm just not remembering that specifically because, of course, we didn't get to watch it. We just got like today reports after the fact of what happened. The cool breeze. Can you explain habeas corpus? Oh man, in 30 seconds or less. Habeas corpus is a residue of an ancient common law right. I believe the writ of habeas corpus may have preceded the Magna Carta, or perhaps originated right around the same time. Ancient writ. And it is an order that habeas corpus means have the body, you have the body. And it's an order specifically to undo a restraint, to release a restraint on somebody that is unlawful. And so habeas corpus now in the U.S., it's often a creature of statute, of rule, but it all derives from this long common law tradition, and it's recognized in many state constitutions and the federal constitution as well. So basically what habeas corpus is a process where you can go to a judge to demand that a person be released from a government restraint. Where we see it most often today is in post-conviction processes. So you go through an appeal, you get convicted in a state court, you go through an appeal, you argue reasons that it was unlawful, the appellate court disagrees with you. You are then often going to be looking at a habeas process, a habeas corpus process, to try to get another court to review that, often a federal court. There's habeas available sometimes in like an equivalent to habeas in state level proceedings, but there's also habeas available in the federal court. So if you think, the appellate court in your state got it wrong for some reason, they violate, their decision doesn't comport with the legal requirements, and so you're continuing to be unlawfully restrained even though you went through the appeal process. You can often present that type of issue in federal court on habeas. That's where I tend to see it in criminal justice most often, is in post-conviction review. But it can come up in other frameworks. We clearly saw it in this case, in this sort of interlocutory review of whether Karen Reed is able to be retried at all, in light of the jurors, multiple jurors from the first trial coming forward saying, hey, we unanimously agreed she was not guilty on counts 1 and counts 3. If the jury acquits, then double jeopardy attaches. You cannot retry that person for the crimes of which the jury has acquitted them. And so she went through first an appeal up to the Massachusetts Superior Court, and then when they are up to the Massachusetts, the Supreme Judicial Court, and they disagreed with her position. So then they took it to federal court using the habeas process. So this is the habeas. The restriction is basically she's subject to release conditions. She's going to be subjected to a new trial. Because of the government, it's unlawful under double jeopardy principles. That's how it worked its way up to ultimately, the petition for certiorari to the U.S. Supreme Court that was denied. can be can be used to review like bail conditions and things like that if they're illegal. If the judge imposes a bail condition that says, the defendant is to be waterboarded from 9 a.m. to 10 a.m. daily until confessing, that would be illegal. That would be violation of it would be due process. It wouldn't probably technically be the Eighth Amendment. It's the Eighth Amendment if it's punishment. Anyway, sort of a technical distinction, but anyway, it would be an illegal condition. So you could theoretically pursue that through a habeas process. The main limit on habeas is that you have to, if you're going to go into federal court and use their habeas proceeding, you have to have exhausted any possibility of getting relief through the state courts, both through a direct appeal type of process, and if there's any type of habeas equivalent proceeding in the state court, you typically have to exhaust that as well. So that's well over 30 seconds. My explanation of habeas corpus. It is an ancient writ, goes long back as a limit on the power of the ultimate executive, whether it's the king or whether it's the president, the prosecutor, the court, to be able to restrain somebody unlawfully. They can't just decide we want this person in jail, so we're going to put him there. If you're interested at all in a little bit of the kind of back history of habeas corpus, I did a video quite some time back. One of the very few times I've had a guest on my channel. It's just not really what I do. But I had Danielle Bolelli, the host of the History on Fire podcast, my favorite podcast, came on with me. It was great to talk about the case of Standing Bear. And I referred to it as the most significant civil rights case you've never heard of, because you probably haven't. You've probably never heard about the case of Standing Bear. But it involved a Native American petitioning in a federal court for a writ of habeas corpus against an order that was attempting to compel him to return to a reservation in Oklahoma after the tribe had been removed and relocated to Oklahoma. He tried to go back home, basically, was arrested by General Crook at the instructions of the U.S. government, and was to be imprisoned and shipped back to Oklahoma against his will, filed for a writ of habeas corpus. And you can watch the rest of the video for the rest of the story if that's the kind of thing that you're interested in. But we talk a little bit about this too, like what it is, how it works, and why it was an issue in that case. So just a little bit more detail on habeas there. MC, good morning, Andrea. When the judge says, I'll allow it, is it the same as overruled? Is the record noted differently as a result of it? Well, the transcript should say verbatim what she says. So it should say, I'll allow it, not overruled. Now, sometimes there are separately from the verbatim transcript, there's often like minutes, a clerk's minutes of what's happening, where the clerk is noting down the significant actions that are taken over the course of a case. So they're noting the witness is called, the witness is sworn, objections, the outcome of the objection, evidence that's offered, evidence is, admitted or not admitted, is it objected to? Basically just keeping track of all the legal issues that are presented over the course of that trial day. So I would expect if there are clerk's minutes, the clerk is translating this term, I'll allow it, into what it is legally signifying, which is, yes, she's overruling an objection. So I would expect the minutes are saying that, but the actual verbatim transcript needs to be her words. And that's what a transcript is supposed to be. I'll allow it. I don't like it. I'm not the only one who doesn't like it. But a big part of the reason why I don't like it is it's just so self-aggrandizing. I'll allow it. Like you're the crown court over here. Like you are the Star Chamber. Like you are. I'll allow it. Ugh, it's just gross. That's not your role. You are a humble servant of the legal system. We're there to administer the rules and the laws as they have been adopted by legislatures, interpreted by courts, applied in other cases that are binding precedents on you. I'll allow it. It just is so big for her britches. That's my main problem with it. Jay Coop, everyone go read Turtle Boy tweet about Karen relationship with the kids. Well, let's go find it. Let's go find Dr. Turtle Boy. Not sure which tweet we are talking about here. One from 1 hour ago, just a reminder before Jennifer McCabe brainwashed John O'Keefe's then 13-year-old niece. The girl told Karen Reid that she, quote, can't imagine my life without you. You are the most amazing person I have ever met, unquote. These children adored Karen, and she helped raise them when Paul O'Keefe wouldn't. Now the Commonwealth is using them as weapons to frame her. That's sad. He's got a photograph of Karen smiling with the kids. The kids' faces are blocked out. There is what looks like a text or a like DM or text exchange between Karen and perhaps one of the children. And the comment is the communication is happy birthday. Thank you so much for everything you do for me. I really appreciate it. I can't believe it's only been 1 year that I've known you. It feels like forever. I can't imagine my life without you. You are the most amazing person I have ever met. And I hope 39 treats you well. Can't wait to make more amazing memories. Sad. Sad. Yeah. They had a very, very good relationship. She was a good influence on the children. Very sad. See where that's at today. The rural juror. The problem with kids is the one area where defense has to decide whether to impeach the dinner. Karen Reid being mad about not eating dinner, showing poor character or not. It was refuted by video evidence, I think, in a pretrial motion. It doesn't sound like this came up. I vaguely remember this from the first trial. That they were trying to elicit like Karen, just instances where Karen, I don't know, the kids didn't like her so much. We've already heard, but just not, I don't think to the extent that they hammered it in at the first trial, that part of the conflict, of course, between John and Karen had to do with the kids. And we heard a little bit, maybe more about this at the first trial, that he considered sometimes what she did to the kids to be spoiling them. She took them out for Dunkin' Donuts the morning of the 28th. That's why they had that long text fight. That's what that fight was about. Karen had taken them out for Dunkin' Donuts. There were other instances where apparently she had bought them expensive gifts. He thought that you're spoiling the children. I hate this type of attitude, honestly. I really do. Like, there's nothing wrong with kids getting treats, kids getting rewards. Like, sure, you can create a sense of entitlement in kids if it's not like a gift, if you're just kind of overwhelming them with, they got to have stuff that's better than everybody else all the time and they get what they want and stuff like that. I mean, yeah, you could create a bad attitude with a kid like that, but just giving a kid a gift in and of itself is not spoiling a kid. It's this very like militarized, strict kind of approach to raising children that, I don't know, just doesn't particularly sit well with me, but, be that as it may, that was a source of a lot of the conflict between John and Karen was, she's too nice to the kids and he thinks she's spoiling them. And so part of the strategy the Commonwealth had in the first trial, I guess, was just to try to show, well, not always, like sometimes she was mean to the kids too. So something about Something about like one time when Karen was the disciplinarian as opposed to John. I mean, yeah, sometimes that happens. Sometimes both parental figures are going to have that kind of responsibility. But I just, yeah, I don't know what the whole point of that was. But didn't elicit it. It doesn't sound like from Ted Daniels' description. So I guess it's a non-issue. Jamie Zoller's Church. Andrea, thank you for keeping us updated and amused and informed. I look forward to your stream each day. Keep on keeping on. Well, thank you. I will do that. I will keep on being here. This is a little bit of a long trial, but it's not too bad. And we gotta see this thing through now. We've seen it the first time. Gotta see it the second time. See how things are different. Appreciate you joining us. Z, vid 1, John O'Keefe didn't want to break up as best relationship he had. Vid 2, Karen unsure if John O'Keefe felt true love or dependence, follows previous clips and testimony. So yeah, I couldn't hear real clearly what was being said in those first two clips that he played today. What I got in my notes was just from the first one in Dateline that he was not breaking up with her, or she understood not breaking up with you. And then in the second one, she didn't think that John knew about the text with Brian. Not sure that he would have reacted or gotten mad or anything. Like, sure, they would have broken up, but not like he would have been emotional about it. That was the lead into the kids' testimony, I guess. Who do we think is the better judge of the state of the relationship between John O'Keefe and Karen Reed? One of the participants in the relationship, or the kids for whom these are the parental type figures? The jury's supposed to be like, oh, Karen is lying about the relationship because of what the kids said. That seems like a reach to me. But looks like Sue has perhaps provided a little bit more commentary about the testimony. So Sue says, regarding the niece's testimony, it doesn't appear to me on first pass that her testimony differed from last trial. Assistant District Attorney Laura McLaughlin did the direct, and defense attorney David Yanetti did the cross. The jurors were attentive, several with sympathetic looks on their faces during her testimony. She made a joke during cross that got a laugh. The Commonwealth established that Karen and John were fighting more in the December 2021 to January 2022 than before, that things were tense. They had a fight in Aruba. Karen was frantic the morning of 1/29. Karen did not interact when she got back to the house. The defense established that Karen took her to get her nails done once a month, took her to Karen's hairstylist, straightened her hair for her one night a week, took both kids to her house without John, went to her sporting events, and she called Karen, not the defendant. Just more about the contrast between what the relationship was then and, how things are now. The Commonwealth established that Karen could be cold when angry, was louder than John when they fought, was asked to leave by John but didn't, told John the kids were worried about him once when he was out, but they weren't. So a little bit of additional information there above and beyond what we got reported by Ted Daniels. Is that helpful? We still trying to get on motive with this. That's the motive. Somehow, Karen having this, breaking apart relationship with John is motive for her to kill him, but Brian Higgins having a romantic interest in Karen is not. If this is a supposed to be a romantic entanglement gone bad, I have a hard time seeing how you fail to see both sides of that equation. James Casatelli, are the recordings of this trial being kept anywhere for posterity by the Commonwealth itself? Nothing in our judicial system should be off camera. I doubt it. I don't know for sure. Now they do have it, we can hear them running the Zoom camera. Sometimes we hear it, when the stream comes on. Sometimes we see it in the captions when the screen is silent. But they you can hear the little invite. You're invited to join. Press whatever. So it does seem like the court is maintaining its own video record of the trial independent of the live feed, but the live feed is not theirs. It belongs to the pool, the camera pool. I don't know if there is like a provision in the order that the court gets a copy of it to keep. But it's not presumptively their property. It's photographs, video evidence, all the equipment and everything is maintained by somebody else. So as far as that goes, not sure. I don't know that we have an answer, but it does seem like they are running the Zoom system, and so they have their own independent record on video. Dear Woke Christian, new here. Great commentary on this story. Great in peace. Well, thank you so much. Appreciate that, and glad to have you here with us. We do have a great time watching this trial. It's a wonderful chat. Thanks for joining in. Jessica, how much influence does D.A. Morrissey have on the way Brennan is trying this case? Well, this is a good question because in theory, he shouldn't have any at all. He has been disqualified. His office as a whole wasn't, but he was. So he shouldn't be exercising any influence over it all. There should, in fact, be like a wall, a barrier between Hank Brennan, whatever Hank is doing with the case, whatever evidence he's developing in the case, theories, plans, etc., should all be completely isolated from the district attorney, Michael Morrissey. Is that happening? Well, your guess is as good as mine. I mean, apparently Michael Morrissey is not above having burner email accounts to, conduct communications he's not supposed to be having. Communications that violate the rules of ethics of attorneys and judges. Ex parte communications about pending matters on a burner email account. So somebody is willing to do that. Are they willing to overlook an order disqualifying them? Should prohibit them from having any information about the case. Do I trust that guy to respect that order and follow it? No, he doesn't respect the ethics rules and follow those. Basic, grounded in due process principle. You don't communicate ex parte with the court about matters pending before the court. That is not allowed. Crystal clear. The judge is supposed to be impartial. You have to treat them that way. But if he doesn't care about that rule, why would he care about this order? Sweet Lorraine, is Brian Higgins the only witness that says the Jeep was parked outside? No one else saw it. Can we tell from Brian Higgins' cell what time he left 34 Fairview? Jen McCabe said it was outside. She placed it at the mailbox. So just past the driveway. She's the only one that's testified from, other than, I guess, Sarah Levinson, inside 34 Fairview. At the time.
All right, so I'll see counsel at Sidebar.
Goes back in session meeting.
Going straight to Sidebar. And I don't believe she saw the Jeep. I don't think she testified about it one way or the other. So it's Jen McCabe's story at this point. We haven't heard from Brian Higgins. In the first trial, Brian Higgins testified that he was the first to get to 34 Fairview. So he lowered his plow. He like swiped out the driveway and then backed out and parked on the street in front of the mailbox. We've heard from the meteorologist now that there was only enough snow to track a cat at that point in time, so this seems a little bit questionable. It's not the amount of snow that you would plow. It's just not necessary. I don't know why you would do that. Scrape the plow, you're going to damage the plow, you're going to damage the driveway. Scraping a big metal plow across somebody's concrete driveway, you can damage it. Doesn't seem like the kind of thing that you do, but that's what he said, and that's what he said last time. Of course, we haven't heard from him this time. So at this point, it's just Jim McCabe that places it out there by the mailbox. We cannot tell from Brian Higgins' cell phone what time he left 34 Fairview because we don't have his cell phone, because he took the SIM card out of it, stuck it in a bag, and took both the cell phone and the SIM card to a military base and put them in a dumpster there. So we don't have his cell. They could possibly get that information through call detail records. I've been talking about that, how that's a way to obtain some location data through cell tower connections that law enforcement can do. They tried to do this. Tully tried to do this in the first trial to identify where Karen went after she left One Meadows Ave at 5:07 in the morning on the 29th. They were trying to hint that she went back to 34 Fairview, but they couldn't establish that. So that type of information is available, but based on that testimony from the first trial, it sounds like it just may not be able to be that precise in this area in Canton. Would it show movement? Maybe, if there's handoffs between towers. So you're within the range of one tower, you move out of the range of that tower and into the range of another tower. The phone activity the connection is going to be handed off from the first tower to the second one. And there are records of that you can get from the phone company. Those can be pretty good to show movement. But I don't know what the tower situation is here. How far is CPD from 34 Fairview? What, mile and a half or something like that? Not very far.
Counsel. Exhibit II for ID. Thank you.
They're working something out. So anyway, possible they can get stuff like that from the call detail records, but it would just depend on the cell tower density and the type of information that they sought out. If they sought out call detail records for him, all that type of thing. So possible, but we didn't hear about that in the first trial as far as I know.
Tour of the session, please be seated.
All right, may we have Sergeant Clark, please?
Yeah, Chief Drummond?
Yes.
Sir, when you went with Michael Proctor to interview Colin Albert, you knew that the case originated on January 29th of 2022?
I was aware of that.
And the date that you conducted that interview was July 18th of 2023?
That's correct.
Did you ever ask Michael Proctor why he waited a year and a half to interview Colin Albert?
I did not.
Once that interview was concluded, one of the two of you had to write a report to document what Colin Albert had told you, correct?
That's correct.
And Michael Proctor, as the lead investigator, was the one to write the report, correct?
Michael Proctor wrote that report.
You did not write it.
Correct.
He chose the language to use in that report, correct?
Correct.
And you weren't standing over him while he was typing it up, correct?
Correct.
And he wrote that report to his supervisor without running every word by you, correct?
That's correct.
Did you ever review that report to check whether it was accurate?
Not before it was published.
And the only other thing I have for you, sir, is you were called to photograph evidence on February 1st. Were you ever asked to go to 34 Fairview Road on February 8th to photograph and document evidence supposedly found on that day?
No, I was not.
Were you ever asked to go to 34 Fairview Road to document any evidence on February 10th?
No, I wasn't.
How about February 11th?
No, sir.
And then on February 18th, nearly 3 weeks after January 29th, did anybody contact you to ask you to come out and photograph and document evidence that was supposedly found 3 weeks later?
Ask it differently, Mr.
Yes.
Yanetti.
Were you called out to 34 Fairview Road on February 18th of 2022 to photograph and document anything?
February 1st was the only date I was called to 34 Fairview, sir.
So the answer to my question is no, correct?
That's correct.
Thank you, sir.
Is there any follow-up, Mr. Lally?
No redirect.
No redirect.
All right.
Thank you, Your Honor.
All
Thank you,
miracles.
folks.
Next witness, please.
Yes, Your Honor. The Commonwealth called Evan Brent to the stand.
Okay.
Another one I don't believe we heard from at the last trial. And another Lally witness.
Excuse me.
You solemnly swear the evidence the court, the jury, in the case down here, and the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning.
Good morning.
All right, go right ahead, Mr. Lally.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please state your name and spell your last name for the jury?
My name is Evan Brent, B-R-E-N-T.
And what do you do for work, sir?
I work for the Massachusetts State Police.
And how long have you been a trooper with the Massachusetts State Police?
For just under 8 years.
And in what capacity do you currently work with the State Police?
Currently, I am a sergeant and I'm assigned to the Leominster Barracks.
Now, going back to when you initially joined the State Police, did you undergo any training?
Yes, I did.
And could you please describe for the jury, generally speaking, what that training consisted of?
I went to the State Police Academy in New Braintree. I attended the 83rd Recruit Training Troop from August 2017 until January of 2018. And I learned about different topics that you would expect to learn about at an academy, such as criminal law and procedure and motor vehicle law, to name a few.
Now, when you joined the State Police, where were you initially assigned?
I was initially assigned to the Holden Barracks.
And how long were you at that barracks?
For about 3 or 4 months.
And where did you go from there?
I went to the Charlton Barracks.
And how long were you in Charlton?
For a little over a year.
And then following Charlton, where did you go from there?
I went to a unit called Crime Scene Services.
Now, what specialized training did you receive in relation to that work with the Crime Scene Services Section unit?
New members assigned to crime scene undergo a progressive training program that consists of completing a series of modules, each of which has assigned readings and a written test for each one. It moves on to assisting in the lab and then eventually assisting in the field. There's additional assigned readings, classroom instruction, and it concludes with a series of competency tests that must be passed before you are assigned your own casework.
Now, when you're working for the Crime Scene Services Section, how are assignments or how are you assigned to a particular case or investigation?
As cases come in, if you're on call, you would own that case if it's your call day, if something comes into the lab or something you need to respond to.
And how long do those on-call periods typically last for?
Typically, when I was there in Maynard, it was 24 hours. So you would own a day starting at 7 in the morning, and it would go all the way until 7 the next morning.
Now, how big of an area does that particular unit, the crime scene services section, how big of an area does it cover?
Oh, Lally being Lally again.
The Maynard lab
the same unimportant
covers
stuff.
somewhere between, I think, 50 and 55
last witness
different
already said.
municipalities.
Now, sir, were you working with the State Police Crime Scene Services section on February 3rd of 2022?
Yes, I was.
And where were you requested to go on that date?
I was requested to respond to an address in Canton.
And do you recall what that address was?
It was 34 Fairview.
And approximately what time did you arrive at that location on Fairview Road?
It was about 9:45 in the morning.
And who did you meet upon your arrival there?
I met with several members of the State Police Detective Unit for Norfolk County.
And do you recall specifically who those members of the State Police Detective Unit were?
Yes, there was Lieutenant Tully, Sergeant Bukhenik, Trooper Proctor, Trooper DeChico, and Trooper Moore.
And when you arrived there, what were you asked to document on that occasion?
There was a search effort digging through some snowbanks that they were looking for some items. They wanted me to document it with photography.
Now, during that search effort, were items located and recovered?
Yes.
Now, can you describe for the jury the process of item recovery that you observed there on that day?
So once an item was excavated, I would be alerted. I would come over, I would document the item in its place, and then one of the detectives would use a gloved hand, and that item would be bagged and documented on the bag.
Was that the same with respect to each item that was photographed by you and then bagged by the State Police Detective Unit?
Yes.
Now, if I could just ask you, if you could expound a little, when you say excavated, what do you mean by that? What did you see being done that day?
They were digging with shovels.
And as far as the items that were recovered, do you recall where they were in relation to the snow pile and the ground itself?
Some were on top of the snow, so there was some significant snow melt. I think that day it was raining out, and it was much warmer than it was the previous 3 days. So some had been revealed by this melted snow, so they were on top. Others were under a foot and a half of snow.
Now, what kind of instruments or tools do you use in addition to your camera when you're photographing items?
So items of interest would be documented with a scale, so that way it would show how big the item is.
And why is it that you use a scale as far as photographs are concerned when it comes to certain items?
Because some of the photos, you wouldn't be able to tell how big the item is or proportionally what it looks like. So it has the scales, just a little ruler that shows exactly how big the item is.
Now, sir, upon your completion of documenting recovery of items at Fairview Road, were you asked to go anywhere else?
Yes, I was.
And where were you asked to go?
I agree with this.
I was asked to go to an address 1 Meadows Road.
And who went with you there?
Trooper Proctor.
And once there, what were you asked to document or memorialize at that secondary location of 1 Meadows Ave?
There was a vehicle in the driveway that he wanted me to document.
And was that a Chevrolet Traverse, is that correct?
Yes.
And were you asked to document anything else with respect to the home adjacent to that driveway?
There was a camera up above the garage that he had pointed out, so I just documented that as well.
Thank you. Your Honor, may I approach?
Why would they know on February 3rd that they need to document John's car unless they had seen the Ring video and knew that she had hit his car? Why would they need
Showing
to
you
document
this,
the condition
you
of his
recognize
car?
that?
His car has nothing to do with
Yes.
any of it.
What do you recognize that to be?
It's a disc of crime scene photos.
And the photos on that disc, are those the photos that you took at each of those respective locations on February 3rd, both 34 Fairview and 1 Meadows Ave?
Yes.
And what's contained on that disc and those photos, is that a fair and accurate portrayal of what you observed at each of those respective locations that day?
Yes, it is.
Your Honor, Commonwealth seek to introduce the minutes of the next exhibit.
And same caveat, as long as that's all that's on that disc, we have no objection.
Okay. It's coming in.
Exhibit 135.
And Your Honor, may I approach the witness again?
Yes.
So I'm handing you a series of 7 photographs. Do you recognize generally what's depicted in those 7 photographs?
Yep, Jen had that little slip. The car repair guy was
And
there.
the first 5 of those photographs, is that essentially taking photographs as you walk around the Chevrolet Traverse in the driveway that day?
Yes, that is correct.
And the last 2 were of the garage doors at 1 Meadows Ave, is that correct?
Yes, sir.
Your Honor, Commonwealth seek to introduce and admit as next exhibits.
No objection.
So he's doing this in duplicate. He's doing his Lally thing, I guess, where he puts in everything in bold, but then he is separately admitting some of them that are just the ones he wants the jury to look at.
And Your Honor, with the court's permission, may I publish those photographs in relatively short fashion with the jury?
Sure.
Ms. Gilman, if I could have photograph 7749. And Trooper, just briefly, what are we looking at in this photograph?
The front entrance to that address, 1 Meadows.
Ms. Gilman, 7752. And Trooper, same question, what are we looking at here?
That was the vehicle in question.
And if you could, Trooper, just describe sort of perspective-wise what portion of the vehicle we're looking at in this photograph.
So we are looking at an angle view of a Chevy Traverse, the back of the
Lord.
vehicle, and part of the driver's side.
Should the jury not be able
And
to
Ms.
use
Gilman,
their own eyes
7758.
to know what part of the car they're looking at?
And
Why
what
might
part
it
of the
be
vehicle
inverted
does
or
this depict,
something?
Trooper?
The rear of the vehicle.
And Ms. Gilman, 7759. And again, Trooper, what portion of the vehicle in this photograph?
This is going to be an angle view of the rear of the vehicle and the passenger side.
And Ms. Gilman, 7769. And again, Trooper, what portion of the vehicle in this photograph?
This is the front of the vehicle.
And Ms. Gilman, 7771. Again, Trooper, what are we looking at in this photograph?
And an angle view of the front of the vehicle and the driver's side.
And Ms. Gilman, if I could have 7777.
Carefully documented John's car that has nothing to do with anything, but not
And again,
taillight.
Trooper, what are we looking at in this photograph?
This is the driver's side rear quarter panel.
And Ms. Gilman,
Very close,
7791.
attentive to that. Why? Why the interest in the quarter panel on February the
Now, you
3rd?
also took photographs of the garage doors at 1 Meadows Ave, is that correct?
Yes, sir.
Okay, and how many garage doors did you observe there that day?
2 garage doors.
And which of the 2 is this?
This is going to be the right garage door.
And Ms. Gilman, if I could have 7795. And which of the 2 garage doors is this, Trooper?
This will be the left garage door.
Thank you very much. Ms. Gilman, thank you very much. You can take those down.
The garage doors, really critical pieces of the case. Thank God we called this guy to make sure the jury
Now,
has
Trooper
those
Brent,
photos
from
of
your
garage doors.
observations of those photographs and your observations personally, visually on scene February 3rd at 1 Meadows Ave, what damage did you observe to the garage doors at that residence?
I did not observe any damage to them.
And again, both from your view of those photographs and your in-person visual observations of the Chevy Traverse from all angles on that date of February 3rd, what damage did you observe to that Chevy Traverse?
I observed no visible damage.
Thank you, sir. No further questions, Your Honor.
All right. Any questions, Mr. Yanetti?
Yes, Your Honor, thank you.
Why were you looking for damage on February the 3rd? What did you think might have been there?
Sorry.
They're not supposed to know.
Good morning, Trooper.
Morning, sir.
To be clear, the Chevy Traverse that you photographed at One Meadows, you did so on February 3rd of 2022, correct?
Yes, sir.
And you realized at the time that was 5 days prior to the incident in question, which was January 29th of 2022?
5 days after, not prior.
Did I say prior?
You did.
Thank you for correcting me because you're right. You were photographing it 5 days after January 29th, correct?
Mm-hmm.
Yes, sir.
And it's fair to say, sir, that your earliest involvement in the case was February 3rd of 2022, correct?
Yes, sir.
So you don't know, and you didn't know at the time who had access to that Traverse during those 5 days, correct?
That is correct.
Now, as of February 3rd of 2022, you, I believe, testified you were part of the crime scene services section of the Massachusetts State Police, correct?
Yes, sir.
You met former Trooper Michael Proctor on February 3rd at 34 Fairview Road in Canton?
Yes, I did.
At the time, did you know you were at the home of a Boston police officer named Brian Albert?
I did not.
And February 3rd was the first and only time that you responded to 34 Fairview Road, correct?
That is correct.
With regard to anything that you saw on the lawn or on the snow that day, you have no personal knowledge as to how any of those items got there, correct?
I do not.
And 5 days after January 29th, you had no personal knowledge at the time of who had access to that front lawn during those 5 days, correct?
That is correct.
You had no information that a guard had ever been posted near that lawn?
Not that I'm aware of.
And when you got there, there was no crime scene tape, correct?
No, there was not.
There was no tent?
No.
Other than the police officers standing there on February 3rd, the lawn was open to anyone who wanted to look at it, just like any other lawn on the street, right?
I'm unaware of that. I don't know.
Now, in terms of your actions that day in documenting the scene with photographs, you did not write a report on what you saw and what you photographed, correct?
I took notes of what I saw and what I photographed.
Michael Proctor was the one to write the report in which he reported that you were the photographer on scene, correct?
I don't know what Michael Proctor did for a report, so I can't testify to that.
Okay, but you didn't write a report.
I wrote a report of what I did, showing up at the scene and taking photos and then submitting those photos to the Norfolk County Detectives Unit.
You knew at the time that Michael Proctor was the lead investigator on the case, correct?
Yes, I did.
And
didn't get the memo on the case agent.
Other dates in February, on February 8th of 2022, were you asked to go back to 34 Fairview Road to document and photograph anything found on that day?
I do not believe so, no.
What about February 10th?
No.
February 11th?
Again, my only involvement was on February 3rd.
So that means that on February 18th, nearly 3 weeks after January 29th, you were not asked to go back to 34 Fairview to document or photograph anything on the lawn that day, correct?
Correct.
I have nothing further, sir. Thank you.
Any questions, Mr. Lally?
Very briefly.
Okay.
When you say Proctor was the lead investigator, don't you mean case agent?
Just for clarity, Trooper Brent, you did write a report in relation to your response documentation on February 3rd, 2022, correct?
That is correct.
And you mentioned that you also took notes, is that correct?
That is correct.
And what did those notes entail?
It detailed several items that were collected, my response timed, and who else was there on scene.
Now, when you were there on scene, as far as 34 Fairview on February 3rd, what did you observe as far as these? You mentioned that the weather had gotten warmer, some snow had melted. What did you observe specifically as far as the snow accumulation on that front lawn area in the area of the flagpole of 34 Fairview?
Objection beyond the scope.
Sustained. Sustained.
Beyond the scope.
As far as these items, again, when they were recovered, several of these items were under how much snow?
I would estimate about, there was one particular item that was about a foot and a half under the snow.
Nothing further.
Nothing on that.
All right. All right, Trooper, you are all set, sir. Thank you.
All set, sir. Using her Jessica Hyde voice.
Who is the Commonwealth's next witness?
Your Honor, the Commonwealth will call Brian Gallerani to the stand.
Okay.
Brian who?
Your Honor, as this witness is approaching, can I just move into evidence clips 19 and 20 that were previously played for the jury?
Yes.
Thank you.
Okay, Gallerani. There he is on the list. Just want to make sure I know how to spell his name.
You solemnly swear the evidence given before the jury in the case down here to be true.
Yet another new witness.
Good afternoon.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the court?
Brian Gallerani, Gallerani.
And what do you do for work, sir?
I'm currently employed as a sergeant for the Needham Police Department.
And how long in total have you been a member of the Needham Police Department?
19 years.
And how long have you held the rank of sergeant?
2 years. It'll be 2 years in July.
Now, prior to holding the rank of sergeant with the Needham Police Department, what did you do before that at the Needham Police?
I was a detective for 8 years.
Now, over the course of your work as a detective with the Needham Police Department, what training have you received in regard to collection of biological samples?
I've been certified by the Mass State Police since 2015 in collecting DNA.
Now, can you explain just briefly to the jury sort of what that process of certification entailed? Sort of how did you become certified?
Excuse me. So specifically, I was certified in DNA buccal swab, which is the process of obtaining cells suitable for comparison, DNA comparison by swabbing a person's cheek, cells, and gums.
You got
and that
special training
certification
to
that you
swab a
received,
cheek?
is that up to date at this point?
It is.
Now, at some point on January 16th of 2024, did you have occasion to collect buccal swabs or samples in relation to this case?
I did.
And before I get to that, just briefly,
Proctor
as far as
Bukhenik?
with your work as a Needham Police detective and or sergeant, you had no involvement with any investigation either by the Canton Police or the State Police in relation to any incident in the town of Canton, correct?
Correct.
Now, with respect to that date of January 16th, where did you go?
I went to Norfolk County DA's office in Canton.
And who did you meet with, or who did you collect samples from on that occasion?
I collected samples from Trooper Proctor and Sergeant Bukhenik.
And again, briefly, can you explain to the jury the process of that collection of samples from Sergeant Bukhenik and Trooper Proctor?
Mm-hmm. So I swabbed the inside of their mouths with a cotton swab. I let it air dry, put it in the kit, sealed it, and photographed it.
And then following your collection, what did you do with those collections once you had them?
I brought that back to the Needham Police Department and entered it into the evidence locker.
And as far as that collection process that you were describing, did you do that
Was there
in
a log?
conformity with the training and certification that you referenced earlier?
I did.
Did it get logged?
With reference to those items, at some point were you informed that those items were to be transferred or transported to a Bodie Technology Lab in Lorton, Virginia?
Yes.
And were there any specific instructions as far as shipping that you received from the lab in reference to those items?
There were.
And did you comply with those instructions as far as how those items were shipped from the Needham Police Department to the Bodie Lab in Virginia?
Yes.
I have nothing further. Thank you.
Any questions from the defense?
Very briefly, Judge. Good morning, sir.
Good morning.
Were you ever asked to do any buccal swabs of Chief Berkowitz of the Canton Police Department?
I'll allow that.
No.
Were you ever asked to do any buccal swabs of Detective Kevin Albert of the Canton Police Department?
No.
Were you ever asked to do any buccal swabs of Lieutenant Brian Tully of the Massachusetts State Police?
No.
O'Hara?
Thank you. I have nothing further.
No, just the big
Anything,
guys.
Mr. Lally?
No, Your Honor.
All right. Thank you very much, Sergeant. You're all set.
Thank you.
Good questions.
Next witness for the Commonwealth?
Commonwealth calls Maureen Hartnett.
There she is. Been waiting to see. Knew they needed to call her. Getting ever closer and closer to presenting a technical case.
Follow me, ma'am.
You solemnly swear the evidence of the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good afternoon.
Good afternoon.
You consider stand wherever you're comfortable. Please keep your voice up, okay?
Yes.
Whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and offer the spelling of your last name?
My name is Maureen Hartnett, Hartnett.
Could you tell us where you presently work?
I work at the Massachusetts State Police Crime Laboratory.
Before you began working at the Massachusetts State Police Crime Laboratory, did you receive any education, any further schooling after high school?
Yes, I did.
Could you share that with us?
I have a bachelor's degree in biology from Bridgewater State University and a master's degree in forensic science from the University of New Haven.
After you graduated with your master's, did you begin working at the crime laboratory or did you work somewhere else before?
I began working at the Massachusetts State Police Crime Laboratory.
How long have you worked at the Massachusetts State Police Crime Laboratory for?
I've worked there in total approximately 9 years.
Can you give us a basic understanding of how the crime laboratory you work at is broken down, the different departments and what you do?
There are various units within the laboratory. There is the criminalistics unit, which is the unit I work for, the DNA unit, the Office of Alcohol Testing, the Arson and Trace unit, and each of those units is comprised of civilian workers. And there's also portions of the laboratory that are made up of sworn or troopers that work for Crime Scene Services section as well as the Firearms Identification section.
Would you consider your role a civilian worker or are you a Massachusetts State Police trooper?
I'm a civilian worker.
You mentioned that one of the departments that you work in is the criminalist unit.
The criminalistics unit.
Could you give us a little more detail about what the unit does?
In the criminalistics unit, we examine items of evidence for the possible presence of biological fluids. We conduct trace identification, damage analysis, as well as gunshot residue collections on evidence.
Do different employees do different things in that unit, or do all the employees, are they trained to conduct all of those different type of testing?
There are specific types of analysis that only certain members of the unit will conduct based on the fact that those types of analysis are not requested very often.
Is the unit broken down by level of experience? Are there different roles within the unit based on experience?
Yes, there are.
Could you explain that, how it's broken down, the structure of it for us?
Generally, a training analyst will be a forensic scientist 1, which means they're in training and they're not performing any type of independent casework. Once an analyst is authorized to perform independent casework, they are then a forensic scientist 2. And that above them would be their supervisors, which are forensic scientists 3. And that is specific to the unit. And then as the chain of command goes up, there are additional levels as well.
Do you have a particular level that you've achieved?
Currently, I'm a forensic scientist 2 in the criminalistics unit and crime scene response unit.
In addition to your education and your master's degree, do you receive any specific training when you enter the unit?
Yes, every analyst will receive generally the same training when they enter the unit. It is written in our protocol, so it is standardized, and that is completed once they enter the unit. It takes approximately 9 to 12 months to complete that training.
Is there any ongoing training involved when you work in the criminals unit?
Yes, as a part of our accreditation, we also receive ongoing education yearly.
You mentioned accreditation. Can you briefly tell the jury what that means as it relates to the unit and the lab?
Accreditation is a voluntary quality assurance program that the laboratory is a part of. And basically their role is to ensure that our protocols, our procedures, our equipment, and our personnel are held to a certain level based in the scientific community.
In your role, do you do all of your testing at the office or in the lab?
As part of the crime scene response unit, I will respond to crime scenes and I will perform some testing and collection at crime scenes as well.
How long have you been involved in the crime scene response unit?
I've been involved with the crime scene response unit the same amount of time I've been in the criminalistics unit, which is approximately a total of 9 years.
As part of crime scene response, do you actively go to an ongoing developing scene, or do you arrive somewhere after the event?
It depends on the circumstances. Oftentimes we are called out to a scene directly after an incident takes place. There are times when we also will examine additional items or additional scenes after the fact.
How many scenes have you responded to as far as crime scene response where you were the person who was in charge?
I would say approximately 300.
When you are asked to or assigned to go to a scene, a crime scene, whether it's active or whether it's later in time, do you make an assessment when you get there, or is there a plan developed before you leave your office and get to the scene?
I'm sorry, can you be more specific?
Sure. How do you decide what you're going to do before you get there?
Generally, when I arrive on scene, I get a brief description of what they think may have occurred. Of course. I will take an overall sketch and diagram of the scene, and I'll also take some notes of the scene before I perform any type of testing or collection.
When you arrive at a scene and you start engaging in an analysis and determine whether you want to do testing, are you allowed to use your own independent judgment?
Yes, I use my training and experience to determine what items I would like to test and what items I would like to collect.
Is there ever any input by whatever law enforcement team or officer is at the response scene?
Yes, there is.
You mentioned that you've been to a number of crime scene responses. I want to ask you specifically about a response on February 2nd, 2022. Do you remember that?
May I check the date on that?
With the court's permission, please.
Yes, you can.
Thank you.
Gotta check the date.
So I responded to a crime scene on February 1st of 2022.
My apologies. Where did you go on February 1st, 2022?
I was dispatched to the Canton Police Station in their garage area.
That's a crime scene, you say?
Did anybody else from your lab go with you?
There was a crime scene services trooper that also responded at the same time, but there was no additional crime scene responder from my unit that responded.
Did you arrive at the Canton Police Department?
Yes, I did.
Is there a garage that you were directed to?
Yes, I was.
When you arrived at the garage, which sometimes may be referred to as a Sally Port area, were there any other people there when you arrived?
There were Massachusetts State Police troopers as well as some Canton police officers.
Did you know who they were?
I did know who the Massachusetts State Police trooper was, yes.
Okay. Was Michael Proctor there?
Yes, he was.
Was Trooper Dunn there?
Yes, he was.
Was Trooper Clark there?
Yes.
You mentioned Canton Police Department officers. Do you know Lieutenant Gallagher?
Yes, I did have an interaction with Lieutenant Gallagher as well.
When you got there, did you have a chance to look at an item?
Yes.
Tell us what your focus was on. What type of item?
I was asked to examine a black Lexus SUV.
And was there a black Lexus SUV?
Yes.
As you were observing and making, analyzing the item, did you see whether anybody was taking photographs?
Yes.
When there's a person taking photographs, do you ever have any input or direct them, or do they do that totally independent of you?
After they're done doing what they're required to do, I will ask them to take specific photographs because I do not perform that function at a crime scene.
When you first arrived, did you have a chance to walk around the vehicle?
Yes, I did.
Did you observe the vehicle from standing behind it, looking at the back of it?
Yes, I did.
May I approach, Your Honor?
Yes.
Alessi.
I'm handing you a document. Do you recognize that?
Mr. Alessi.
Yes, I do.
And what is it?
Handling this Hartnett.
This is the rear of the black Lexus SUV.
Does that photograph, does it appear to be substantially accurate to what you saw that day?
Yes, it is.
Is it a fair and accurate depiction of what you saw?
Yes.
May I approach again?
Yes.
I would move this into evidence, please.
Okay.
No objection, Your Honor.
Exhibit 138.
With the court's permission, I'd like to show P145.
Okay.
Ms. Hartnett, is that what you saw when you arrived?
Yes, it is.
Did anything stand out to you when you first looked at the back of that Lexus?
I noticed there was some damage to the rear passenger area of the vehicle.
Look at those bumper
Take
sprinkles.
that down, please. Did you have a chance to walk around and look at the vehicle from the driver's side of the vehicle, the left side?
Yes.
May I approach?
Yes.
Thank you, Mr. Brent.
Okay, I'm showing you a photograph. Do you recognize what's in that photograph?
Yes.
And what is it?
This is the driver's side of the Lexus.
Did the Lexus appear to you the same as it does in that photograph?
Yes.
Is that a fair and accurate depiction?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
Okay, thank you. Exhibit 139.
With the court's permission, I'd ask to show the jury P144.
Okay.
Could you describe what you saw, ma'am?
Yes, so this is the driver's side of the black Lexus.
Thank you. You can take that down. Did you get a closer look from the right side of the Lexus to pay detail or attention to what you described from the back view that stood out to you?
Are you referring to the damaged area?
I am.
Yes, so I did take notes of that area and as well as had additional photographs taken of that area.
May I approach, Your Honor?
Yes.
I'm showing you a photograph. Do you recognize it?
Yes.
What is it?
This is a close-up photograph of the rear passenger side tail light area.
Does that photo depict what you saw that day?
Yes, it does.
Is it a fair and accurate depiction?
Yes.
With the court's permission, I'd like to present as an exhibit.
No objection, Your Honor.
Thank you.
Exhibit 140?
May I show it to the jury, Your Honor?
Yes.
P161, please. Can you describe what you saw?
Yes, that is the rear passenger taillight of the vehicle.
Is that how it appeared when you first walked in that day?
Yes, it is.
You can take that down. Thank you. When you examine an item like a car, do you take any type of efforts to protect from contamination?
Yes.
What do you do?
Before processing or touching any item of evidence, I'll put on gloves. I use disposable instruments whenever possible, or if I need to use reusable instruments, I will spray them with a 10% bleach solution prior to use. I also change gloves often while I'm examining a vehicle and keep my notes and my pens that I'm writing my notes with. I don't put on gloves when I touch those, and then when I go back to examining the vehicle, I will then re-put on gloves to protect the evidence.
If you see something of note, something that stands out to you, do you have any way of marking the item?
Yes, I take diagrams at the scene and note on my diagrams anything of note. And as I had said, if there's anything that I also want close-up photographs, then I will request the crime scene services trooper who's assigned to crime scene to take those photographs.
Do you ever put any type of markers on the item itself?
Yes, generally I will mark the items with either a letter or a number so that I'm able to refer back to them both in my notes, and I'm able to refer to them when I look at the photos.
When you mark different items or observations that you make, do you give a specific number to each item for to memorialize it?
Yes, I either use a lettering system or a numbering system.
And how do you memorialize it? Do you put it in writing?
Yes.
What do you do?
On my diagram, I will refer to something, for example, as letter A, and then I'll also mark that item using a marker on the item of evidence with the same letter so that I can connect and associate the photograph with my notes and anything that I collect as well.
In addition to the broken taillight that we just looked at, did you make observation of any other things? And I'm just asking generally, not asking you to specify.
Yes.
Were there other things that stood out to you?
Yes.
Did you take any swabs to see if there was any biological evidence?
Yes, I did.
Where did you take swabs from as far as trace for blood?
I screened for blood on various areas of the undercarriage of the vehicle.
And what was the results?
Those were negative.
What does negative mean?
It means that there was no blood present in that area, or if there was, it was below the level of detection of our test.
Did you make any observations where you saw items or marks of interest?
Yes.
I want to ask you about any observations you made of the back bumper. Was there anything significant that you saw relative to the back bumper of that vehicle?
Yes.
And share with us what you saw.
There were scratches on the bumper as well as apparent pieces of glass on the bumper.
When you saw what you believe to be pieces of glass on the back bumper, what is the process you follow?
I gave those an identifying letter. I noted those items in my diagram, and then I eventually collected those items.
How do you collect them?
I would have used either disposable tweezers or tweezers that were cleaned with a 10% bleach solution.
After you collect the items, for example, glass on the back bumper, what do you do with that?
In that moment or later on?
Take us through from the moment you have it till the end.
So I would put those pieces of glass into a glassine envelope, which are then packaged in a large envelope. They are sealed and dated and initialed with my dates and initials. Eventually, when I return to the lab, those pieces are given an item number and then secured in our cold room.
Is each piece of evidence given a separate item number?
Yes.
As far as the entire case, your entire response, not the separate pieces of evidence you may find, is it assigned a particular number or a case number?
Yes, each case will get a larger case number, and then each item within that case gets an individual item number, so that item can be tracked throughout the lab.
Do you remember from your memory what the case number of this investigation as far as your response was?
Yes.
Could you share that with us?
The case number assigned to this in the laboratory information system was 22-2184.
I want to go back to the glass in the bumper. May I approach, Your Honor?
Yes.
Yes, let's go back to the bumper sprinkles.
I'm showing you a photograph. Do you recognize what's in that photograph?
Yes, I do.
Is that a fair and accurate depiction of what you saw that day?
Yes.
And could you generally describe what you see?
This is a close-up photograph of the apparent glass on the bumper of the vehicle.
Can we listen to evidence, please?
No objection, Your Honor.
Definitely not.
141?
Court permission, I'd like to show P167 to the jury.
Okay.
There are 2 pointers in front of you. Would you mind pointing out for the jury what stood out to you? And Ms. Gilman, could we get a little bit of a close-up on that bumper, please?
So I can see one of the, it's a little difficult to see, but I do see one of the larger pieces of apparent glass right here. Would it be better if I use this one?
Could you? Do you mind?
So this piece here is a larger apparent piece of glass. I think that was the largest one that I saw.
And those 2 white stickers, could you tell us what those are?
This sticker, this sticker here is marking where the apparent pieces of glass are.
Is there another sticker above, or is that?
I'm not sure. If you could close up, I'm not sure what that is. Yes, so that is another sticker, and next to that sticker are additional pieces of glass.
Those items to the right of that picture, are those pieces of glass?
Yes, I would say that's an apparent piece of glass here, and this one.
And could we just go down to the bottom part again, please? Thank you, Ms. Gilman. You can take that down. Did you collect what appeared to be items of glass?
Yes, I did.
Were they assigned a particular number?
Justified about what you did with
Do you
it.
know that number offhand?
I would have to refer to my notes.
With the court's permission?
Yes.
Thank you.
Please.
Those items were given the item number 3-3.
Did you focus on the right rear side of the vehicle beyond the broken taillight?
Yes.
Did you notice any damage, any scratches to the right quarter panel or the right side of that Lexus?
Yes, I did. I noticed some scratches as well as a dent in the rear door in that same area.
Let's start with the scratches first. When you notice scratches, is there a way you marked them?
Yes, I would have given them a letter.
And did you do that?
Yes.
May I approach, Your Honor?
Yes.
Showing you a photograph. Do you recognize that photograph?
Yes, I do.
Do you recognize what's in that photograph?
Yes.
What does it depict?
It is a close-up photograph of one of the scratches on the right rear area of the vehicle.
Is that a fair and accurate representation of what you saw that day?
Yes.
All right, move this into evidence, please.
No objection, Your Honor.
All right. Thank you.
Exhibit 142?
With the court's permission, I'd like to show the jury P172.
Okay.
Could we close up just a little more, Ms. Gilman? Thank you. Starting at the bottom, what is that, ma'am?
That is a close-up of the scratches that I noted in that area.
And could you zoom out again, please, Ms. Gilman? Is that on the back bumper or the right quarter panel?
I believe it's on the right bumper. It's a little difficult to make out in that photo.
Uh-huh.
Could you zoom in again and move up just a little higher,
We're
Ms. Gilman?
carefully trained
Thank you.
photographers.
Do you
Nevertheless,
have another
give us
sticker on the
this.
top?
Yes, I do.
Do you know what that is?
Yes, I do.
What is that?
That is an apparent hair that I noted in that area.
So that doesn't designate a scratch. That's something entirely separate and different.
That's something different, correct?
We'll get to that later. I just want to point out that it's not a scratch. Now, you mentioned that you saw a scratch. Was it a singular scratch or a number of scratches? Could you zoom in, please, Ms. Gilman?
It was a couple of scratches.
Is there a number you designate if it's not a physical item, if it's something like a scratch, or the designations just for actual physical items?
I use the designation for both observations as well as physical items.
Would there be a number for the scratches?
Yes, well, there's a letter, yes.
Do you know what that letter is?
Yes, I believe it's D.
D, okay, thank you. Take that down, please, Ms. Gilman. May I approach, Your Honor?
Yes.
I'm showing you another photograph. Do you recognize what's in that photograph?
Yes.
What is it?
That is damage that I noted on the rear trunk door of the vehicle.
Is that a fair and accurate depiction of what you saw?
Yes.
When you say damage, what type of damage did you notice?
There was some scratches as well as a dent.
I'd like to move this into evidence.
No objection, Your Honor.
Okay.
Thank you.
Exhibit 143.
With the court's permission, I'd like to show the jury P176. Can we zoom in just a little bit more, please? You told us that you saw both dent and scratches. Starting with the scratches with the pointer on the TV to your right, could you show us where you saw further scratches?
So the scratches are up above, and then down here there's chipped paint and a dent.
And where is the dent in relation to the scratches?
Just below it.
Could we zoom in a little more if we could, Ms. Gilman, please?
You're not going to be able to see. This is a terrible photo.
Can you see in this photograph the dent that you saw?
Yes, I was referring to this area here as a dent in my observations.
People don't know how to
Take that down,
photograph
please.
black, and they don't know how to photograph white. Even their specially trained photographers.
You mentioned a hair. I'm going to ask you some questions. How many pieces of hair did you find attached to that Lexus?
I found one apparent piece of hair on the Lexus.
Was there a designation number for the hair that you found?
Yes.
And do you remember what that number is?
I used the letter A for that particular item.
Did you say letter A, ma'am?
Yes, correct.
May I approach, Your Honor?
Yes.
I'm going to show you two photographs. You take a look at the first photograph, please. Do you recognize that picture?
Yes, I do.
And what's in that photograph?
This is a photograph of the apparent piece of hair I noted on the rear area.
Is that a fair and accurate depiction of what you saw that day?
Yes.
Turn to the second photograph, please. Do you recognize what's in that photograph?
Yes, I do.
What is it?
This is an additional photo of the apparent hair on the vehicle.
Both photographs of the same piece of hair?
Yes.
And the second photograph, is that a fair and accurate depiction of what you saw?
Yes.
I'd like to move these two photographs into evidence, please.
No objection, Your Honor.
Okay, is A and B, please.
144A and 144B.
With the court's permission, I'd like to show P173 to the jury.
Do they know how to
If we
photograph
could
a
get in
hair?
As close as possible, Ms. Gilman. Do you recognize what's in that photograph?
Yes, I do.
And can you share with us what you saw?
This is a close-up photo of the apparent piece of hair on the rear of the vehicle.
What did you do when you saw that, what you thought to be a piece of hair?
I marked it with the tape. I designated it as letter A, and then I asked the crime scene services trooper to take a photograph of it.
Did you try to preserve it in any way?
Yes, I did.
Tell us how you preserved that apparent piece of hair.
I collected that hair with either disposable tweezers or tweezers that had been bleached with a 10% bleach solution. I put them in a glassine envelope and then put them in a larger manila envelope. In a larger manila envelope.
What happens to that larger manila envelope?
It is returned back to the lab. It is submitted under the same case number and given its own individual item number.
Did you bring it personally back to the lab?
Yes, I did.
When you brought it back to the lab, do you remember where you brought it when you got back to the lab?
After it was entered into the computer system, I then sealed it, I initialed and dated it, and then I would transfer it to the crime scene response holding area in our cold storage room.
When you pass it along, is it to protect it in evidence, or is it for a purpose of further testing?
At that point, it's just to store it in evidence, and then it will make its way into whatever unit needs the piece of evidence first.
And you did all that with that piece of evidence?
Yes, I did.
I'd like to show the second photograph that you identified. I believe it's P165.
Okay.
Do you recognize that photo?
Yes, I do.
Okay, what do you recognize that to be?
That's an additional photo of the apparent piece of hair on the rear of the vehicle.
In the two different photos, are they taken from the exact same angle?
I believe they're taken from slightly different angles.
And the hair is, could you point that out with the pointer of the hair that you found?
Yes. This hair is the apparent hair.
Okay. Thank you. You can take that down, please. Regarding the damage to the broken taillight, did you have any interest in maintaining that piece of evidence?
Yes, I did.
What did you want to do?
I wanted to collect the entire taillight housing.
Why did you want to do that?
If there were pieces from the taillight that could be later matched to the taillight, I needed the entire housing to be processed at the lab.
Did you make efforts to try to maintain or remove or preserve that entire taillight housing?
Yes, I did.
What's a taillight housing?
Excuse me?
What is a taillight housing?
I'm referring to the entire piece, including the back, the glass covering, the light bulb inside. So it's in the entire unit.
Did you attempt to remove that entire unit yourself?
I did.
Were you successful?
No, I was not.
So what did you do?
A Canton police officer that was in the Sally Port at the time offered to help disconnect it with some tools that he had.
Have you ever seen whether there's video that memorialized that entire event?
Yes, there is.
And have you ever watched that video?
Yes, I did.
Does that video show you attempting to remove the housing and then receiving assistance from somebody?
Yes.
When that housing was removed, what happened to it?
I then placed it in a box, I believe I placed it in a paper bag in a box. And then once I brought it back to the lab, I added additional cushion with additional paper to protect it from any further damage.
Were you going to keep that housing, or were you going to put that in evidence for other reasons?
That was put into evidence storage for the time being.
May I approach, Your Honor?
Yes.
Showing you a photograph. Do you recognize what's in that photograph?
Yes, I do.
What is it?
This is a photograph I took of the taillight housing back at the laboratory upon examination.
Is that in substantially the same condition as when you saw it?
Yes.
Any differences whatsoever from when you saw it?
Not that I noticed, no.
Is that photograph fair and accurate of what you saw that day?
Yes.
All right, move this photograph into evidence.
No objection, Your Honor.
Okay.
Exhibit 145.
With the court's permission, I'd show photograph P187 to the jury, please.
Okay.
Could you tell us what that is?
That is a photo that I took of the taillight housing at the laboratory.
And that's after it's obviously removed from the vehicle.
Yes, that's correct.
And that was packaged and preserved?
Yes.
You could take that down, please. Do you have the actual item, the actual housing with you?
I believe it is here, yes.
With the court's permission, I'd ask the witness to be able to open the item, show it to the jury, and then I would move it into evidence.
Okay.
Thank you. If you would you please remove the item from that box?
Yes.
May I approach?
Yes.
So I wonder what she wasn't able to remove.
I brought gloves, yes.
Was she unable to remove a screw, or was she unable to disconnect a wire harness? Which one of the two was it? Not a whole lot of other things holding a taillight housing into the frame of the vehicle. Check that out. Open the box before you put the gloves on.
You could hold that so the jury can see it. If you could hold it up high, please. Thank you.
Hold it up high like Simba. Hold it up high.
Thank you very much. If you could return that to the box. I would move this item into evidence, please.
No objection, Your Honor.
That's the only item in that box?
There are additional items in that box as well.
I only want to introduce that one item.
Okay, so it's got the bag, you need to take that bag out.
There are also other items in that bag.
May I approach, Your Honor?
Yes.
Oh, boy.
Yes, why don't you join me? Actually, Paul, the lunch is here? All right, jurors, the lunch isn't here, so this seems like a good time to take a break.
Just like last time.
In about 50 minutes. Yeah,
Of course.
50 minutes will have us at 10:40 my time, 1:40 theirs. Oh, they got to sort out what's in the bag and what's not in the bag, just like they did with that little extra piece of taillight plastic that wasn't supposed to be in the bag that Connor Keefe was identifying on the stand. So what did they do? They just took it out of the bag, marked it for identification, and admitted the rest of the bag into evidence. Guess we'll be doing something like that again.
See what they're doing here.
Quiet, folks, still on the record. Thank you.
Yeah, they're observing.
Yes.
But now they're giving them privacy or something. Well, I guess we are at lunch now, officially. Oh, man. What's the other stuff in the bag? Does it even belong in the bag? It could belong in the bag. But she didn't describe putting anything else in the bag with the taillight housing. So why is other stuff in the bag? A little bit of an issue, isn't it? Good Lord. It's not a funny joke, guys. It really isn't. So tell me what you think. Is this a little bit of an own goal on the part of the Commonwealth? We didn't hear from Evan, Brent, or Zachary Clark during the first trial. Crime scene services guys. Is this a little bit of an own goal to highlight when you didn't? They got noise. When they didn't have crime scene services respond? Because that came out real crystal clear on Cross. You're there for very limited purposes at very limited times. But most of the time when they're out there at the crime scene, like for example, on January the 29th with CERT, you weren't there. You weren't called out for any of that. When all the rest of the taillight pieces are revealing themselves outside the front of 34 Fairview, you're not brought in to document any of that. I'm not sure that that was super smart, particularly when, Zachary Clark, what's he called in for? He's there to fingerprint, and you didn't find any. Okay. And you are apparently responsible for the digital photographs of that car, the ones that you don't know how to photograph black, although you've been specially trained. You don't know. You got to overexpose black slightly. You got to underexpose white slightly. And that's because if you're using your light monitor in a digital camera, it's all integrated now because people are rarely setting your own shutter sizes and f-stops and so forth, shutter speeds and all that. The light meter is taking an average, and it's assuming it's like taking an average of what is in the screen, and it is basically like targeting the midtone, the gray. It's looking for gray. So if everything, the majority of your screen is black, in your camera's light meter's mind, it's gray. So you need more light to be able to bring out the back than the light meter is going to feed into it. You have the opposite problem with snow. It's seeing a bunch of white. The phone is reading it as gray. And so you end up, you need less light for it to show detail, and you end up overexposing it. It blasts out. You don't get any detail. So that's what you got out of calling this guy, is that he took some photos that are going to come in anyway. I mean, she's authenticating photos taken at the crime scene that are not photos that she took, right? That's all you need to do to get crime photos in. Is there a true and accurate depiction of what it was that she saw at the time? You don't need the photographer to bring it in. So why exactly did this guy get called? I don't know. And all it seems to do to me is just really highlight stuff you don't necessarily want the jury to be thinking about. All the times the crime scene services didn't respond and didn't go and document the evidence like this. Also, now we're calling out Trooper Paul. Trooper Joe Paul was there, the accident reconstructionist. The jury's now heard that. Are they going to hear from Trooper Joe Paul, the accident reconstructionist? And if not, are they going to wonder why? Where is he in all of this? The same kind of approach that we saw from Mr. Brennan the other day with Trooper Bukhenik, where it's like the trial equivalent of a discovery dump. We're just going to dump a bunch of stuff on the jury. We're not going to actually show them. We're not going to bring any of it to their attention or tie it together with our theory in any way. We're just going to dump a disc of crime scene photos on the jury and then not show them. It's just very irresponsible, I think, because if it doesn't matter to your case, you shouldn't admit it. And if it does matter to the case, you should be showing the jury why it matters to your case. It's not your job to dump stuff on the jury and expect them to sort it out for you. If it matters, present it, and they'll see that. If it doesn't matter, don't put it in. But we saw that with the video stuff with Trooper Bukhenik. And my theory at the time, well, they're trying to bury the jury in discs of video so that they don't know what is what. Because none of those were shown. They were just put into evidence. The videos that we saw were the Sally Port, the inverted Sally Port video, the apparating people, so forth. Dumped a bunch of discs on the jury. Why? I mean, who knows? We were given no explanation as to why any of that mattered or what it showed or anything. So similar approach here. Let's just dump a disk of crime scene photos on them, but not even show them. Very tailored cross by Mr. Yanetti. Of course, he's not going to be allowed to get into Michael Proctor's misconduct or Kevin Albert's misconduct. That was cut off and sustained. But what does this emphasize? It emphasizes he doesn't know anything about who had access to the vehicle before he shows up on February the 1st. Emphasizes that the interview of Colin Albert took place a year and a half after the origination of the case, that Michael Proctor is the one who wrote the report, chose the language, and of course wasn't called out for any of these other searches, recoveries, etc. of evidence. Evan Brent, very similarly. Okay, you met a bunch of people on February the 3rd. We dumped a disk of crime scene photos, but didn't show anything except photos of the Chevy Traverse. Guys, is this a little bit of an own goal? On February 3rd, you're interested in John's Chevy Traverse. Why is that? Particularly that close-up you took of the driver's side rear quarter panel. Why so interested in this part of John's car? John's car has nothing to do with this incident, as far as you know. This is a little bit of an own goal. Maybe kind of give away the fact that they saw Karen hit his car on the Ring video. Is that maybe a logical inference from the evidence? Why else are they interested in his Traverse? Certainly haven't given any explanation. They saw it on the Ring video, guys. That's why they were interested in it in February 3rd, 5 days after it happened, long before. Trooper Bukhenik's trying to pretend like, almost the first time he saw that video. Now, he saw it at the trial before, the earlier proceeding. You remember seeing it? Seeing the tire move? Trying to pretend like that was news to them? No idea until Karen brought it up? No, then why were you looking at John's car on February the 3rd? That is a problem. That is a problem with the Ring footage. Where were the items found? Some of them were on top of snow, according to Trooper Evan Brent. Some of the items that they found were on top of snow. Because he explains as the significantly warmer, then it was raining on February the 3rd. So the snow had melted. It was the items were revealing themselves on top of snow because they shouldn't be on top of snow at all. Every single piece of evidence should be at ground level. But we're just going to dump the photos on the jury, not show them any, not tie it to our theory of the case, just dump it on them. That's we're back into classic Lally case presentation. Once again, just David Yanetti set that up. He understood that immediately, didn't he? So it was just 5 days after January the 29th when you were interested in that Traverse. Yeah, just 5 days later. Long before Karen Reed brings it up in court. Long before then. They already knew. They had already watched the Ring camera video. They already knew. Oh, that is not helpful information for them. Emphasizes that the crime scene wasn't secured, had no idea how the items got there, who had access to the lawn. There was no guard. There was no crime scene tape. There was nothing. Oh, and he knew Michael Proctor was the lead investigator. He didn't get the memo on the case officer. Yeah, he knew he was lead, and he wrote the report, and he didn't go back on any of the other days. Brian Gallerani, the guy from Needham who came in and swabbed Proctor and Bukhenik, did the swabs to collect their DNA. What did we emphasize? Oh, the other people with access to the taillight, the other, potential conspirators, Berkowitz, Kevin Albert, Tully, they're not swabbed. They're not swabbed. And now finally going into Maureen Hartnett. Maureen Hartnett is going to take a while, and she's going to be slow and boring. A lot of this stuff, it can be a little bit dry when you get into the technical testimony, but it is rather important. So we know she didn't take any of the photographs. This is all Clark. Or no, not Clark. This is Brent. This is Brent who was there on February the 1st. No, it was Clark. These are all Clark's photos. And so what do we know? There's no blood. No blood under the undercarriage. Swabbed it. Nothing. I imagine we'll follow up on Cross about the rest of the car. Obviously, visibly, there's none. But did you do anything to check that out other than just use your eyeballs? Are your eyeballs enough for that purpose? I mean, I would think they are. You could probably spot a little bit of dried blood on a, mirror polished enamel automotive paint surface. Uses that 10% bleach to sterilize. That is a strong bleach. That's like what you put in the swimming pool. Typically a little stronger than what you buy in the over-the-counter cleaner, like your home cleaning bleach. More like 1.5%. So what do we have? With the bumper sprinkles now have made their appearance. Item number 3-3. Oh, I wrote that down. Yes, I will, because that will be followed up on. The bumper sprinkles were item 3-3. There's some scratches on the back of the car that she noted, and the apparent hair. The apparent hair. Apparently there is a dent, but I don't know about you guys. I could not see a dent in that photograph because somebody does not know how to photograph a black object. So there's no depth to the photo. It's just lack of detail. There's video of all this happening. Huh, no kidding. Sally Port video from February the 1st of 2022. You don't say. Wonder where that came from. Wonder who had it. Wonder when it was downloaded. Wonder where it's been kept. Wonder when it was handed over to the defense. Is it Sally Port? Did somebody record it on their phone? Who knows? And then we have the taillight housing in a bag with other items that, from her description, are not supposed to be there. Her description, she put the taillight, the whole taillight housing in a bag, in a box, put it into evidence. Now there's other stuff in the bag. What is it? Why is it there? Your guess is as good as mine. But I suspect they're going to solve this problem the same way they did when there was plastic that didn't belong in the evidence bag Connor Keefe was opening up. Well, just take that out, put it over here, and put what's supposed to be there into evidence. What a mess. This is why you have evidence logs of things. This is why you have evidence handling procedures. It's just a little bit ridiculous, guys. Oh, I am going to have to run out and handle the trees. We have had a very windy morning here, so I am expecting they're going to be very thirsty. So I'm going to take my my little morning break a little bit early right now. After the recap, when I get back, we'll come back to your questions and comments. But in the meantime, thank you very much for hanging tight, and I will be back shortly. All right, guys, we are back. Thank you so much for your patience. It was indeed a very dry scene out there with the trees. Dry as the entire world, listening to Brian Higgins's text game. So it took me a minute to get everybody nice and restored to where they need to be with all that. But we're back. Appreciate your patience. Still have a few minutes left, I'm sure, before court comes back. We're going back to the NBC 10 feed, which has been restored. Don't know what that glitch was this morning, but it's the one I usually rely on. So we'll go ahead and go back to it. In the meantime, let's see what you guys have been thinking. Oh, we were looking at this right as court came into session. So it was Jen McCabe who says that the Jeep is parked outside. That's the only person who has identified it so far. And we were talking about his cell is not available because he, did that bizarre disposal routine with it. But they could potentially get some location information from his call detail records from the phone company. We don't know if anybody has done that. And we also don't know if it would reveal the level of detail that you'd need to get detailed movements because the Canton Police Department is not really very far from 34 Fairview. So don't really know if it would register that movement or not. So we don't know. Ag 4981, murder charge with undetermined death normal? I mean, normal, no. Definitely not normal. I mean, undetermined in general is not that common. It's not really that common. And I think there was a chatter who pointed out a few days ago that normally when that's the case, it's because you found very old remains. There's just not a lot left, that you can draw clues from. And so you can't rule out, was there some type of foul play? Did somebody wander away and fall into a secluded area and just not be discovered for a long period of time? That's most often when you see it. Don't often see undetermined in a situation like this. And, I pointed out that what I consider a little bit bizarre about this situation is whether you think it might be a fist fight or whether you think it might be a car accident, either of those would be a homicide. So you don't have to buy the Commonwealth's theory for this to be a homicide. So the fact that she didn't rule it a homicide suggests that she must have had difficulty ruling out some other manner of death. And the likely one, I guess, is probably accident. I mean, nobody thinks this is natural causes. That it was an accident. Is it possible he slipped and cracked his head? That seems to be the question. But no, it's not very common to see undetermined manners of death at all, let alone in a murder prosecution. Kells Bells, wonder if after all the corruption and incompetence by Yuri Bukhenik testimony, Hank Brennan wants to change focus on victims. Could be, explaining the shift to why did we hear from the niece this morning? Now we're shifting, of course, back to law enforcement. And I don't know that that's going very well. So maybe he needed to, fortify the jury to get him ready for this. Get them on side before stuff that is not particularly helpful starts to come in. Oh, I'm looking forward to this Alessi Cross of Maureen Hartnett. We may not honestly get to it today. I mean, when I tell you guys her testimony is probably going to take a long time, it's probably going to take a long time because she did a lot. She was the one, as I recall, that went back and did the whole reconstruction. Is she the one that did? No, she wasn't. It was Ashley Vallier. That will save us time. That should save us time. She's not actually the one who put the taillight pieces back together. But nevertheless, she did a lot of the forensic collection and screening and so forth. So may take some time, but we'll get an Alessi Cross. I'm looking forward to that. Mommy's baby pumpkin. Do you think baby Brennan will show out and throw fits in front of jury while cross-examining Dr. Russell Arca, considering how bad he's treated them before? Oh no, I laid my marker down back when it happened, back when we had that Arca voir dire. I laid my marker down. He will not present like that in front of the jury at all. At all. He knows it's a bad look. He knows it's an asshole move. He just knows that Bev won't care. You know, she won't hold it against him, and she's kind of, you know, got his back on his interpretation of the case and the law in many respects anyway. So yeah, he's gonna sit up there and throw out those accusations against them and be rude and belittling and snide, while simultaneously suggesting that for the defense to cross-examine Jessica Hyde about a previous finding of unreliability is dehumanizing her, maligning her. My goodness, the horror. The horror. Where would you get such an idea? Oh, I don't know. Maybe we watched the Arca voir dire. Maybe that's what we know what that looks like. No, I think he's going to be very, very different in how he presents in front of the jury, because they're going to come across well. They did the first time, they will this time, and you coming out and being an asshole to them, it's not going to get you the points you think you want. Disney Gal, have you seen the pic of BH hand from the Canton cam? Right hand red and appears swollen. I did see this. A couple of folks went in and, like, you know, close, just kind of blew up that CCTV footage. Guys, could it be? Yes, it could be, but I'll just kind of take you back to the conversation we had yesterday about all the questions swirling around this footage anyway, and what does it show, what doesn't it show? And the reality is that footage is often not particularly good evidence, especially this CCTV, this security camera. It's not meant to capture like HD level detail. It's not really what it's for. It's often in low light conditions or just bad light conditions. You got this flat overhead light, the fluorescent lighting, not particularly conducive to good quality. I mean, even in the parking lot, we see Brian Higgins's sweatshirt. It looks white because of the lighting conditions and the environment and the camera quality that we're dealing with. So I personally very hesitant to put much weight on really most of the video evidence at this point. It's all low quality, low light, easy to just project what you think or believe or want to see onto these images. So I have seen that, but I don't personally put a lot to it, because I just don't think that the CCTV is high quality enough to be able to draw an inference from it. Other folks can disagree, but that's my thought about it. V. Grave, read death penalty. I'm against the death penalty and thinking about it for Koberger. I think it's fundamentally unfair to select jurors who are pro-death penalty. Are pro-death penalty jurors more likely to convict? Yes, they are. And this has been confirmed in study after study after study. When you have the death penalty in a trial, you have to death qualify the jury, meaning a juror who is not willing to consider imposing the death penalty, who wouldn't be willing to do it under any circumstance, they're not qualified to serve. So you only get people on the jury who are like, yeah, sure, I'm totally fine with putting somebody to death. And it does. It changes the dynamic, potentially, sometimes significantly, to have that death qualification. And there has been quite a lot of scholarship on this. Can change their view of different kinds of evidence, what they pay attention to, what they don't pay attention to. Pro death penalty juries, by and large, are going to be more likely to convict. Yes. Steve F. Defense should call Proctor and Higgins, but should they call Brian Albert? He is malevolent and much slicker than Bukhenik. Do you call him and strip his bark off, or avoid risk and keep him out? Brian Higgins sure has been an invisible part of this trial, hasn't he? He's like really kind of slipped beneath the radar, and that it's a dramatic difference from the first trial where he was, one of the people that the finger is being pointed directly at. Great interest in Brian Albert and his version of events, his explanations, and so forth. In this trial, we've hardly heard him. The key players really been Proctor and McCabe. That's who the Commonwealth seems to be bringing kind of front and center in this trial, as far as who represents everyone inside 34 Fairview and who represents the investigation. I feel like we've hardly even heard Brian Albert's name this time. They have to bring him in, I would suspect, if they're going to bring in any of the suspicious circumstances involving him, like his butt dials with Brian Higgins. Anything that's from his phone records, they're probably going to have to bring it. They're probably going to have to call him if they want that to come in. The fact that there was a 222 call, pretty sure it was Brian Albert to Brian Higgins first. And then, no answer. It lasted like a second or 2 seconds or something like that. Then an immediate call back seconds later from Brian Higgins to Brian Albert. And they had that, was it 22-second phone call? Maybe it was less than that. I don't remember the specifics off the top of my head right now, but the butt dial, as Brian Albert explained it, during the intimate moments with his wife, nonetheless. The butt dial to Brian Higgins, the butt answer, and then the butt call back, and then the butt call, and then the butt hang-ups. I think they got to call him if they want that in. But yeah, he is slicker. He is slicker than Bukhenik, no question about that. So, do you have other reasons to call him? It's not clear to me that the defense really considers it necessary either, because this trial is not about confronting who was there and pointing the finger at them as the ones who did it. It's much more focused on the investigation and the questions you didn't ask. And so if we want to highlight the questions you didn't ask, we don't put Brian Albert on the stand to ask him those questions. We just go ahead and stick with what the investigation didn't do and didn't pursue. So I think they might have to, if they want to get the butt dials and stuff in. They can get some of it with Brian Higgins, but I don't think they can get the full picture in with Brian Higgins. So then if you have to call him anyway, do you get into some of those details? Well, yeah, you might, because you might be able to pin him down to some of the issues we've already identified, like the white Jeep. What's his position on the white Jeep? He's the one during the first trial. He does acknowledge Chloe being in the house, and he explains one of the very first things he did when he got home was take Chloe out, take her out to the backyard to do her business, because I guess Brian Jr. hadn't let her out while he had his friends over for the birthday or whatever. Maybe he didn't know if Brian Jr. had let her out. So that was documenting Chloe's presence, which could potentially be an important part of the defense case, but also it's an opportunity when something could have happened that would cause dog bites to John O'Keefe's arm at 34 Fairview, sometime between the time when he left the waterfall and when he's found on the corner the next day. Something, there's an opportunity there for some interaction. Maybe it's malevolent, maybe it's just inadvertent, but it's an alternative explanation for what ultimately happened to John that they didn't ask questions about. The investigation didn't didn't pursue, didn't follow up on that. John's got dog bites on his arm, but we're just going to pretend we don't see any of that. We're going to act like that's perfectly normal car accident injuries. Barely a bruise on the man's body, but that chewed up arm, that's what clued us in that we needed to look at Karen's car. That's where they're going with it. So, I mean, I think you do. Yeah. To answer your question, I think you do. You might keep it a little bit more targeted, a little narrower than you would for just an ordinary direct examination. Probably narrower than what Mr. Lally did with him in the first trial. Have him just narrate the whole day from starting off at that funeral of the fallen officer in New York. Might drop in the drinking at the hillside with Brian Higgins before they ever got to the waterfall. Chloe at home, the butt dials, and then potentially some of the sus activity after the fact, the group chats. If there's more of the group chats we can get into. You're a detective, so what are you doing at Jen McCabe's house? You don't really ask those questions, though. You make sure that the facts are in evidence, but those facts are already in evidence. The jury already knows Brian Albert, the Boston police officer. I'm not sure if they know he's a detective. Don't remember if that specifically has come out, but he's at Jen McCabe's home later in the morning. Follows her back, seemingly there while the interviews are taking place, and having all these group chats where they're cluing each other in about what's going on. Then, of course, they're getting rid of his phone. His explanation, he just upgraded it. He just upgraded his phone. It was for his birthday, but it was a month after his birthday, but it was for his birthday. Yeah, issues with some of that. So yeah, I think you do. I just think you have a plan. You treat it like a cross, even if it's not. You know what you're getting at. You get in, you get out, and then let Mr. Brennan just deal with your scope of what you've established and not open the door wide open to whatever he wants to say about January 28th, 29th, the subsequent investigation, and so forth. Wicked Rose, Mandela effect at work. So much time had gone by. Is this? I might have missed when this came up. I might be referring to a specific event. If so, sorry I missed that. But yeah, Mandela effect. Just sometimes not mentioning stuff is better. Don't look at this just means everybody's going to want to go look at it. Oh wait, no, God, that's Streisand effect. I've got it all backwards in my mind. So now I'm not even quite sure what I'm asking. Hang on a sec. I got something weird going on my computer. One of those things where they spam you to try to get you to download some security software, as if their security software isn't some virus they're trying to get you to download. Anyway, it doesn't want to come off my screen. Okay. The Mandela effect. Had to remind myself, a phenomenon where a large number of people collectively misremember facts, events, or details. It's named after a widely held but false memory that Nelson Mandela died in prison in the 1980s when he actually died in 2013. Oh yeah, he got freed after quite a long time, 30 years, 40 years, 50 years. I mean, a long time. I forget exactly how long, but yeah, he was released and then died after. I didn't realize a lot of people thought he had died in the 80s. So the name for a large collective false belief makes sense. Makes sense. People just tend to come together. We've talked about memories a lot of times, a lot of different times on this channel. Memory is not a video recorder. Even if it were, And look at what we're dealing with video recorders, not necessarily that great anyway. You can project all kinds of stuff onto them, and memory is a rewriting process. It's not a passively taking in stuff as it's presented. There are processes affecting perception, judgment, storage, and all this stuff that goes into memory. So memories can be a lot more flexible than we would like to think. And if we are surrounded by people who have influence over us and information is shared, or even just emotions are shared, it can change. As you're thinking back over my time with this person, perhaps, what at the time was good might be recolored in a different environment. Amy G, according to the prosecution, Karen Reed must have said, "I hit him 30 separate times, yet everyone on scene only heard her say it 3 times each. Peculiar. Didn't somebody just get excited and turn it into 4? Katie McLaughlin turned it into 4. Oh, man. Timothy Nuttall had first testified only twice, but then in his enthusiasm in this trial, he grew it into 3. They brought that up on cross-examination. Katie McLaughlin had originated the 3, but now with this trial, it's 4 now. Guys, they're so enthusiastic about I hit him that it just continues to grow in their memories. And that's the best case scenario. The best case scenario here, I think, is confabulation. I really do think Timothy Nuttall, he does. He comes across to me as like a case study in confabulation. He's so earnest. He really believes it. He's a true believer. And I hit him. And he didn't learn the first trial that the vividness of his memory does not correspond with its accuracy, because he had that vivid memory of the puffy coat on John and having to work it over John's stiff, cold fingers and having difficulty doing that, getting the puffy coat off. Very vivid memory he had, and none of it happened. Not a single bit of it happened. But he didn't learn from that. This time he had a very vivid memory of the I hit him. And it didn't happen. Didn't happen when he described it as he described it. You can see on the video. And Matthew Kelly is if he gets called, presumably by the defense, and testifies consistently with the first trial, didn't happen. He didn't hear it. Did not happen. However, Mr. Nuttall thought he did. But he really believes in it. He believes in it so much that it keeps growing. Keeps growing with the telling. Aaron White, Haas long before everyone here hits the like button. Well, as long as they need, it's okay. Do what you feel like doing. If you feel like acknowledging the stream, that will be appreciated, but certainly not necessary to be here. Maggie Beth, Peggy expected Karen to babysit 3 children. Yeah, who was it treating Karen as the babysitter with benefits? Exactly. Yeah. How dare you, drop him off at a party? Was she supposed to babysit him too? I don't understand the expectations there, but it doesn't look like a very pleasant relationship. One where you can do no wrong. She's complaining about John setting her up to fail. Where might John have learned that from? A lot of questions about that. Motions and Lemonade. I love listening to you. I love your big brain. Thanks for the hard work. Well, thank you for that. I like being able to share ideas and stuff. You guys have wonderful ideas. A lot of ideas. Second time we've watched this case, watched a lot of the details. And you guys in the chat, you're often still coming up with stuff I've never thought of before. Stuff I've just never even crossed my mind as some of the theories of this case. So it is a group effort, and I appreciate that from all of you guys as well. Katina, I have the hardest time understanding Peg O'Keefe. Of all people, wouldn't she want to know the truth? Was it too tempting to blame the girl not good enough? My impression is that it was very easy to sell Peggy O'Keefe on Karen did it. She already doesn't like Karen. She's already inclined potentially to think that whatever happened that morning was Karen's fault, even if Karen didn't actually do it. How could you just drop, just dropped him off? Like that's her fault? If you just dropped him off and he's going to a party and he's leaving the party and there's a serial killer on the street who just happens to coincide with the timing of John coming out of the house and the guy whacks John. Is that Karen's fault because she dropped him off at the party? You kind of get the impression that's how she'd see it, don't you? I do. You just left him there? Yeah, he's a grown-ass man in his 40s. Yeah, I left him there. So I think she was already primed to accept that, and then it's kind of what she wanted to believe. So very easy to sell her on it, and very easy to get her to hang on to that with an iron grip. It's what she wants to believe, that it's Karen's fault. Very, very early on in this case, we talked about the patterns, domestic violence. That's what this case is alleged to be. A toxic relationship at best. Those things tend to be learned from the people that you see in bonded relationships. You learn how to be in a romantic attachment based on what you observe. If John is setting Karen up to fail, John is, in this withholding of affection type of attitude towards the relationship. They have a fight and he's just they argue about something. He's like, okay, I'm out. Not going to talk about it. You do what you need to do, Karen. I said I'm sorry. I don't know what else you want. Very just dismissive of her and her entitlement to have her own feelings and experiences that you as a caring partner, normally you care about that type of thing. But devaluing her, he learned that from somewhere. Devalue your partner? Where might he have learned that from? Maybe the woman who got up on the stand and devalued her husband in front of the entire world? John's had this pattern of shallow relationships that don't last. Where did he learn that from?
Questions and attempting to introduce the taillight
An easy
housing.
setup.
Do you remember that?
Yes,
And you mentioned there were a number of items in that bag.
that's correct.
And during that break, did we have a chance to look inside the bag,
Yes,
accompanied by counsel for the defense?
yes.
When
We looked inside
items
the
are
bag.
stored in a
We
bag,
fixed it.
is it common for them to be transferred to other locations other than your evidence locker?
I'm sorry, can you rephrase that information?
When
that
you
question?
store a piece of evidence in an evidence bag and you put it in the evidence locker for safekeeping, does the evidence sometimes travel to other places?
Yes,
If it's tested for other types of information, maybe DNA or biological fluids, can that item be transferred to another department?
yes,
Is sometimes that item brought back and forth to court for other proceedings?
yes.
And do you know if this item has been on different travels over time?
I do know that it went into several different units within the laboratory, yes.
When you opened up the bag and you said the housing was in that bag, the other items that were in the bag, do you know when they were put in there?
No, I do not.
Do they appear to be pieces that are consistent with the taillight housing?
I can't testify to whether or not they're consistent.
Okay. When you saw the pieces, do you know whether or not any of the pieces broke off that taillight housing?
I do not know.
The taillight housing, did it have any loose pieces when you first retrieved it from the Canton Police Department?
No, it did not. It had missing pieces, but nothing was loose on the taillight housing itself at the time that I collected it.
And the loose pieces on the bottom of that bag, they were in the bag when you opened it this morning?
Yes, that's correct.
The loose pieces, last time you had an opportunity to open that bag was how long ago?
The only time I opened that, the packaging for the taillight housing was in the laboratory when I first examined it in 2023.
And do you have any indication this has passed many hands or hands since then?
I do know that that item went to the trace unit after I examined it.
Those loose pieces in the bottom of the bag, I'm going to ask you to keep them with the taillight housing.
Okay.
And I'm going to move that piece of evidence. Evidence, I may have one moment.
Okay.
How's that work?
Okay.
Don't know what they are. Can't say they're consistent. Nothing wrong with the housing when I took it.
One
Same
last
explanation they
question.
tried to give with the plastic. It's
When
broken.
a bag is opened by somebody who's examining it, if there are small loose pieces accompanying the item, is it ever packaged in separate baggies or containers?
In the criminalistics unit, so I can only speak for myself and my individual examination, if there are loose items within the item that's packaged with it, I would separate it and potentially separate into a smaller package and put it inside the larger container so that it doesn't get lost.
In addition to the loose pieces in the bottom of that bag, do you see separate small containers of packaging of smaller pieces?
Yes, there were 2 smaller containers within that larger bag.
And those smaller packages that are separate from the actual larger item, did you put smaller pieces in those small bags?
I did not do that.
It's done by somebody other than you.
At some point, yes.
Okay. I now move to introduce that into evidence.
No objection, subject to the explanation and cross-examination, Your Honor.
Okay.
Could you present that?
Yes.
She already did, didn't she? Or is she going to show us all the other little pieces now too? Ones that have no chain of custody?
So I didn't even display it, I think just provide first to a mark.
The whole bag?
Yes. And you can keep the gloves on, I just want to be able to show the small.
Oh, okay, that's fine, I was going to be here.
After it's marked.
Sure.
No, put some new ones on.
You've already showed us the housing. Can you show us some of the small pieces in the bottom of the bag and also the small separate packaging that you did not package?
Yes.
Thank you.
Show us the unknown stuff, please. The mystery items that evaporated inside the bag.
Could you explain what those are?
These are 2 small glassine envelopes that were in the container.
Any markings on those envelopes?
Yes. Would you like me to read them?
Please.
Okay. Some of it is illegible to me. I didn't write it.
Helpful.
Oh, I'm sorry. It appears to be at least the second half of the case number. It's possible that's the 2202184.
Even read the case number.
Pieces E, G, I'm not sure if it's an M or an H, I, S, K. This also has a case number 22-02184, 3-1, assorted small pieces.
Thank you. And was there any pieces that weren't packaged other than the housing in that bag?
Yes.
And could you show us, please?
Got a Solo cup in there.
This item was also located in the bag.
A big ass piece of plastic.
And these 2 items were also located in the bag.
Huh. No kidding.
Thank you very much. May I approach?
Yes.
I'll take that.
Thank you.
When you brought the taillight housing back to the lab, did you take it out of the bag and do anything with it?
Yes, during my examination, I did remove it from the bag to look at it.
When you, after you looked at it or during your observations, did you take any samples from it?
Yes, I did.
Explain to us what you did.
I took a polyester swab. I moistened it with sterile water, and then I applied that swab to the external front areas of the taillight.
Why did you do that?
My goal was to collect any potential biological material that was present on the exterior of the taillight.
Did you engage in that procedure pursuant to your training and experience?
Yes, I did.
If we could have former P-187 back on the screen, which is now an exhibit. Could you use the pointer and the television to your right? Could you show us or show the jury where you took a swab, what areas?
Yes.
Thank you.
So I took my collection from this upper right-hand corner, the red apparent plastic, as well from this area down here, another piece of red plastic, and then these clear apparent plastic here on the front of the taillight housing. Basically any areas that would have been exposed when the taillight was intact.
Why do you take the swab and go to multiple different parts of an item?
The goal of this collection was just to determine if there's any biological material in that area. And there's no forensic relevance really to if it came from the upper right or the lower left. I took that collection as a whole. And in addition, there was a very small surface area to begin with.
When you took the swab, did you run it along the breaks in the red part?
Like the edges here?
Yes, the edges.
It's possible, yes, that I collected from those edges.
Do you have a memory of what parts you actually swabbed?
I remember swabbing the external areas of the taillight, those that would have been on the outside prior to any damage being done.
Okay, thank you. You can take that down, please. After you engage in the procedure of taking a swab, what do you do to preserve that swab?
That swab is air dried. It's then repackaged in a small glassine envelope. A portion of the swab is also put in a clear plastic tube, which is sent forward to the DNA unit.
Did you do that?
Yes, I did.
Why do you go through that type of procedure? Why do you take that many steps?
I'm sorry, may I correct my answer from the last question?
Please.
My apologies. So in this particular instance, the entire swab was cut up and put into plastic tubes for further testing.
Why did you do it that way?
This item was quantity limited. The swab itself was quantity limited, meaning that they'd have to use up the whole swab in order to run DNA analysis.
Did you do DNA analysis on the swab?
No, I did not.
Why not?
I don't work in the DNA unit, so that is the job of a different analyst.
And at some point, did you take that item that had been preserved and put it into evidence?
Yes, I did.
Were you shown a bag full of red plastic cups with an item in it when you were at the Canton Police Department?
Yeah, were you?
Yes, I was.
Could we have Exhibit 56, please? Thank you. This is a photograph that's been marked as an exhibit. Do you recognize what's in that exhibit?
Yes, I do.
And what is it?
Those are 6 red plastic cups that contained frozen red-brown stains.
Did you do anything relative to the content of those cups?
I took a collection from one of the cups using 2 sterile cotton swabs.
Can you just briefly explain what that process entails?
Yes. I allowed the frozen red-brown stains to thaw. I applied sterile water to 2 cotton swabs, and then I applied it to one of the red-brown stained cups to collect the material from inside.
How do you preserve and maintain the integrity of whatever sample you collect?
That sample is then entered into a glassine envelope, a large aluminum envelope. It is then sealed with my initials and date. It is given an independent item number and stored within the proper unit within the lab.
Allowed to thaw,
Take
you
that down.
say?
Thank you.
Allowed to thaw? How long did that
At
take?
some point, did you look at clothing?
Yes, I
Since
did.
when were they
Where
frozen?
did you look at clothing?
I examined the clothing from this case at the Massachusetts State Police Crime Laboratory.
Was the items brought to the crime laboratory?
Yes, they were.
Did you have a chance to unpackage them?
Yes, I did.
When you received them, how were they stored?
They were stored in brown paper bags and potentially boxes. I don't remember off the top of my head.
And did you look at a number of different items of clothing?
Were they
Yes, I did.
sealed in plastic?
And approach, Your Honor?
Were they mounted on plexiglass?
I'm going to show you a series of 4 photographs. I'm going to ask you about each one of them individually. You recognize the first photograph?
Yes, I do.
What is it?
This is a photograph I took of a gray sweatshirt.
Does that photograph accurately depict the sweatshirt as it appeared to you when you looked at it?
Yes, it does.
Can you look at the second photograph, please? Do you recognize what's in that photograph?
Yes, I do.
What is it?
This is an additional photograph of the front of the gray sweatshirt where I had put some markings on the sweatshirt.
Why did you put markings on the sweatshirt?
These markings specifically are noting areas of damage.
Third photograph, please. Do you recognize what's in that photograph?
Yes, I do.
And what's in that photograph?
This is a close-up photo of the area of damage that I denoted as 1.
And a fourth photograph, please. Do you recognize that photograph?
Yes, I do.
What is it?
This is a close-up of area damage 1.
Is that a fair and accurate depiction of what you saw that day when you examined this particular item?
Yes.
All right, move these 4 photographs into evidence.
I could just see them quickly.
Do we think Alessi knows what each and every photograph that she took at the crime lab is?
No objection, Your Honor.
He does.
So let's mark them 1 exhibit A, B, C, D, please.
Exhibit 147, A, B, C, and D.
Thank you. With the court's permission, could we please show former P190 to the jury?
Yes.
Is that one of the photographs you just recognized?
Yes, it is.
And could you explain to us what you see?
This is the exterior front of the gray sweatshirt. There is linear damage between the top and bottom of the sweatshirt, as well as linear damage across each sleeve of the sweatshirt.
Do you see the cut down the front of that sweatshirt?
Yes.
Did you distinguish that cut as any different than the damage on the arm?
I did not do any damage analysis on that particular area of damage.
Why not?
Typically in these type of events, you'll see those types of damage associated with clothing being removed from emergency medical technicians, so they're not forensically relevant.
Thank you. If we could turn now to former P194. Is this the same sweatshirt?
Yes, it is.
And there's a little bit difference, is markings or tabs on it?
Yes, that's correct.
What are you doing there?
I put tabs on each of the areas of damage on the sleeve and 2 on the chest that I was going to examine further.
When you put the tabs on, do you write a report or mark it in any way to memorialize it in case the tabs fall off?
Yes, in this case, they were marked tabs 1 through 9. Those are not permanent on the sweatshirt. They're actually just pieces of filter paper that I used to mark it.
Could we, Ms. Gilman, zoom in on that right arm, please? Thank you, sir. Thank you very much. What is written on those tabs?
Each tab has a number on it that corresponds with an area of damage that I examined.
And when you write a report, when you memorialize it, is that keep an accounting of each?
Yes, that's correct.
If we could turn now to form a
I didn't get the
P196,
full number,
which
but
is
it's
147C. What is that
somewhere in the
depict, ma'am?
ballpark of 10.
That is a close-up of the area of damage 1 that I did further examination on.
Could we zoom in a little bit on the, that's the circle part.
Like a puncture and then a
Is
pole?
that a fair and accurate depiction of what it looked like when you examined it?
Yes, it is.
And finally, if we could have P197, which
Not a
is
nice
exhibit
clean cut by
147D.
something sharp.
What are you doing there?
That's a close-up photo of that same area of damage 1 with a scale included.
We just saw a close-up of one of the holes that was marked number 1. Did you do the same analysis for each and every one of those areas that you marked?
Yes, I did.
And did you look close up at each and every one of them and measure each and every one of them?
Yes, I did.
Are there photographs showing all of those different angles for each and every hole that you went through?
Yes, I took numerous photographs of each area of damage.
If you could take that down, please. In addition to that sweatshirt, did you look at any other clothing items?
Yes, I did.
Court's permission, can I approach?
Yes.
Thank you. I'm showing you 2 photographs. If you could look at the first one, do you recognize what's in that photograph?
Yes, I do.
What is it?
This is item 7-17. It's an orange T-shirt.
Is it fair? Should I write? Thank you. Is that a fair and accurate depiction of the T-shirt when you examined it?
Yes, it is.
And the second photograph, please, could you take a look?
Yes.
Do you recognize what's in that?
Yes, I do.
What is it?
This is the other side of the orange T-shirt.
Is that a fair and accurate depiction of the T-shirt when you examined it?
Yes, it is.
All right, move these 2 photographs into evidence, please.
No objection, Your Honor.
Great, thank you.
This is going to be our pattern with her. Hand her some photos, then go look at them and talk about them.
Exhibits 148 A and B.
With the court's permission, I'd like to show P232 to the jury.
Okay.
Could you tell us what you see?
That is a photograph of item 7-17. Is the back of the orange T-shirt.
Could we zoom a little in on the numbers on the bottom, Ms. Gilman? What's that on the bottom?
That is the case number, the individual item number for that T-shirt, my initials, and the date that I examined it, or the date that I took the photo.
So you had obtained this item on that date, or this is when you examined it and already had it?
That is the date that I opened it up, examined it, and took the photo.
And on the left, what's that ruler used for?
That's a scale just to show the size of the item.
Could we zoom back out and get a full look at that? Thank you. If you could turn next to P233, Ms. Gilman.
Classic. We've seen it a million times.
What is that, a photograph of?
That is a photograph of the front of the orange T-shirt, item 7-17.
Ms. Gilman, can we first see the bottom left-hand corner zoomed in a little bit? Thank you. Why did you place a marker there?
I used markers on this item to note areas of staining that I was going to do further analysis on.
Did you do further analysis of that stain area?
Yes, I did.
And how did you do that? Any different than the swab you talked about before?
This I screened for blood, and I'd have to check my notes for any further testing I did on it.
When you screened it for blood, was it a positive or negative result?
That was positive.
Do you know if you did anything further with it?
May I check my notes?
With the
Yes.
court's permission? Thank you.
Can you turn the lights up, please? Thank you.
Little blood on the front of his T-shirt. What's it? Oops. Sorry, guys. What's it doing there?
Please.
Yes, I also performed a confirmatory test for blood on that stain.
So what's the difference between a preliminary and a confirmatory test?
A screening test, other types of materials may cause a positive reaction. For the confirmatory test, it is confirmatory for blood, as well as it indicates human blood, although you might get a positive reaction from primate blood or ferret blood.
Can we now
Primate or
turn to the
ferret?
top right and zoom in if you would?
Didn't expect the
You see
ferret
three
to enter
tabs
the
there. What are
trial.
you looking for in those areas?
Those are 3 additional red-brown stains that I performed further testing on.
And do you have the results of that testing?
So I performed a screening test on each of those tests, and each of those screening tests was positive. I performed a confirmatory test on stains A and C, which were also positive. I did not perform that test on stain B due to its small size.
If you could zoom out just a little bit, please. Similar to the sweatshirt, there's long cuts through the front of that T-shirt. Is your analysis and opinion any different than the similar cuts that you saw on the sweatshirt?
What's blood
Yes,
doing
I
on
did
the
not
front of
perform
his
any
T-shirt?
additional analysis on those area of damage due to the fact that they're most likely attributed to the emergency medical technicians or medical personnel removing that item of clothing.
Thank you. You could take that down, please, Ms. Gilman. And for the final piece of clothing, did you have a chance to look at pants?
I did look at a pair of jeans, yes.
May I approach, Your Honor?
Yes.
What does he have? Nice little clean droplets of blood on the front of his T-shirt that was underneath his sweatshirt
you 2 photographs. The first
that
one,
he
you
was lying on
recognize
his back on all
Yes, I
night.
do.
And what is it?
This is a photograph of the front of the pair of jeans, item 7-1.
Could you look at the second photograph, please? Do you recognize what's in that?
Yes, I do.
What is it?
This is a photograph of the back of the pair of jeans, item 7-1.
Do both of those photographs fairly depict what you saw when you examined the clothing?
Yes, they do.
I'd move these 2 to evidence, please.
No objection, Your Honor.
Okay.
Thank you.
Exhibits 149A and B.
With the court's permission, I'd show P242, which is 149A, to the jury.
Okay.
Was there anything of note when you examined these pants?
These pants also had linear damage between the top and the bottom, which would be consistent with cuts made by emergency medical personnel when removing the item.
If we could
What about
zoom in to show
stains?
those cuts, Ms. Gilman. And could we scroll down, please? Thank you. If we could next show P243, which is 149B. Could you zoom in on the top part of those pants, please? Do you make any observations or notes about the pants?
May I look at my notes, please?
With the court's permission, please. Thank you.
Stained on both sides.
I noted numerous red-brown stains on the clothing, as well as dirt and debris on the clothing.
What part of the pants did you note the dirt and debris?
It was just a general observation. I didn't specifically denote where it was.
Ms. Gilman, could you scroll from the top to the bottom of the pants, please?
So not like a specific location, like a specific stain.
Thank you. You can take that down, please.
Do any blood testing on
Did you
those
perform
pants?
any
Hartnett?
additional testing relative to the clothing that you examined, that being the sweatshirt, the T-shirt, and the pants?
I performed numerous tests on each of the red-brown stains on the items that I marked.
After you completed examining the red and brown stains, did you do any other type of testing or evidence collection relative to the clothing?
Yes, I did.
Could you share with the jury what you did as far as further evidence collection relative to the clothing?
Can we take it item by item? How would you
Sure
prefer
can.
to do it?
Let's start with the sweatshirt.
Okay. So in addition to testing the red-brown stains, I collected any stain that was positive or confirmatory for blood. After performing that collection, I also performed a collection around the tears on the right sleeve of the item, That's using 2 cotton swabs moistened with sterile water, which I vigorously rubbed around the areas of the teared areas on the sleeve.
Teared areas?
I also performed an additional scraping and swabbing of the unstained area of the sweatshirt for any potential skin cell recovery. In addition, I performed a debris collection from the sweatshirt.
I want to stop you there. I want you to explain to us in some detail, what is a debris collection and how do you undergo a debris collection?
After I've completed all the testing that I'm going to do on the item, I remove any large items that may be present on the item, such as apparent hairs or fibers, anything that I can pick off, I can visibly see with a pair of tweezers. Once that is done, I will do I did a general debris collection where I took a large metal spatula shaped object and scraped the clothing, or in this particular case, the sweatshirt. And any debris that came off the sweatshirt was put into a glassine fold and preserved.
Before you tried to scrape off any debris that was on the sweatshirt, could you, to your own eye, see any debris in the sweatshirt?
May I check my notes?
Yes.
She didn't do the testing. That was Andre Porto.
In this particular case, I did pick off a couple of pieces of what I termed black debris. I made no additional analysis of that item. I packaged that separately, and then the scrapings themselves, I did not make any observations of anything contained in those scrapings. So there was nothing of note that I could have put in my notes to further classify them.
When you do the scraping, is there a table or a desk that you would see small pieces or difficult pieces? How do you contain what you're scraping from an item?
I lay out a piece of glassine paper, which is approximately 6 inches by 6 inches, and I scrape the debris into that glassine, and then I fold it up and put it in an additional envelope to prevent anything from falling out.
So if there's any debris, you would fold it in the glassine and then put that in a separate envelope?
Yes, that's correct.
And did you continue to study and scrape the other pieces of clothing?
Yes, I performed that same type of scraping on the orange t-shirt. That scraping was combined with the scrapings from the sweatshirt. I performed the same scraping on the jeans as well as the boxer shorts.
In that scraping process, did you acquire debris?
Yes, there was some visible debris.
How small were the pieces?
I did not make any measurements of it.
Why not?
That's done by a different analysis unit, so I didn't do any type of analysis on that debris.
How small or large were the pieces of debris that you scraped from the clothing?
I did not take any measurements of them.
How did you store the debris that you scraped from the clothing?
It was put into a glassine fold, given a separate item number, and then put into a larger glassine fold so that it could be tracked throughout the laboratory.
Do you have that item number?
Yes, I do.
Which one?
So the debris from the sweatshirt and t-shirt was item 7-18.18.
So they don't even know what was outside of the shirt.
7-18.18.
And the t-shirt.
And that's the debris that you scraped from the shirt and the sweatshirt.
Correct.
She combined
Did you do any
them.
debris scrapings from the pants?
Yes, I did.
Was any debris produced from the pants?
Yes.
Was it similarly packaged?
Yes, that's correct.
Was there a different item number given for the pants?
Yes.
And what was that item number?
May I check my notes?
Yes.
Thank you. That item number, the debris from the jeans, was 7-1.8.
Those two items, the debris that you acquired from those clothing items, did you send them anywhere?
I put those in our secured storage unit, and they were later forwarded on to the trace unit for analysis.
They later went to the trace unit?
Yes, that's correct.
Okay. When you arrived at Canton on February 1st, 2022, do you recall what the weather was like outside?
I don't recall. I just know that it was winter.
If only there were
You
photos.
said when you first get to a scene, you have a conversation about the investigator's information to help your assessment. And I don't want you to discuss what that conversation may have been, but did you have a similar conversation?
Yes, I did.
When you're looking at an item that's been stored, like in this case, a car, does the weather conditions, ice, cold, snow, ever preserve or maintain evidence on an item longer than it otherwise would stay?
I'm sorry, can you ask that one more time, please?
Does ice or snow or the weather ever maintain evidence longer than otherwise would stay?
I don't have any data or information to that.
Have you ever had an opportunity to view videos of the Lexus when it was first stored and the condition of snow and ice on it and the firing process of that?
I don't believe that's the part of the video I saw, no.
You saw a video after the snow had already melted?
I don't know if the snow had melted. When I saw the vehicle, it did not have snow on it.
Okay. Thank you. I have no further questions.
Okay.
Your Honor, may I approach the
Yes.
witness? Thank you. Your Honor,
Show
pursuant
Mr. Brennan what you did. Okay.
pursuant to a stipulation with the Commonwealth, we've stipulated into evidence various documents. So what I'd like, with Your Honor's permission, and for the clerk to have remarked is next in order, and then I'll proceed from there.
Thank you. Should any be marked A, B, and C, or are they each separate?
Separate, please, Your Honor.
Okay.
Exhibits 150 through 153.
And Your Honor, there is one more exhibit that we had pursuant to stipulation offering that evidence. Next in order.
Exhibit 154.
And Your Honor, if I could just show Mr. Wolf this to make this more efficient
Okay.
for the last one. Thank you, Your Honor.
The pocket
Thank you
was
for that
ripped on the
opportunity, Your
photo.
Honor. And if I could, please, I'll leave these here. These are all going to be published with Your Honor's permission, but obviously the witness is going to need that.
It was ripped. Just not all the
Thank you,
way
Your Honor.
to the bottom, but it was ripped.
Unless I may approach for the witness. Thank you. You may leave this as we-
Sure, thank you.
Good afternoon, Ms. Hartnett.
Good afternoon.
Is it acceptable to you for me to refer to you as Ms. Hartnett?
Yes, that's fine.
Thank you. You were dispatched to the Sallyport at the Canton Police Department on February 1st, 2022 by former Massachusetts State Trooper Michael Proctor, correct?
Yes, that's correct.
You understood at that time that Michael Proctor was the lead detective, the person who was in control of the investigation?
Yes, that's what I was informed of when I arrived.
Oh, informed that.
While you were there, one of the things that you did initially was to conduct an overview of the vehicle meaning the black Lexus SUV that you talked about extensively on Direct, correct?
Yes, that's correct.
That was important to you, given the limited information that you had at the time about what was contended to be a potential motor vehicle pedestrian incident, correct?
That is something that I would do in any type of exam where I'm looking at a vehicle. I look at the overall vehicle.
So you were looking for anything possible that would rise to the level of investigative concern regarding that vehicle, correct?
Yes, that's correct.
And you're familiar with the parlance investigative concern, right?
Yes, that's correct.
And that's why you noted various items, for example, scratches on the vehicle?
Yes.
You didn't draw any conclusions as to where those scratches came from, though, did you?
No, I did not.
The dent that you noted and photographed that you discussed on your direct examination, you likewise made no conclusion as to the source or cause of that dent, correct?
That's correct.
And you did therefore not make any or draw any conclusions as to whether that dent was caused by any motor vehicle or pedestrian accident, correct?
Correct.
You're a forensic scientist too for the Massachusetts State Police Department, as I understand it?
Yes.
With regard to the taillight that you spoke about rather extensively on your direct examination, you likewise were not able to, and you make no conclusions as to the cause of that broken taillight, correct?
That's correct.
And you draw, therefore, no conclusions with regard to whether that taillight became in the condition that was discussed on direct examination pursuant to any alleged motor vehicle pedestrian incident, correct?
Correct.
The dent, the scratches, the broken taillight on the Lexus, to your knowledge, as you sit here today, could have existed before February 1st, 2022, when you went to Sallyport, correct?
Yes, that's correct.
And to your knowledge, the dent, the scratches, the broken taillight could have existed before January 29th of 2022, correct?
Yes, that's correct.
You also looked for, as you stated, tissue, blood, biological material, and things of that nature on the vehicle, correct?
Yes, I did.
In that inspection of the vehicle, you didn't see any visible stains or tissue on the vehicle, did you?
No, I did not.
You were told, Ms. Hartnett, that there were wounds on the right arm of Mr. O'Keefe, correct?
Yes, that's correct.
And at the time you went to the Sallyport on February 1st of 2022, you were not shown a photograph by anybody of the wounds on the right arm of Mr. O'Keefe, were you?
No, I was not.
However, you've seen since then a photograph of the right arm of Mr. O'Keefe and the wounds on that right arm, correct?
Yes, I have.
With Your Honor's permission, if I could publish Exhibit 1 in evidence?
Okay.
Thank you. Mr. Wolf?
Let's look at the arm. About where those holes were, those strange puncture-looking marks.
I'd ask you to take a look at that, and you recognize that what's depicted in that Exhibit 1, correct?
Yes, I do.
And you've seen that pattern of wounds on the right arm as depicted in a photograph of the decedent before, correct?
I've seen this photo before, yes.
You cannot state whether the wounds on the right arm as depicted in Exhibit 1 are from a motor vehicle, can you?
That would be on the scope of my expertise. I don't make any conclusions on injuries on a person.
So the answer is you cannot and do not make any conclusions with regard to the source of the wounds on the right arm as Mr. O'Keefe as depicted in that Exhibit 1, correct?
That's correct.
And you're also not able to state whether you observed anything on the vehicle.
Mr. Alessi, can we put are you done with this?
I'm not yet,
Okay.
Your Honor, but I will let the court know. It'll be shortly. Thank you. And you
Nope,
cannot
sit in the
state
dark,
that you
Judge.
observed anything on the SUV that would cause the wounds on the right arm of Mr. O'Keefe as depicted in Exhibit 1, correct?
That is not a type of analysis I would perform.
So the answer to that question is no, you cannot state that you observed anything on the vehicle that would cause those wounds to the right arm of Mr. O'Keefe?
Yes.
Sustain.
Did not reach conclusions about that.
We can now take that down, Your Honor. Thank you. Did you look toward the top
Got a
of
chin jet
the
going on.
liftgate of the Lexus vehicle when you were at the Sallyport Kent Police Department on February 1st of 2022?
Are you referring to the exterior or the interior?
Exterior.
I don't recall specifically looking at that area. I did an overall examination of the vehicle, with exception to the actual roof of the vehicle. So I don't remember specifically looking at that area.
So as you sit here today, there is nothing notable with regard to that area of the vehicle, correct?
I had nothing in my notes regarding that area, no.
And as you sit here today, there's nothing you're recalling that is notable about the tap part around the lift gate of the back of the SUV, correct?
That's correct.
Nothing notable. There's some foreshadowing.
Did anyone ask you to examine that area?
Not that area specifically, no.
Do you understand what I will refer to as the undercarriage of the vehicle?
Yes.
And what, just for the jury's better understanding, what are you referring to when you refer to the undercarriage of the vehicle? I know it may be common sense, but just to be clear.
What I understand the undercarriage to be, where if I was laying underneath the car, what I would be looking at, include the muffler, various pipes, but that's the extent of my knowledge of vehicles.
So if we're
Muffler
talking
and pipe.
about the back of the
Muffler and
vehicle,
pipes.
and if we go sort of top to bottom, top where we were talking about the lift gate going all the way down, and then go to the bumper, and then go under the bumper, and where it curls under the bumper, then with the bumper and underneath and more a little toward the front, is that what you're referring to as the undercarriage?
No, it's
Yes,
like a
just the
series
general
of
area
tubes.
underneath the vehicle, extending from under the bumper to the front of the vehicle.
Right, so the undercarriage is not merely from the back, but it's underneath all the way toward the front of the vehicle, correct?
Yes, that's
and you
correct.
refer to all, I'm sorry, I didn't read that.
Differential, the suspension,
So all that
spring.
area you refer to as the undercarriage.
Yes.
All the electrical stuff. You might have your fuel pump down there. You might have your fuel tank down there. Yeah, we could go through and name all the parts of a car that are not
Did you
the muffler and the pipe.
notice anything of note in the undercarriage, as you just described it, of the vehicle?
No, I did not.
The alignment of that car.
And as regards sampling that you discussed
What's
on
the
your
alignment?
direct examination, did you take any samples of that undercarriage area of the vehicle?
I did not collect anything from the undercarriage, no.
And is the reason you didn't collect anything because you didn't see anything of note that was worthy of collection?
In addition to that, I also performed some testing of that area.
And what testing of that area did you perform?
I performed screening tests on some of the lower lying areas of the undercarriage, on the tire flaps, the edge of the bumper, the muffler pipe.
And what were the results of that testing, that screening testing?
Indeed.
Those results were negative.
And negative for what?
It was a screening test for the possible presence of blood.
So on the entire undercarriage, from where we started in the very back, all the way underneath, all the way up to the front, the screening test came back negative for any blood or other biological material or anything else of note that would be part of that screening test.
So I did not perform a screening test on the entire undercarriage. I just performed the screening test on the lower lying areas, and those were all negative. And there was also no visible staining in that area, so that is correct.
The low pipes.
What
You
I'd
got
like
that?
to
The low pipes.
do now is to talk about sort of overall what we just discussed. So you discussed certain damage to the vehicle. You had no way on February 1st, and you have no way today of knowing whether any or all of that damage was pre-existing before January 29th of 2022, correct?
That's correct.
So it's possible that all the damage that you've discussed could have existed before January 29 of 2022.
Yes, that's possible.
Sure would be nice if it were
Are
photos,
you
wouldn't it?
aware of the odometer reading of the Lexus when it was in the Sallyport garage?
No, I'm not.
If we showed you a document in evidence that would have that on the mileage on the odometer, might that refresh your recollection as to what the mileage was?
That's not something I made a note of or even observed on the day that I was looking at the vehicle.
Okay, so you were there with Trooper Clark on February 1st, correct?
Yes, that's correct.
Are you aware of whether Trooper Clark observed and took a picture of the odometer? Are you aware if that happened?
I'm not aware of that specific picture.
The mileage on the vehicle was of no interest to you in your inspection as a forensic scientist too?
So my role as a forensic scientist too is to look for potential biological fluids and trace materials on an item. The mileage would not be something that I have ever made note of in any of my examinations of the vehicle.
So but you do analyze damage, correct?
I perform damage analysis on textiles and softer materials, not on vehicles.
But you performed the damage analysis on this vehicle, correct?
No, that's not correct.
So you observed damage on this vehicle, correct?
Yes.
But although you observed damage for your role, your position is that the mileage is of not of interest regarding your role. If I got that correct?
Correct.
Thank you. Moving on to another category, you spoke on direct examination about solo cups and 6 solo cups, and there were depictions put on the screen. Do you recall that?
Yes, I do.
So on February 1st, in addition to taking some swabs from the vehicle, you also mentioned that you took swabs of, as I recall it, frozen red-brown stains located inside the red solo cups?
Yes, that's correct.
Other than in this case, did you ever have to take swabs of red stain material from solo cups that people usually use for other purposes?
I've never performed a collection like that, no.
So this is the first time you ever performed a collection like that, correct?
I mean, the collection process itself is standard, applying the sterile water to the swabs and putting it in a potential stain of interest. However, no, I've never collected a sample from a red solo cup before.
Have you ever taken a sample from a red solo cup since that February 1st?
No, I've not.
Frozen, you say? How cold was that?
How many swabs
fridge?
did you take with regard to the red solo cups?
I took 2 swabs.
How did you choose which of the 6 solo cups that you were going to take? And I understand you took 2. Did you take 2 swabs?
2 swabs, but they were considered the same sample. They were taken from the same cup, same stain.
That was what I wanted to get at, is you took 2 swabs, but they were from the same solo cup.
That's correct.
Do you recall how you chose which solo cup you were going to take the swab from?
I don't recall.
Could that be of significance, which one you chose and why?
In this particular case, I did not believe it was significant at the time.
Did you confer with anybody as to what might be the best solo cup from which to take the swab?
I did receive information about where those solo cups were collected from, which helped me in making that decision.
You knew this was trash evidence anyway. What happened to the solo cups after this?
Forensic scientist too, you're aware that blood stains can contain, and these red-brown stains here, could contain multiple contributors, correct?
In some instances, that is correct.
What's a multiple contributor?
A multiple contributor, I believe the term more used in the DNA unit. However, having many contributors to a particular stain just mean there may be multiple sources of that biological material.
Do you know which red-brown stains that are contended to be found at the scene relate to which solo cup in the bag that these solo cups were in?
The information I had at the time were that these were collected from a same single stained area from beneath the victim.
But you don't have personal knowledge of that, correct?
No, that's correct. I was not present at the scene at 34 Fairview.
If the swabs were taken from multiple stains, you would have no way of knowing whether the swabs were taken from the same stain, correct?
Can you rephrase that, please?
Sure. If the swabs were taken from multiple stains, you wouldn't know where the swabs in particular came from?
So are you speaking of the swabs that I took?
Yes.
So the swabs that I took, I know came from one of those 6 cups. And I was informed that those 6 cups of red-brown stains came from a single stained area underneath the victim.
That information you just spoke about, was it put in any note that you read?
It was something that I had in my notes.
Did anybody else convey that information to you at the Sally Port?
I got that from an officer on scene at the Sally Port, but I do not recall which officer relayed that to
So it
me.
was verbal information you got from
That is correct.
person. Did that person show you any note or chain of custody or other document to support his or her statement in that regard?
No, they did not.
Ultimately, once you did take those swabs from a single solo cup, what did you do with the rest of the evidence in the cup?
That evidence was left with the Canton PD.
So you left the rest of the brown stained blood evidence from the solo cups with the Canton PD. You didn't take it back with you to the
What they did with it?
To your officer lab.
Correct.
DNA testing was not done on those swabs, was it?
I don't believe it was. No, no testing was done on those swabs.
So as we all sit here today, there has been no confirmation of whose blood those swabs relate to, correct?
At this time, those were not tested for blood at all, so I couldn't confirm that they were blood, and no additional testing was done. That is correct.
So therefore, we don't
They
know
even
any
confirm it was
person
blood.
or persons they might relate to.
That is correct.
Can't even confirm it was
And
blood.
thus, we don't know if there were multiple contributors to those stains.
Okay.
Oh,
Sustained.
Nothing wrong with that question.
you testified that the remainder of the contents of the solo cup that you took you swabbed from, as well as the other 5 solo cups, were retained at the Canton Police Department, as you know, before you left. And that investigation, as you said at the time, was being headed up by former Trooper Proctor, correct?
That is correct.
Michael Proctor was at the Canton Police Department Sallyport location at the time you were performing your work on February 1st, correct?
Yes, that's correct.
Did Michael Proctor take control of those solo cups?
I do not know who took control of the solo cups. I know that I turned them over to a Canton police officer. I handed them to a Canton police officer.
Might Michael Proctor have taken control of those solo cups?
To my knowledge, it was a Canton police officer at that time. I don't know what happened to them after they were turned over to the Canton PD.
Why is it that you believe a Canton police officer had control over those cups rather than former Trooper Proctor?
Just from my actual memory, I remember turning them over. They had collected the frozen red brown stains in the cups. So it was technically their evidence. I took the sample I needed from them. So I just returned it to the officer who had presented them to me.
So therefore, after you presented them, you don't know who took control of those cups. Is that a fair conclusion?
Yes, that's correct. Sorry, I didn't mean to cut you off.
That's okay. My question probably wasn't all that clear. Ultimately, during your work and inspection of the vehicle, the SUV, the right rear taillight housing was removed, as you testified to on direct examination, correct?
Yes, that's correct.
And you testified that a Canton police officer sort of helped you with the last stage of the removal of that taillight?
Yes, that's correct.
Do you know whether that officer was wearing, do you have a distinct recollection that that officer was wearing any special protective gloves?
I only know because I have seen the videos recently that he was wearing gloves.
I'm sorry, I didn't hear your answer.
I only know that he was wearing gloves because I have recently seen the video. I do not have a firsthand memory of that.
You said you recently saw a video. When was that?
Monday.
And what was
maybe? I'm sorry. Let me correct myself. What day is today? I saw it Thursday. Excuse me.
And what was the circumstances under which you were reviewing a video?
I had just recently found out there was video, and it's just something I wanted to see in case I was shown it on the stand, so I knew what it consisted of. I hadn't seen it prior to last Thursday.
Did you testify to that on your direct and I missed it, or did it not come up? Reviewing a video.
I'm sorry, yes, I believe I was asked if I had seen the video, and yes, I had.
Okay, thank you. Now back to the tail light. Mr. Woke, if we could have Exhibit 145 published
So how did you find out
with your
that
honor's
there's
permission.
video? Trying to make it sound like it originated from her, but who told her there was video?
We have up on the screens, and I know you went through this on direct, so I'm going to shortcut it. This is the tail light at the lab that you were talking about on direct, correct?
Yes, that's correct.
And that's the tail light housing that you submitted to the lab that you had obtained from the Sallyport garage, right?
Yes, correct.
So just to cover quickly some basics, there was one swab taken that you mentioned on direct of that tail light.
Yes.
And you testified, if I remember correctly, on direct that you, well, it's better for you just, if you could with a pointer, is just show the areas you covered with that one swab.
So I collected the swab from any of the, what would have been exposed areas of the taillight when the taillight was intact.
And if you could please, just give like a perimeter full, I know it's not a circle, but whatever it is, just full perimeter so the jury can see the entire area that you swabbed.
Sure. It was this upper right-hand red area, this portion down here, I believe it's red. And then there's also a portion of clear area in the front here that was swabbed. And that was all contained on a single swab.
Thank you very much. So I want to keep this up if I could, Your Honor, but we can have the lights back on if that's acceptable. Just so, thank you. In terms of the swabbing, you did not swab, therefore, any other area of that taillight, correct? Including the area to the left of where you just drew the circle, if you will, around, correct?
I would just say it's difficult from this picture to see if there's what would have been exposed when the tip. May I finish? I'm sorry. I don't know specifically on the left from this picture if there's anything that would have been there prior to the damage. If there was an external area, it would have been included in my collection. So I just didn't include any of the internal components of the taillight. So if I'm missing a piece over there that would have been on the exterior, then I apologize. I just can't see it in the picture if it's there.
Let's just assume my discussion and my questions. You don't have to assume this. My questions are just with regard to the inside of the taillight, because you've very nicely governed and talked about the outside of the taillight as you described it, where you swab. Now I want to go to the areas that you didn't swab.
Okay.
Whatever you best can do to describe the areas of the taillight that you did not swab.
Okay.
And if you could use the laser pointer, if that
Sure.
helps you.
So I did not swab the internal areas of the taillight. So here where the light bulb would have been, or down here where it's gray.
And focusing on the more, is it okay to call it the inside part of the taillight? Is that acceptable?
Okay.
So the inside of the taillight, to be clear, you didn't swab that area.
No, I did not.
In terms of where you did swab, given that you swabbed with one swab the entire area, you are not able to say precisely where any DNA might have come from?
Just that it would have been present, if there was DNA present on that swab, it would have come from the external exposed area of the taillight, should the taillight have been intact.
But again, on the inside, because you didn't swab the inside, you had no evidence of DNA on the inside of the taillight, correct?
Correct. I did not swab the inside.
With regard to the, what we'll call the outside where you did swab as opposed to the inside where you didn't, you cannot define whether the DNA was to the upper right, to the outside of the taillight lens, or some other place in that area, correct?
No, I wouldn't be able to narrow down where on the external portion, external front. I mean, I didn't swab anything in the back that was attached to the vehicle. So anything in the external front, I would not be able to narrow down any further where, if any biological material was present, where it was recovered from, specifically on the external area.
You did not find
blood,
any
glass
on the inside of the taillight, did you?
Are you referring to like loose pieces?
Any kind of glass at all?
I did not note anything unusual inside the taillight.
I'm speaking, thank you for that answer. I am speaking specifically about glass. You didn't find any glass on the inside of that taillight when you were at Sally Port for your entire inspection on February 1st, 2022, correct?
I'm just want to make sure that I understand your question.
No glass
I
inside
didn't
the taillight.
find anything that was not inherent to the taillight inside. I don't know what the taillight's made out of. So if there's a portion on the inside that's made out of glass, it may have been there. I didn't see anything that was out of place on the interior of the taillight.
Okay. So using your terms inherent, you mean by that something could have been on the inside of that taillight that was part of the taillight that could have been glass. But other than that, there's no what scientists call exogenous or outside glass or glass that doesn't belong as part of the taillight, correct?
I'm hesitant to answer that specific question. I don't perform glass analysis, so I just perform collection. So if there was something that apparently looked like glass that had been loose inside, is that's what you're referring to, I can answer that question. But I can't say specifically whether a material is glass.
I understand. My question is
no apparent glass.
A basic one.
Okay.
Which is, you found no glass that would not be associated. Let me strike that. Did you ever observe in this taillight any glass as part of the taillight that's part of the taillight? Anything glass that you observed?
Again, I can't make the distinction on a material being glass, so I think the premise of the question I'm having difficulty answering.
Okay. So last part of the questioning, you didn't make any note that said you found glass inside of that taillight, correct?
I wouldn't make a note that something is glass inside a taillight because I can't draw a conclusion to what a material is.
What about
that's
apparent
just not
glass?
part of the analysis I do.
What about apparent
And
glass?
to wrap
Where he's
this
going.
part up, and then we can move on from this item. You didn't find any DNA on the inside of that taillight.
My analysis would not include DNA analysis because that is a different unit. So I can't answer that question.
To your knowledge, as you sit here today, is there any information from anybody that says that there's any DNA in that taillight?
I have no information of that.
Thank you. So what I want to do now is, if we can take that down, Mr. Wolk, I want to move on to what is sometimes referred to as touch DNA. I know you're familiar with that concept, right, Ms. Hartnett?
Yes, that's correct.
And what is, for the jurors' understanding, what is touch DNA?
When skin comes into contact with an item, potentially skin cells can be left behind, which is commonly referred to as touch DNA, when in essence it's these skin cells from the person being transferred to another object or item.
So is this a fair example that if I walk by the podium and brush my hand against it like that, I could very well leave touch DNA on that podium for what I just did? Okay.
So stand without more of a foundation from this witness.
Thank you, Your Honor. So is it possible for me, as I'm sitting here talking, based upon your knowledge, to leave touch DNA on this podium?
Based on your knowledge.
Thank you, Your Honor. Are you familiar with the process by which a person can leave touch DNA on the surface?
Yes, I commonly defer to biological material because that is what my expertise is in. Skin cells can be transferred to an item, and skin cells can potentially provide DNA.
So do hands, palms of hands, produce skin cells?
Yes, they are made of skin cells,
And
correct.
if a hand is on, for example, a podium, can there be a transfer of skin cells to the podium?
Yes, there can be.
And therefore, can the hands on a podium that have skin cells transfer DNA?
Yes, again, I'm not a DNA expert, but generally that would be the source, would be skin cells. Could be, yes.
You also indicated that you collected apparent glass from the rear bumper of the Lexus, correct?
Yes, that's correct.
And you use the term apparent glass, as I understand forensic science, because at the time you're not really sure what it is, right? So you use the word apparent glass, and you can't take away the apparent until there's a confirmation that it is glass, correct?
Yes, that's correct.
And on your direct examination, you went through a discussion, so I'm going to shortcut it a little bit, about apparent glass that you located on the rear bumper of the vehicle, correct?
Yes, that's correct.
Bumper sprinkles.
Your Honor, with your permission, can we publish Exhibit 141, which is in evidence?
Yes.
Thank you. Mr. Wolf? Ms. Hartnett, I'm showing you what is Exhibit 141 in evidence. And I know you know this, and I know it's been discussed. Could you just give a brief summary of what is depicted in Exhibit 141?
This is a close-up of the right rear area of the bumper where I noted the pieces of apparent glass.
And you remember discussing this on your direct examination?
Yes.
Now, I just want to cover some basics with regard that weren't covered on the direct examination. You're a specially trained person, and that's how you get your forensic scientist title, correct?
Yes, it means that I've gone through all the training within the lab.
And all that training and all of those procedures are important and necessary because the collection of evidence is important, correct?
That is one of the reasons, correct?
And if those protocols aren't followed, then that can lead to incorrect conclusions, correct?
Depending on what portion of the protocol isn't followed, but yes, it's possible.
Certainly, at a minimum, it increases the risk for an incorrect conclusion or observation, correct?
Again, it depends on what part of the protocol isn't followed, but it's possible.
I assume it's therefore important to you that the protocols are followed so that the best result and the best collection and therefore the best analysis occurs, correct?
I make every effort to follow the protocols.
Is the quantity of the material you observe and collect also relevant, perhaps not to you, but to other persons in the investigation?
Yes, it can be.
And therefore, it's important not only to get the type of material correct, but to get the quantity correct.
In some instances, yes.
And with regard to your work on this vehicle on February 1st, do you recall discussing the collection, the observations you made with regard to the rear bumper?
Did I I'm sorry, can you ask that question again, please?
On direct examination, you talked about glass on the rear bumper, correct?
Yes, apparent glass.
You talked about what you observed, you talked about what you put a sticker on, you talked about what you collected, you talked about the transport of it, correct?
That is correct.
And you put it in your notes and you talked about it on direct examination
I assume because it was an important part of the work that you did.
Yes, it's a piece of evidence that I collected, correct.
And therefore, it's important for you to have made correct observations and to make correct collection, correct?
Correct.
So did you count the number of glass pieces correctly? Where are we going with this?
With your honor's permission, if we could publish Exhibit 133. If I could have a moment with Mr. Woke just to do this efficiently, Your Honor? Thank you.
He's building up to something and it's not clear what he is with that segue into the protocols. It's important to follow the protocols that can matter. And now the glass and the quantity and the height of the materials could be important. It sounds like she misdocumented something. Like that's where he's going. But we're waiting to see. I mean, who knows? Maybe some more glass apparated into the bag.
With your honor's permission, if Mr. Woke, you could zoom in on the stickers, right? So, Ms. Hartnett, on your direct examination, you stated that there were 2 stickers and that there were therefore glass associated with each sticker, correct?
Yes, that's correct.
So 2 stickers and glass associated with each sticker, correct?
Yes, correct.
In fact, there's only 1 sticker, and the second sticker is merely a reflection of the first sticker, and therefore, you have doubled the stickers and you've doubled the amount of glass on the bumper. Can you see that? Can you determine that from the photo?
No, can I see the other photo, please?
Yes.
Okay.
So if you could, Your Honor, with your permission, go to Exhibit 133.
It is a reflection on the black part. It's a reflection of the bumper on the high shine, high gloss black enamel. Oh my God, it is. He's totally right. How did we not notice this before?
You asked to see this one. Can you now make a determination, having seen both of them, whether there is in fact just 1 sticker and therefore 1 volume of glass associated with it?
No, I cannot. You're saying this is a reflection?
The one thing he was able to photograph
Okay.
so far is a reflection.
With Your Honor's permission, if we could go back to the other picture,
Okay.
and you could zoom in.
That's why she didn't know what
Do you
part of the
see a
car it
reverse
was.
B in that picture?
I'm sorry, I didn't get that.
I'm sorry, a reverse B as in Bob?
No, could you zoom in on each of the stickers for me, please?
We'll do whatever you would like to do to answer the question, so.
Sure.
Because you're not going to be able to talk your way out
And
of
then if
this
I could just
one.
see the other sticker, please. Yes, I believe that is a reverse B, correct?
And doesn't that mean that it's
A
a
reverse
mere
B.
reflection and that there's only 1 sticker that you put on and therefore only 1 volume of glass associated with 1 sticker?
Can you say that question again? I can't hear you.
I'm sorry, I will stay by the microphone. Is this microphone picking up? So therefore, can you now conclude, because of the reflection and because of the reverse B, that there is only, in actuality, and there was only in actuality, 1 sticker and 1 B, and therefore 1 volume of glass associated with this bumper?
I don't know specifically that it's a reflection. It's not unusual for me to use the same letter on a sticker if I'm going to collect the items of evidence together. So if I had written it, on top or on the bottom of the scale on one of them and on the top of the scale on the other one, that is a possibility. It's difficult for me to tell by this picture. What I can tell you is that all the items of glass or apparent glass that were present on the bumper were collected together.
Would you use a reverse
I can't say
speed?
specifically by looking at this photo whether I just label two separate areas to make the photo show the pieces better or if it is a reflection. I can't say.
So from what we just went through, you're not able to tell that that is a reflection and therefore a duplication, is that correct?
Some analysts you are.
Sistine.
We can all
you-
tell.
Have any doubt whether there is
Doubt? Would you
a
characterize it as reasonable?
reflection on the photo that is on the screen at this moment? Do you have any doubt?
Oh, I would say it could be a possibility, yes.
Right. So you have doubt.
Sistine.
So you believe it's a possibility?
Yes, correct.
It's a reasonable
Is it more than
possibility.
a possibility?
Yes. Sistine.
Is it a reasonable possibility?
You would agree that it's important to have the accurate answer to that question, correct?
I think that, yes, obviously, understanding and knowing exactly what I'm looking at is important, but it would not change what I would have collected and how I would have labeled it.
So with regard to what others might do and conclude from that, it could be important to them, correct?
Yes. Sistine.
Let's go to the,
Oh, my Lord.
these, we can go back to the,
Oh, man.
none of these pieces of apparent glass were embedded in the bumper, correct?
No, they were resting on the bumper.
So by not being embedded and just resting on the bumper, you therefore did not make a notation that they were embedded in your notes. You just put that they were on the bumper, correct?
That's correct.
And sort of as we're elaborating here, you're elaborating, they were just, as your words, they were just resting on the bumper.
Correct.
Not embedded. Did Mr. Brennan
we
say
could,
embedded in opening?
If I may confer with Mr. Wolk on the video, thank you.
Do you need the lights on to do it?
10 seconds.
Did he say they were embedded? Looking back through those,
Thank you for that opportunity, Your Honor. If we could go to Exhibit 124, Mr. Wolk, and with Your Honor's permission, if we could publish it.
Yeah.
Ms. Hartnett, there had been various weather before February 1st in the area. Is that correct? You testified to that somewhat on direct examination.
Yes, that's correct.
And are you able to discern from what is on the screen now that there is some type of precipitation that is on the back window of the lift gate of the vehicle?
Yes.
And is that consistent with what you observed when you were in the Sallyport on February 1st?
I don't believe I observed the precipitation on the back of the vehicle by the time I arrived.
But does this refresh your recollection as to whether there was in fact that precipitation on the vehicle at that time?
Can you ask it differently so you need it clearer?
Yes. Do you recall when you were at the Sallyport on February 1st, any precipitation on the rear window of the liftgate of the SUV?
No, I do not recall.
And does this depiction refresh your recollection on that point?
I'll allow that. Does it?
No, I don't recall seeing any precipitation on the vehicle, and I don't know when that photo was taken, so that does not refresh my memory of that instance.
Is there a date of January 29th, 2022 on that photo? We can enlarge it if that would help. And again, this is in evidence. Do you see what is at the bottom of the photo?
I do.
Now, if we could play, with Your Honor's permission, this video. And if we could stop it at certain points, Mr. Wolk, that would be helpful. May we, Your Honor?
Okay.
Thank you.
Oh, some snow fell off.
If you could wait, Mr. Wolk, until the sirens pass. Mr. Wolk, if you can go back just and wait until the sirens pass, please. Thank you. I think they passed.
Literally watching the snow and ice fall off the car.
If you could accelerate it just a little bit, Mr. Wolk, without overly accelerating all that's happening.
Falling off where? Onto the bumper?
And accelerate it a little bit more. And that's good. And if you could bring, yes, thank you. We could have the lights on and take that down, please. Can you describe what you just saw?
Whatever the white material was present on the back of the vehicle was falling off.
And where was it falling onto?
The ground.
And did it hit anything before the ground? For example, did it hit the bumper before it hit the ground?
I didn't take note of that.
That was on January 29th, 2022. You were at the Sallyport on February 1st, 2022, correct?
That's correct.
So that occurs on January 29th. You come to the Sallyport on February 1st, yet there is glass on the bumper on February 1st that, as you have described it, is just perched on the bumper, right?
Yes, that's correct.
Convenience.
Do you know generally where Dighton, Massachusetts is?
Yes.
Do you know where, and you obviously know where Canton is.
Yes.
How far away would you say Dighton is from Canton?
Time-wise, maybe 30 to 45 minutes.
And therefore, roughly, if someone were to go the speed limit, around 30 minutes away?
Sure.
Not holding you to any exact time, just generally. Your notes indicate that the vehicle was recovered from Dighton, the one we've been talking about, the Lexus, and towed back to Canton and placed in the Sallyport garage at the Canton PD before you started your examination, correct?
That's correct.
And you were made aware before your inspection or examination on February 1st of 2022 that the alleged incident in this case took place in Canton, correct?
Yes, that's correct.
So you knew you were looking at this vehicle, when you were looking at this vehicle and doing your examination, that the vehicle, by definition, as to what we had just covered, went from Canton to Dighton and then towed back from Dighton back to Canton, correct?
Yes, that's correct.
So it ends up back in Canton after that journey, correct?
Yes, that's where I examined it, correct.
So, as I understand your notes, the glass pieces that were just perched on the bumper would have traveled about 60 miles before you saw them?
Is that what you're saying?
No.
Well,
what are you saying?
When do you believe the glass appeared on the bumper, if you know?
I don't know when the apparent glass appeared on the bumper.
So you believe it's possible that the apparent glass appeared on the bumper after January 29, 2022?
Yes.
Sustained.
There's nothing wrong with that question. Nothing wrong with that
Do you
question.
know the weather conditions
It is possible.
that were in the area? We talked about it earlier. You talked about it on Direct. In the general time of January 29th of 2022.
Yes, I do.
Do you know when the vehicle took its journey that we talked about, Canton, Dighton, back to Canton? Do you know what day that occurred?
No, I do not.
Would it have, let's assume it was on January 29th. Okay?
Let's assume.
Yes, okay.
For purposes of my questioning. Do you know what the weather was, including wind speed, on January 29th?
No, I do not. I know general weather conditions. Sorry.
You knew generally, but not specifically, correct?
Correct.
Your Honor, with the court's permission, I'd like to publish Exhibit 60 in evidence.
Okay.
Let's get that weather report back up. Let's turn the Commonwealth's evidence into our evidence. Man, so much. What a good lawyer.
And if you
Such a
could
good
go
lawyer.
to the top, Mr. Woke, of the title first. If you could go before that to the very, very top title in the center so Ms. Hartnett can see okay. And then if you could now go down to the part of the document that would show the date and then go from left to right for Ms. Hartnett, please, and the jury. And show which column go up above what the 29 relates to. And if you now then can proceed to the yellow line and go over to and hit the relevant categories. Thank you. So we have a 15.7. If you could now go up vertically as to what that number relates to. And can you highlight what it relates to? And if you could now go down to and go up above 1, just above the average, is to yellow highlight what's above the column up above average speed. Yes. Okay, if you now can go down to the respective columns at the bottom for January 29th. Do you see those two numbers, Ms. Hartnett?
Yes.
Does that refresh your recollection at all about the average wind speed and gusts of wind that were occurring on January 29th of 2022?
I have no firsthand knowledge of what the wind speed specifically was in those dates.
So if we could go back to Mr. Wolk, the exhibit with regard to glass on the bumper of the vehicle so these are your observations on February 1st. And we've talked about the journey that the vehicle went on. You talked generally about the weather.
So try and ask a question without too much.
I understand. Understood, Your Honor. Thank you.
Too much orientation?
In your experience as a forensic scientist too, is it possible for glass that is perched on a bumper to travel 60 miles and be subject to average wind speeds of 15.7 and still remain on the bumper?
Objection.
So it's sustained without a proper foundation.
Understood. Have you ever had experience with analyzing glass on any surface, an outdoor surface, and correlating that glass to weather conditions to make a determination as to the likelihood that glass could be or not be in a certain place on a certain date and time? Have you ever done that?
No.
No, never done that. It doesn't matter, man. Her answers don't matter. That's
Based
part of
upon
what's so
what you
beautiful
know
about these
about this
questions.
case, just based upon what you know, and from your role as a forensic scientist too only, do you believe that information would be relevant to your role as a forensic scientist too?
Sustained.
That was a very angry objection after a long pause. Was he napping?
How did you recover
Woke up mad.
the glass? What tool did you use to recover the glass on the bumper?
Tweezers.
How difficult or easy was it for you to take the glass off that bumper with, did you say tweezers?
Yes, that's correct.
How hard or easy was
you
it for
say
you to
tweezers?
remove those pieces of glass with tweezers?
It was not difficult.
So it's easy.
Yes, correct.
You can take that down, Mr. Wolf. Thank you.
Easier
Moving
than
on
say
to another
twisting an eyebrow?
category, Ms. Hartnett. You testified on direct examination that you
More
located an apparent hair on the rear right quarter panel of the vehicle, correct?
Yes, that's correct.
And again, we say apparent hair for the reasons we've discussed. You didn't know at the time, so you use the word apparent, and you don't take away the apparent until testing confirms it's hair, correct?
Correct.
So the apparent hair was not sitting on the horizontal bumper, but it was on a vertical portion of the panel. Is that correct?
Yes, that's correct.
And that's the quarter panel, right?
Yes.
And that's a smooth surface, right?
Yes.
That hair wasn't secured to that panel, was it?
No.
it in fact wasn't secured in any way on that quarter panel, correct?
That's correct.
It wasn't
And then
taped?
also,
No,
It wasn't glued? It wasn't stapled?
no,
It was not affixed in any way whatsoever?
no, it was not.
took a 60-mile trip, though, didn't it? Through sustained winds and snow.
You
The
found
worst blizzard
this
in
apparent
January
hair
in history.
at the same time you found the glass pieces on the bumper, correct?
In the same general time, yes, that's correct.
When you say same general time, it was just one day you were there, correct?
Yes.
The range of time wasn't that broad, was it, correct?
No, it was not correct.
What was the range of time between finding one versus the other?
I don't know specifically. I was there for approximately 2 hours, so within that time
So
period.
within just 2 hours, you found the pieces of glass and the apparent hair. And within that time, you did your examination, you made your notes, all of that done within just 2 hours.
Yes, that's correct.
You remember the journey we talked about of the vehicle that you spoke about with regard to Canton, Dighton, Canton? You recall that?
Yes, I do.
So do you know whether, do you have any knowledge whether that hair was part of that journey? Do you have any knowledge?
I do not.
Don't know if the hair part of the great adventure.
Do you know when the hair was deposited on the vehicle?
No,
Was it easy or hard to take off the apparent hair from that quarter panel?
it was easy. Again, I picked it up with a pair of tweezers.
Didn't give you any resistance?
No.
With your honor's permission, I would like us to look at a depiction of the hair. May I, your honor?
What exhibit number?
It is, I believe we're going to start with 144B.
Okay.
Oh,
And if you could zoom in, please, Mr. Wolf, for the jury and for Ms. Hartnett.
it just clung
Do you
fiercely.
still have a laser pointer, Ms.
It's
Hartnett?
a heroic hair.
Could you kindly use that and draw a circle around the apparent hair?
Yes.
Thank you. I'm going to refer to that as a J shape. Is that a fair description of it, or do you have a better description of it?
I see two ends of the hair in an arch, so I'm going to say more of like a C shape.
Okay, so you would refer to that as a C shape?
Correct.
And would that be a reverse C? Then if it's a C shape?
In that picture, it's difficult to tell if the ends are making contact or if they're coming off the vehicle. So I'm not sure.
Whatever way you would describe it, a letter or shape, because then what I'm going to do, just, it's not a trick here, but
Yeah.
I'm just
The
going to
other
show
photo.
you another picture of it, of that hair that might be in a different location or different shape. So I want to give a contrast. So whatever term you want to use that's fair to you.
So I think it looks like a C. I can't say, it could also be like a U. I'm not sure which way the ends are facing from this perspective.
Can you once again, just so we're clear and the jury's clear, just draw a circle around it again, what you're talking about, and we won't give it a name,
Okay.
right? We'll just do the contrast. Right.
Okay.
So if I were to just say there looks like there might be a little hook at the top and then there's a vertical line, is that a fair description?
Yes.
Okay, so can we go with that? A little hook at the top and then a straight or a line, that vertical line that comes down?
Sure.
And
yes.
that hook is orienting left, correct? Of the vertical line? It's to the left of the vertical line?
Yes, I do see it from this perspective to the left. That's
Okay,
correct.
very good. And that's the apparent hair.
Yes.
And you
By the
only
way,
saw
all
or
this
found
spotting,
one
what's that?
apparent hair, correct?
Yes, that's correct.
All right, if we could, Mr. Wolk, now go to Exhibit 144A. And if you could zoom in on that for Ms. Hartnett and the jury's benefit. Could you draw a circle now around the apparent hair. Thank you. And isn't that apparent hair now oriented almost 180 degrees the opposite, with the hook orienting right?
The photo's taken from a different angle, so do you see the hook? Are you talking about the hook at the top? Looks now, it appears to be on the right, but I can't, they're taken from different angles, sure.
How do you know they were taken from different angles? Did you take the picture?
No.
Are you speculating that it's taken from a different angle?
I mean, I'd have to see them side by side, but it's just the orientation of the, my marking. Can you put them up side by side?
Absolutely.
Okay.
Would be helpful to you answer your questions? Happy to do it.
Potentially, yes, thank you.
Absolutely, we can. Oh, maybe. Are we going to need to be careful what we ask for?
If we zoom in, is it possible for each one? So would that be helpful? We zoom and get a side by side.
I mean, even from the overalls, I can tell that they're taking.
Let's start with the overall that you would like, and then we can.
It's not much of a difference.
Yes, just by looking at those, to me, it looks like one is from slightly to the side of the vehicle and one is more directly head on.
Right, so one's slightly to the side and the other's a little bit more head on, but that's the only difference, correct? It's still the same from top to bottom.
It's not like it's from the opposite side.
Same orientation, correct?
That would cause it to be mirrored.
The vehicle didn't move, but the camera angle is different in both pictures. That's what I was saying in the other one. So the camera angle is different. The one camera angle appears for who's ever taken the photo to be standing off to the right of the vehicle. The second photo looks like it's more directly head on.
We're like one step to the right.
570 is oriented the same way in both pictures, correct? You see the 570?
Yes.
On the left, and you see the 570 on the right, correct?
Yes, I do.
They're same orientation, right?
They're in the same location on the vehicle, but I don't think they're at the same orientation. I think one looks.
If you could, I want to make sure you finish, but if you could just. My questions are rather narrow.
Okay.
And then if you need more time to answer them, I'm happy to do that.
So let's just ask the questions.
Yes, thank you, Ron. So isn't the 570 in each picture oriented the exact same way?
If you could just explain what you mean by oriented. I think that's where I'm confused.
They're the same. You can read the 570 horizontally. It's the same horizontal plane, correct? It's the same straight across, like one doesn't have the 570 upside down. You can read it from left to right, a 5, a 7, and a 0, correct?
Correct.
Thank you. Now, if we can, Mr. Woke, now zoom in and get the largest depiction of each one from a zoom in.
Doesn't it?
Are you saying the difference in how that hair appears is from a different camera angle?
No, I'm not making that conclusion. I'm just saying I can't make any other conclusion because they're from different angles. I don't feel that I can compare the two.
Is it possible that the hair moved when someone took a photograph?
Yes. Can you answer that question?
Again, I just can't make that conclusion because I didn't take the photo and the photos look like they're from different angles.
In your experience, you've taken samples many times of apparent hair, correct?
Have I taken samples such as that? Yes, that's correct.
Has it ever happened that when you're taking a sample, the photographer or someone breathes on it and the apparent hair moves? Does that ever happen? Yes.
I'll allow that.
That's allowed.
I've never had firsthand experience with that. So that if somebody breathed on an item of evidence, that would be something I would note.
Other
Have you ever had firsthand experience of breathing on a piece of hair ever?
That you're speculating as to what could be causing this difference? Are you speculating?
Sustained. I'd like to see counsel at Sidebar for a couple of minutes, please.
Judge wants to have a sidebar. Oh, there's no problem with any of this. Possibility of it moving. Okay, so I remember Mr. Jackson handled this during the first trial. I remember him showing these two photos of the hair and how they appeared to be different. But this side by side honestly makes it even better, because I got the impression these are photos from opposite sides of the car. And so, yes, if you're looking at, if you have something and I don't know, it's shaped like this. I don't know. I need a better. I can't do a very good example. If you're looking at it from one side, it's going to look one way. If you're going to look at it from the other side, it's going to look like the opposite. And so, hadn't necessarily made the best, impression, I guess, that stuck, that like, yes, this hair moved. Okay. And the photos show the hair moved, but this, looking at these angles, it's like one step to the right. That photograph on the left is like one step to the right from the one on the left. He's like just slightly to the outside of the wheel. Versus straight on, and it moved that much. It's far more compelling in the presentation this time than it was last time. He let her invite him to do the side by side. Oh my Lord. Oh. This is somebody who is just so comfortable dealing with experts. Experts can be some of the most obnoxious witnesses on the stand. Oh, they can be real self-righteous. They can be real, think real highly of themselves and their opinions. And they can be very experienced witnesses, testified many, many, many times. Understand the game, familiar with the game. They can be very hard to cross. But this is fun. He's letting her invite the evidence he wants in.
Your Honor, with the court's permission.
Sure, you can put it back up on the screen.
Thank you. Thank you for your patience, Ms. Hartnett. Do you have any explanation that you're certain of with regard to those two depictions?
Regarding what, sir? I'm sorry.
The two depictions
Why
that
they
are up
look
on the
different?
screen.
Do I have any explanation of what?
Of those two depictions.
The difference
that you're
between
certain
them?
of.
Those are both a depiction of the same apparent hair that I collected from the vehicle.
Thank you.
All right, so turn on the lights, please. Jurors, I'm told with counsel this is a good place to break. So we're going to break for today. Please, those same cautions, do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Please be very careful with your social media use. We'll see you tomorrow. Ms. Hartnett, we need you back tomorrow as well.
We need you back tomorrow as well. They're not done.
Please rise to the jury.
He's coming back tomorrow. Why ending the day a little early?
Yes, can I see counsel at sidebar while the jury's filing out, please?
Don't know if anything will go back on the record. We'll just go ahead and take that fan off the screen. Oh, I know. I'm an Alessi super fan. I really am. He's just such a skilled lawyer, guys. He is so skilled at the technique of what you're doing here. The ability to turn the Commonwealth's evidence into your evidence, the Commonwealth's witness into your witness. This is like one of the holy grails of trial practice, and he's got it down. He makes it look easy. Makes it look easy. Let's use their own exhibits. Let's use their own exhibits to make our points. Let's get you to invite me to show you what I already want to show you. He already knows how to do it. Wolf knows already how to do the side-by-side, blow them next to each other. Yes, you can. Indeed, you can see them side by side. What a setup. Using her to illustrate the point where her answer doesn't even matter. Her answer doesn't matter. I don't care if you have personal knowledge of the wind speed at the time, because it's up on the screen. It's in evidence. The jury has already heard it. And they know what that means. They don't need your actual answer, whatever explanation you're going to give for this hare surviving the 60-mile round trip drive in the snow, in the sustained wind, in the worst blizzard in January in Massachusetts state history, and yet was easily removed with tweezers. No resistance at all. No resistance. But apparently so insecurely attached that it's in a different position in two different photographs. Sure looks like it. Sure looks like it. Flipped over. It kind of mirrored itself. Went from a reverse C to an actual C. Well, boy, what did we get after lunch? We got to see the other mystery pieces of things that are in the bag that don't belong in the bag. Glassine envelopes along with a little piece of red taillight with a label on it. What looked like a black piece of plastic and a long, possibly silver piece. Learned about her swabbing the exterior portions of the taillight to collect potential biological material. She just swabbed it all on one swab. Didn't think there was any forensic relevance to what part that she swabbed mattered. No reason to distinguish between parts of the taillight when swabbing it. All went to the DNA unit. She collected a swab from one of the solo cups, but it was never tested, and we don't know. She doesn't know which one she pulled it from. Look through those photos of that clothing. Yeah, guys, the markers all over the right arm of the sweatshirt. The blood all over the front of the sweatshirt. Okay. Lots of blood on the front. Shouldn't be there. But then all of these puncture-looking holes. Looks like a puncture and a pull when something is a woven material like this, or a knit kind of material like this. You snag it on something. How many times? How many times have you caught your shirt on something, snagged it, and it looks just like this? You get a little hole and a little bit of loose thread pulling back out towards the exterior. Kind of looks like that, doesn't it? So we just saw a close-up of one, but looks like a puncture. It's not a slice. It's not like clean cuts to the fabric, to the threads. Nothing like that. It's a snag, puncture and a pull. Orange t-shirt as well. Blood on the front. Very distinct blood spots on the front. So not a situation where we've got all this blood on the front of the sweatshirt. It's not a situation where it seeped through and stained the t-shirt underneath, because it's not in the same area, and it's in its own, specific, small, discrete pattern. Why is there blood on his t-shirt like that? When did he have his sweatshirt off? Did he have his sweatshirt off to get blood on his t-shirt that didn't seep through the sweatshirt? Blood on his t-shirt that's not supposed to be there. Jeans with stains on both sides as well. Probably shouldn't have stains on the front. They are red-brown stains. She did numerous tests on them. What did we not hear? We did not hear anything about grass stains. Nothing about grass stains. Oh, more about debris collection. Scraped it off with a spatula, stuck it in a glassine bag, and she put the material from the t-shirt in the same bag as the material from the sweatshirt. Why does this matter? Because if you're going to try to attribute pieces of tail-like plastic to the outside of John's sweatshirt as some kind of proof that there was a motor vehicle accident, then you need to segregate that from other potential sources of that plastic, such as his t-shirt. Why would you do that? Looks like they've killed the stream. So I think they are done for the day. Yeah, it's done. So they didn't isolate it. And then who knows what came from the jeans. Yikes. Everything went over to the trace unit. Then we got our Alessi cross-exam. Guys, they stipulated to exhibits 152, 153, and 154, and I don't think we've even seen those yet. Don't know what they are, but yeah, that tells me there's more we're getting into here with this cross-examination of Maureen Hartnett. Yes, she understood, in fact, was informed that Michael Proctor was the lead detective. That denial is just, it was always going to age badly, being so insistent on the semantic distinction between case agent, case officer, and the lead investigator. Everybody's happy to acknowledge that he's the lead, except for Sergeant Bukhenik. No idea when the scratches and the dent were there. No evidence of it. Can't date it. Can't draw conclusions about it. Could have preceded January the 29th. So that's an issue for proof beyond a reasonable doubt. Looked for tissue, blood, and biological material. Saw no visible stains or tissues of any kind on the vehicle other than this apparent hair. Look at the arm. Can't tell if the wounds are from a motor vehicle collision. That's beyond the scope of her expertise. She doesn't do that type of analysis. It doesn't matter. I mean, I don't think that particularly matters. But what does? There's a little foreshadowing here, a little clue that's dropped. Did you investigate the top of the lift gate? Nothing notable regarding that area. Nobody asked her to examine that area. Well, that's peculiar, isn't it? Because Mr. Brennan told the jurors very specifically before the jury view, make sure you pay attention to that little protruding part over there in the lift gate, the back hatch door, little piece that sticks out. Guys, that's going to play some role in the Commonwealth's theory of the mechanism of this accident, and it's going to be evident that is brand new. It's a brand new theory because Maureen Hartnett was not asked to look at it and, in fact, didn't observe anything remarkable about it at all. It's a new theory. Of course, we already know Trooper Paul didn't say anything about that. But that is, I think, a foreshadowing Nobody brought it out as like, hey, this part might have hit John where? Back of the head? Is that going to be the theory now? Surely not. Surely not. But we'll see. But nothing remarkable about it to catch her attention, and nobody drew it to her attention at all. Nothing in the undercarriage. The undercarriage, it's a series of tubes. No, that's not what she said. That was some unrelated boomer talking about the internet. It's a series of tubes. No, this is a muffler and pipes, and then some other parts of the car. She doesn't know the other parts of the car. Doesn't matter, just the low-lying areas, the frame, the suspension, the springs, maybe the shocks, the fuel tank often in there, under there, kind of in the middle of the frame, past the crumple zone. Might have a battery mounted under there. Sometimes you got the undermount battery on the frame. You might have like the alternator. You might have the fuel pump. You might have all different parts of the car under there. Doesn't matter. She swabbed all the low-lying areas. Oh, that's of course before you even get to the drive, the drive shaft, the differential, the steering, all that stuff, the rack pinion. She swabbed the low-lying areas or screened them, found no blood. Nothing of any kind underneath the vehicle, including underneath the bumper, underside of the bumper. Odometer reading didn't matter to her, but now I know it matters to Mr. Alessi. Now I know the odometer reading matters to Mr. Alessi. This way that he raised this suggestion, the red-brown stains, if it's blood, it can contain multiple contributors, meaning there's multiple sources of the biological material. I really love this preview because we are going to get back into that with Andre Porto, I believe was his name, and he was the DNA analyst from the lab who testified in the first trial. And he talked about the mixed profiles that were recovered from John's clothing. And the reason why this is significant is because they were specifically testing the stained areas. They were testing areas that came up as positive for blood. This makes it unlikely that a mixed profile is originating from touch DNA, because the signal strength of the DNA result from blood is significantly stronger than the signal strength from skin cells. Could be 10, could be 100 times, could maybe even be more, stronger of a signal coming from the blood. And so if you have a mixed profile of blood, if you have mixed sample that's some blood and some skin cells, the blood is going to dominate that sample. That's what your reading is going to be. You're probably not even going to pick up the presence of a couple of skin cells. So the way you get mixed profiles in blood is blood. Mixed blood, relatively equal signal strength. That's why I think this is significant and where I think he's going with it. That's why it potentially matters. What was the source of those blood spatters out in the snow, out on top of the snow? Been watching this trial for 2 years, and still new things come up, new things come to mind. Didn't cross my mind. Somebody could have gotten a fight with John, been bleeding, and dripped some blood on the snow while they're out there dumping his body out on the front lawn. It could have been from one of the conspirators. Hadn't really crossed my mind, but it's a viable explanation, viable theory. Hasn't been ruled out. DNA testing could have ruled it out, but they didn't do that. So even after all that embarrassment, the ridicule that you're going to take with that evidence collection method, we're just going to scoop some dirty snow up into Solo cups and put them in a grocery bag. Frozen, she said. Frozen? Still frozen in the refrigerator? How cold is this fridge? How cold is this fridge? So it had to thaw, and then she takes a sample of it. All this embarrassment for nothing, because they don't even test it for DNA. They don't even rule out, hey, maybe this is Brian Higgins's DNA after he got in a fight with John. They don't even rule that out. After going to all this trouble and that humiliation. This is how you handle the investigation of a dead police officer, with Solo cups and a Stop and Shop bag. And at the end of the day, it didn't even mean anything because they never tested it. So I suspect that's a little bit of a preview too. That's why he's bringing up multiple contributors. Yeah, they can, because we're going to hear about multiple contributors from red stains to John's shirt, John's clothing. And so, could have been one of those contributors. Could have been one of those contributors that left a little blood out there on top of the snow. Hadn't even crossed my mind. Tell you get something new in this case all the time. She, of course, has no idea who has the cups, what went into the cups, what came from where. There's just no real documentation or orientation of this at all. The video, she only knows that the officer who helped her remove the taillight housing was wearing gloves because she saw the video on Thursday. And she wanted to see it because she just recently found out there was one. How did you find that out? How'd that come up? By the way, there's video. How'd that come up? Why do they have Sallyport video from February the 1st? After all of these explanations we've been given about what they took, what they downloaded, what they didn't, what got overwritten. Why do they have this? This is should be causing the judge some grave concerns, and yet, of course, we're not hearing any hint of that. Didn't find any glass on the inside of the taillight. Well, she doesn't know what glass is. Doesn't know what glass is, but bottom line, doesn't really matter. If there was glass that was part of the taillight, that might be there, but otherwise, he pulled out the exogenous. No exogenous glass. It came from an external source, exogenous. You hear about this with, most commonplace you probably hear this term is with doping. They're distinguishing between endogenous testosterone, what a human body naturally produces, and exogenous testosterone that you might inject into your body for certain performance-enhancing purposes. They can distinguish between them both sometimes in molecular structure and also just in quantity. No exogenous glass in the taillight. Nothing that was noted. Bottom on, I can't ID stuff as glass. Well, but you can ID apparent glass, can't you? Because you did. So that seems to be a foreshadowing too, but I don't know where that is going. Is that going to the ARCA theory that they tested about possibly a tumbler, possibly the tumbler was thrown at the taillight and shattered? Was consistent with the damage they testified in the first trial. They were able to create a cannon, a tumbler cannon, and shoot it at the taillight at a speed that was sufficient to cause the type of damage that was seen in the Sallyport. Did it leave glass in the taillight? Perhaps. Wonder if it did. Just a foreshadowing, maybe, of ruling out one explanation for how the taillight came to be in that condition. Maybe. It seems to be a foreshadowing, but we're not sure exactly what of yet. Yeah, she's going to tell us about touch DNA. She knows just enough to tell us what we need to know for our purposes. Skin cells. So yeah, you touch things, you can leave skin cells. That's all the jury needs to know. So you can touch a tail light, especially the exterior part of a tail light, and leave skin cells. But she has no information of any DNA on the inside of the tail light. Would the inside of the tail light have come into contact with John O'Keefe's body, specifically probably his arm? If this whole mechanism here is supposed to be his arm is out, car hits him, taillight hits him, shatters, blows up everywhere, cuts his arm. Is his arm going to come into contact with interior portions of the taillight? Seems like it probably would. Wonder if we'll get some expert confirmation about that. But just touch DNA on the exterior that would be consistent with walking by and touching the taillight. I mean, frankly, it's, you know, it's not just skin cells. It's not just touching. Studies of sitting in a room, having a conversation with other people like 6 feet away from them, and your DNA ends up all over each other. It's not just touching and not just skin cells, but he's making the basic point. It's not very good evidence. Touch DNA on the exterior portions of the taillight. Not particularly compelling because you don't know how or when it got deposited there. Especially if you don't have any blood or any other type of body fluid that might give you a little bit of a better story. The reflection. The reflection. It was a reflection. Of course it was a reflection. As soon as he pointed that out, oh yeah, it's really obvious that's what it is, because there's not 2 bumpers on the car. There's one bumper and a shitty quality photograph where all the black is washed out except for this nice reflection that you were able to pick up, because they don't know how to deal with lighting either. They don't know how to deal with exposures, and they don't know how to deal with lighting. What did they teach them at this photography class? Like how to point the camera and push the button? What did they teach them? Guys, I mean, this is sort of embarrassing. We got in Delphi, we had a forensic crime scene photographer present, you know, a lot of the evidence in that case, a lot of the crime scene photos in that case, taken by a very highly skilled, very well-trained, very experienced forensic photographer. And just the difference in quality, it's night and day. It's night and day. I mean, this looks like photography of the quality where you told the guy it helps to have the lights on when you take a photo. And like, that's the level of detail that he's given for how to get perspective, how to get detail. Knows nothing about light and exposure and reflection. Boy, she fought that. I don't know specifically that it is. Well, we're looking at it with our own eyes, and everybody instantly went, oh yeah, it is. Especially now when you're going to go point out that reverse B on the label. Honey, you're going to try to justify this by saying you might use the same letter on different labels. It's not the same letter though, is it? Because it's mirrored. Oh, yikes. Major ding to the credibility right there. Yeah, it's important to know what I'm looking at. Yeah, indeed it is. It's important to know what you're looking at. That's why they're supposed to take decent photographs in the first place. You're supposed to have it in your notes Why would it be in your notes if there were two spots on the bumper? Why would that be in your memory? Yikes. The glass was just resting there. It wasn't embedded in any way. I was looking back through the notes from opening. I didn't see anything in the opening where he said embedded, but I feel like that's out there. Maybe chat remembers. Somebody made a claim that the glass was embedded in the bumper. Nope, it was enough to remove with tweezers. Show us the Sallyport video where we literally watched the snow melting off that back window and falling. Yes, where would it fall? It would fall. It's not going to jump over the bumper. It's not going to jump over the bumper off the window. It's going to fall straight down flat right onto that bumper, right where that glass is. All that snow on the back. Great visual. Fell right on the bumper. 30 to 40 miles between Dighton and Canton. So the car took a 60-mile round trip. Doesn't know anything about the wind speed. It doesn't matter. We can show you because it's in evidence, and your answer doesn't matter anyway. The jury's going to get it. She doesn't know when the glass appeared on the bumper. Doesn't know when the hair appeared on the quarter panel. Hair that was not affixed in any way, but also went on a great adventure. It was easy to remove with tweezers. It gave her no resistance whatsoever. And yet in those two photographs that are taken within a step of each other, taken within about a step of each other, it's in the opposite orientation. But she has no experience, no personal experience of hair being moved by breath. So can't really say if the photographer's breath is what caused the hair to move. Oh man, what is the jury thinking right now? This is their case, guys. This is their evidence. This is the facts, science, and data that are going to prove, according to the Commonwealth, that there was a collision here. The miracle glass and the Spartan hair, okay? The hair of Thermopylae. It just hung on through 60 miles, but finally succumbed and gave up the ghost right when they're there taking the photograph of it in the Sallyport. Alas, overrun by the enemy, but its heroic memory will not be forgotten. It will be sung of in centuries distant. So Judge Bev is getting a little annoyed with how this is going. I think what he's doing is proper. I suppose there are points where he's repetitive, he's repeating, he's saying in a different way. Things that she's already answered. Mr. Brennan does that all the time. Does that pretty constantly. But it doesn't shake him because it doesn't matter. He's been making his point. He has turned the Commonwealth's evidence into his. He's gotten her to volunteer for this presentation that is even more helpful than what we've seen before, when the defense lawyers are in total control of what the evidence gets to see, what evidence the jury gets to see. Got her to volunteer. Why don't you show me side by side? Great. Yes, let's do just that. And we haven't even gotten to those exhibits that were stipulated to at the beginning of the cross-examination. So yeah, she's coming back tomorrow, and we know there's more coming. We know there's more coming. How much more damage can he do? Like, what else did she even do? What else did she even do? We going to get back into the clothing, perhaps? Maybe the clothing. She was pretty vague on her direct examination about any type of testing, swabbing, etc. that she did on the clothing. So perhaps we're going to get a little bit more detail about that. Learned something new today. I didn't know that the confirmatory test for blood can sometimes confuse ferret blood with human blood. Huh. Seems odd. Wonder why? No idea. Interesting piece of trivia, guys. File that one away for your Tuesday trivia night. That one could come up. Never know. What can be mistaken for human blood in a confirmatory test? Huh, ferret. Who knew? Who knew? Not pig, though. Pig is what matters for our purposes while we're talking about foreshadowing. Yeah, the swabs on that arm of that sweatshirt. Yep. Suey. Didn't follow up in any way, Mr. Brennan did, about the jeans and any examination of those, other than just it had some dirt and debris on it. Didn't note specific locations. So in other words, you didn't test the blue or the red-brown stains to see if they were grass stains or dirt, like Trooper Bukhenik had suggested. But you didn't get into the details of those tests at all. So I kind of suspect Mr. Alessi is going to do that. Didn't talk about the shoes, guys. Oh, I know he's going to follow up on that. I know he is, because he's got an eye for details. And blood on the top of the shoes. Very difficult to explain that. Not when he's supposed to be lying on his back, incapacitated from being hit by a car. Should not have blood on the top of your shoes. If you can come up with some kind of way to explain away blood all over his front, the different pattern of blood on his t-shirt than is on the sweatshirt, the lack of seepage through the sweatshirt, maybe you can come up with an explanation for all that. The blood down the front of his pants, because it's when the paramedics were working on him, for example, or Karen lifted the shirt and he shouldn't be actively bleeding still at this point, but that aside, we've come up with some explanation. It was from the moving, the transfer. That's how blood got on his front. Not on the top of his shoe, it didn't. Not on the top of his shoe, it didn't. Got on the top of his shoe from gravity. Meaning his head was over his feet. Meaning he was in an upright position when that blood was flowing. And that sure seems consistent with those injuries on his face. It's what it looks like when you bleed all down the front of your clothes, because you're in a fight and your eye's cut and your nose is all soft and mushy and red, and your lip as well, laceration inside his lip, side of his nose. That stuff is bleeding down your front. That's what it's going to look like. Little droplets, little run patterns, maybe even a little droplet on the top of your shoe. So I know Mr. Alessi is going to hit on that shoe. Oh yeah, we're not going to forget about the shoe. Well, guys, I mean, not the most dramatic day ever, but we had some fun. We had some fun. I mean, did they land anything today? Did the Commonwealth land anything today? I don't know why they called the crime scene services people to just highlight all of the times the crime scene services was not called out to do anything. You know, those important times. I don't know why you're showing me that you carefully photographed John O'Keefe's car on February the 3rd when there should be nothing at this point in time in the investigation that leads you to think John O'Keefe's vehicle has anything to do with anything at all. Unless you were looking at the ring footage and saw Karen hit it with her car. You shouldn't even be looking at it. You took all that care to document John's car that is not supposed to have anything to do with this incident, exactly like you didn't do with Karen's car when you seized it. I'm not sure I'm seeing the upside of calling these crime scene services guys. I really don't. You can get the photographs in other way. If they're just trying to bolster, oh, there were more people present for the search, so, you know, would have to be a conspiracy of everybody. No, I don't think so, because the whole crime scene was unsecured for days. Somebody wanted to sprinkle some taillight out there. Taillight you're not supposed to be finding on top of the snow anyway. And yet apparently you did. This is a mess. This is a mess. Of course, the niece that we didn't get to see, but we saw a couple of the reports about that. They started fighting more after Aruba. I can understand that. Understanding, having the frame of reference from the last trial about what happened in Aruba. Yeah, I can understand you might fight a little bit more after that. Karen got louder when they fought. Okay. Nobody heard any screaming, yelling, anything like that outside of 34 Fairview, did they? So, is that even really helpful? And now Maureen Hartnett, she's supposed to be delivering, the coup de grace, the critical forensic evidence, facts, science, and data. Mr. Brennan promised us an opening. And we have no blood on the car. No blood on the car. We have, the miracle hair and the miracle glass. Very well illustrated how silly it is. The idea that somehow survived all of that exposure when she was able to remove it simply with tweezers. Came right off. Wasn't difficult at all. Provided no resistance. Didn't even put up a fight. The fight was all gone at that point. The hair of Thermopylae had exhausted its ability to cling to that position. And all of it, she's, acknowledging no idea when. Can't say when. Can't say when it got there. Can't say how it got there. Could have preceded January 29th. Could have come thereafter. The problem with all of this, any of it could be after because they didn't document her car. They didn't document her car. I don't know that somebody didn't walk up into it in the Sally port and, whack it on the top of the lift gate with, tire iron or something, dent it and scratch it. We don't know that because they didn't document it when they seized it. Seems like yet another nothing kind of day for the Commonwealth to me. Not seeing a whole lot of progress being made towards that proof that John O'Keefe was hit by a car. Well, let's get back to your comments and questions, guys. See what you guys have been noticing today. Aaron White, the defense could use a brief strategic cross of the kids to send the message to the jury how despicable the Commonwealth calling them was. Do you think that they achieved that with what they did? By kind of reminding the kids about, the niece about, you were close to Karen once. You looked up to her. You thought highly of her. And now you're calling her the defendant? Perhaps that message has been sent with what they did. Summertime, what footage is there from Karen's route home confirming times? We could extrapolate what time she left the Alberts if we saw video from the community. So this this is also unclear. We don't necessarily know what route she took home. There had been a little bit of a controversy from the first trial because we heard all about the missing Canton Sallyport video, but there is also video that is missing from the Canton Public Library. And it's like, I want to say about a 10-minute period, 12, I don't even remember now, covers the 12:30 time frame. It's not the only route that Karen could have taken to get home, but it is a possible route she could have taken to get home. And so there's, for some time been speculation, well, that if she went that way, perhaps it would have shown her tail light. So that's an explanation for why that footage is also missing. But another theory of that dealt with Allie McCabe, who came to pick up Colin Albert, according to the text messages. This is what we were told in the first trial, and that perhaps the missing library footage is more about concealing Allie McCabe's whereabouts, the timing of that, and so forth. Not really clear. We just know that there's missing video from the Canton Library for some inexplicable reason. You would think, given the era that we live in, surely there is surveillance video all over this town, and there could have been a canvas, and it could have been located and identified, and yet there's again remarkable lack of curiosity about that. Not even apparently going to the other houses on John Street at the corner, whatever, seeing if they have ring footage. Might show the car passing by, might show the condition of the taillight. No curiosity for any of that at all. So as far as I am aware, no, there's no video of her route home. That's part of the issue. It's part of why they're stuck with the phone data and the Wi-Fi connection to try to establish the time frame, because they don't have video. They're remarkably incurious about seeking it out. Now, the following morning, they went and got a ton of video of her car all over that town, all kinds of different places, different times. Got it for that morning, but the night she went home, they didn't. Peculiar, huh? Oregon Joe went through custody battle as a kid. Court didn't have me come talk about abusive father, stepmother. No way jury will like Commonwealth calling kids. Anybody who's been through family court with kids is going to, I think, look at this with a real stink eye, because it's one of the first things you're told. And most places now in a like a dissolution, if there's kids involved, you might have to do some kind of like informal counseling or a parenting class. They just want to make sure that people understand how to get through a divorce without damaging your kids any more than necessary. And one of those that's real crystal clear is that this is not your kids' fight. It's your fight. Don't drag your kids into it. Don't put them in the middle of it. They're kids. Let them be kids. They love both parents. And it is not in their interest to try to interfere with that, try to damage that. It's very, very selfish and very damaging to a child to put them in the middle of their parents' battle. So I can't imagine it sitting well with the jury, because anybody who's gone through a divorce with kids sitting on that jury knows you got to keep your kids out of it. Here's the Commonwealth now putting the kids right in the middle. No, healthy people, good parents want to protect their children. You don't send your children out to do battle for you and then hide behind them like they're your shields. Healthy parents don't do that. You protect your children at all costs. Katia Kane, this ZC is like a freaking robot. I think cross-examination is like a freaking robot, and Lally dry and boring. Well, we're back to good old Lally giving us the repetitive questions. Everything is with respect to the run-on questions. Like, he tries to be so detailed, but he's got to like draw the map while he's asking the question with respect to everything, in regards to everything. Very, very boring, but that's That's what Lally can be trusted with at this point, apparently, is the crime scene services investigators that probably shouldn't have been called in the first place. Don't know that this gained you anything, and I do think it cost you a little bit. Hey, Brown Berry, asking for my law school applicant kiddo. Do you recommend this as a good case for self-study? Oh man, this is you're not likely to have a case like this in your own practice. This is not a good case from the standpoint of like what's typical, but it could potentially be a good case in terms of just so many different issues that it presents. Issues with the evidence, issues with bias, issues with the mistrial, the double jeopardy, the processes. I mean, you've gotten a real taste of a lot of what the criminal justice system has to offer, all in the context of one case. So it's very informative that way. Definitely don't look at this as like a case to study because you might experience a case like this. You probably won't. Heaven help you, you never do. But it is good in the sense that it gives you broad exposure to a lot of different issues that come up. Cell phone forensics, accident reconstruction, just so many different subject areas and legal issues and all that. Karen and Mrs. O'Keefe match. P.S. I enjoy your commentary. Are they wearing similar colors today? I didn't notice. I didn't pay attention. I don't really pay that much attention to the family in the gallery most of the time. I don't know. I recognize the behavior is something that the jury is going to see, and so if they're, for example, staring down the defendant, staring down Karen, glaring at her, whatever, reacting to the testimony, that is stuff the jury is going to see. But I don't know. They're not really my focus. To me, that's a little bit of a sideshow because it doesn't matter what they think. What they think is largely irrelevant. They could think Karen is literally Hitler and firmly believe that she's guilty, and if she didn't do it and the evidence proves she didn't do it, what they think and what they feel and how they act, it doesn't matter. So I tend to not focus on that too much, but I'm human. I notice it from time to time, and it certainly has come up in the context of this case. Josh H. KR was yelling louder than JJ. Why was JJ yelling? Hey, good question. Good question. Why was he yelling at all? How did this fight come about? You're not going to ask the kids that. God, it's so not the kids' business. Good point, though. All you're doing is highlighting, both people are yelling. You don't say. Oh, now you've made this less complex. Thank you. Any suggestions on how to move in law paralegal as a first step? 15 years in HR, aka avoid litigation. You have great real life experience. You already understand. That so much of what is out there in terms of legal obligations and requirements and rules and so forth, they are there because of lawyers, because a lawyer will sue you if you don't, in fact, have this rule or practice or whatever. It's the case for so much of everyday life now. I mean, one of the key examples that always comes out in my mind, because we have an ER, a retired ER doc in the family, medicine. So much of medicine has nothing to do with what is in your interest, what is going to treat you and make you better. It's all about lawsuit avoidance. Example that we're frequently given about that, CT scans of children's heads. Kid falls, bumps their head, maybe gets a little headache, take them to the doctor. They're going to order a scan of the kid's head. It's almost certain to not be a skull fracture, a brain bleed, any kind of injury like that. The CT scan is going to increase the kid's lifetime risk of getting some type of cancer. So from a cost benefit standpoint, you probably wouldn't order it. But the risk of, if this is the one in a blue moon scenario where the kid does have a brain bleed or a skull fracture or something like that, and you didn't order the scan, you're going to lose, massive amounts of money. It's going to be a big lawsuit. You're going to lose a ton. Jurors award lots of money for injured, hurt kids. So it may not be the medically prudent thing to do most of the time. The kid's fine. Kid's pupils are good. Kid's talking. Kid's alert. Kid's been walking around for an hour. No effects of any kind. Kid hasn't collapsed. All these things that would normally probably rule out needing to do that. Just keep an eye on him. And if anything changes, bring him back would probably be the normal advice. Nope, you don't want to get sued. So you're probably going to order that scan, even though it may not be in the kid's best interest. So you already have that awareness. If you're interested in pursuing law, just look at pursuing law if you want to do that. Look at going to law school. Why not? You can. Look into it. Look into the LSAT. Maybe take a practice LSAT. See if it fits your skill set, your way of thinking, and things like that. Paralegals are a massive part of the process, under-recognized, underappreciated. They often carry a lot of the weight, both in terms of just organizing the case, managing information, details, sources, planning what needs to happen next, identifying steps to progress the case through an investigation, but also a lot of the legal work. Paralegals are responsible for. So they're doing a lot of what lawyers should be doing, a lot of the same skills. They're just not getting paid for it. So if you want to and can do that kind of work, dude, just go to law school. Be the one who gets the big bucks for it. My thought about that. Pretty much any paralegal, I might suggest that if you have the ability, you're already doing the stuff that the lawyers are supposed to be able to do. They go to law school to learn how to do. Go to law school and let that be you. BB, you are by far my favorite court day streamer. David Yanetti is done playing nice. Love it. Well, he's very he's very targeted. That's what I love about it. So he's not nice. David Yanetti's never really been a play nice guy. I'm sure he was nice to these kids, but it's just not his style, is it? He's not he just always comes across as very direct, very, very gruff. He's got that pointed way of answering his asking his questions where he ends it with correct. He's putting the words in your mouth. And so there were no other you don't know how long Michael Proctor was there in the Sallyport alone with the vehicle. And so you don't know, correct? And so you don't know if anybody else had access to the vehicle either, correct? It's very direct, and it can read as a little bit aggressive, but some of that may just be to us non-massholes. Us West Coasters out here, we tend to be a little more chill from what I hear. Here things might be a little different over there in the Boston area as far as the culture. So to my ear, my eye, David Yanetti really never plays nice. He's always a little bit on the aggressive side. But I think he was on with these cross-examinations. They were focused, got out what he wanted to get out. Even if the judge isn't going to let him do it. Hey, she hasn't told you what the problem is. I don't know if the problem is foundation or the form of my question, so I'm going to keep trying. Then she's going to call the sidebar. And at that point, okay. But the jury's already heard what I'm asking about. Doesn't really matter that much anyway. They're going to hear about the relationship between Kevin Albert and Michael Proctor. That's going to come up. The fact that they can't bring it up with cross-examination of Zachary Clark at the end of the day is not going to matter. It's not going to matter one bit. But he tried. Right on target with the photo of the Traverse taken on February 3rd, 5 days after January the 29th. Did he on purpose say 5 days prior just so that they had to correct him? No, it was 5 days after. Oh, thank you for correcting me 5 days after. And now we've said it multiple times. Help cement that. I don't know if he did that on purpose, but it certainly worked out well. Yeah, 5 days after they were out there photographing the Traverse when they didn't do that with Karen's car at any point. And why are you even interested in the Traverse at all? Feel like that's coming. That's a question. Why would you think this Traverse has anything to do with anything on February 23rd of 2022? I don't know. If only there were a lead investigator we could ask about that decision. Oh, the Commonwealth's not going to call him? I wonder why they don't want us to be able to ask that. Well, I guess we, the defense, will call him. I love where this is going. So yeah, he was on today. I enjoyed David Yanetti's Cross. It's very selective, very targeted, focused. It's the kind of thing I like to see in a cross-examination. CNO, can you explain what the defense can legally bring up when they call Higgins, the Alberts, McCabe's, and Proctor? Well, generally anything they have personal knowledge of. Generally speaking, anything they have personal knowledge of. It's what witnesses get to testify about. So, Proctor, anything he put in any one of his reports will go to Bowden, potentially. It's available to question him about the investigative decisions he made, the steps that they took, the steps that they didn't take. His discipline is going to be on the table. That's allowed. His other communications, it's on the table. It's allowed. Anything he has personal knowledge of. Now, they're prudent to limit it to stuff they can prove. If you just think something happened, but you don't actually know, it's probably not a good idea to bring it up in cross because you don't have any way to back it up. But when you have the text message between Courtney Proctor and Michael Proctor, where she says, Julie Albert wants to give you a gift, and he says, give it to my wife instead, something along those lines. Yeah, you're going to raise that for sure, because you're going to be able to stick that text under his nose and get it in evidence if he denies it. So anything they have personal knowledge of really is on the table. Anything that they have previously said, any prior versions of events that they've given, they can be questioned about all of it. So fairly broad scope. Z, KR had no preparation plan for kids, but loved KF and PF. KR set up trust for Meadows' house they shared with parents, so they didn't worry about mortgage and eviction. I remember hearing this. I don't know anything about the details, but I do remember hearing about that because Karen is what? She's a financial services person. And so they often, people people do different things in financial planning and whatnot, but it's not uncommon to be involved with things like succession planning, asset protection, and stuff like that. They're familiar with trusts and LLCs and different ways that property can be held because it can have very different tax implications is often the common reason why that comes up. They're going to know the difference between if I have an individual retirement account and I name my spouse as my beneficiary versus I name my kids and then my spouse survives me. They're going to know what the different implications are of that. And they have different tax implications. And so it's part of what financial planners do a lot of the time is just help sort all that out so that good decisions can be made. One thing about doing a trust, takes it out of probate, and just may provide a little bit different protection for the ultimate inheritor of that asset. So doesn't surprise me at all that she would have that type of knowledge and that she would use it to assist this family. Don't know much about the details though, but I have no reason to think she didn't do a lot for those kids. Evidence so far tends to substantiate that, regardless of how she felt about it in her own, private heart of hearts. Yeah, she might have resented it. She might have not liked it very much. I know I wouldn't. Never wanted kids of my own. I would not be thrilled about getting into a relationship with somebody with kids. Nope. If I did it, I might be venting in my private communications with people that I trust and need to talk things out with. KIU, aka Kirstine. I live in Denmark and our justice system is so far from US. Accused suspects are anonymous until a guilty verdict. It's illegal to lie to a suspect. We aren't perfect, but fair, in my opinion. I'm always fascinated with the different judicial systems. The one that I learned about, I guess I got most familiar with as a kind of a foreign system was the German system. And I learned about that because my parents lived in Germany for some time when I was younger. And so what I learned is Germany has a ministerial system where the judges, there's usually three of them. In a German trial, there's three of them, and they act both as the decision maker, but also as the investigator. It isn't like the adversarial system we have in the US where the judge is just a passive recipient of whatever the parties present. The judge in Germany is actively involved in, I'm going to subpoena this evidence. I'm going to hunt this down. I'm going to direct what information ultimately gets presented to me to make my decision. I found that very fascinating. I remember where else? I think it was Australia. Somebody was telling me about in Australia where the initial trial is decided by a judge. So the facts, guilty, not guilty, are decided by a judge. But when it goes up on appeal, there's a jury that decides have all the processes been followed? Was it legal and so forth? And that's exactly backwards to how the US does it. It's exact mirror image. We have the jury decide the facts and then judges review the legality of the process. So I always find stuff like this fascinating because there really is no one right way. There's a lot of different ways and there's good and bad things, I'm sure, about every system. The anonymous until a guilty verdict, I think there's a lot to be said about that. I'm pretty sure the UK is real similar. There's a lot of protection when it comes to reporting on pending criminal cases and the type of information that can be released. Probably difficult to reconcile that with the First Amendment in the U.S., the public access to cases, and of course the right of the press to report on information. So it's probably a fundamental difference there that can't be overcome. But is it better for it to be anonymous? Maybe. I can definitely see the upsides to it. And the illegal to lie to a suspect, yeah, I'm generally going to see the upsides of that. The downside to it makes it harder to elicit confessions from people. I want it to be hard to elicit confessions from people who didn't do the crime. I want that to be hard. I'm fine with it being, hey, no licking. I'm fine with it being a little bit harder to elicit confessions from guilty people as a trade-off. Because if you're already trying to elicit a confession from a guilty person, you should probably have pretty good evidence against them. Your case shouldn't be hanging on, can I get this person to confess or not? It should just be the cherry on top. So those things both sound very good to me. Sound like good features of a criminal justice system. Marianne, do any of them think this was mentally okay for the kids? Let them be kids and keep them out of this. Preach. Preach. They should never have had to be dragged into this in the first place. I see people, people will say, I'm sure now, how old is the niece now? She's like a junior in high school. She's an older child, but still a child, legally still a child. Like that's, not so bad. It's okay. She's 17 or whatever. No, I mean, you're still a child, you're still young. And all of these important events occurred when you were much, much younger. So you're kind of forcing your child self to be involved in this. No. Kids, you should be protecting your kids at all costs if you're a responsible parent. Can't help you, Rhonda. Does the niece's testimony imply Aruba is coming? I don't think so. I'm not sure. We know that motion is still outstanding after originally saying, oh no, we don't have to address 404, the defense's 404B motion pretrial to exclude the Aruba stuff because it's irrelevant. It doesn't tend to establish anything. And Hank said, we don't even have to deal with this because I don't intend to call the Sullivan sisters. Now we have this new motion that got filed, reconsidering that. Nope, on second thought, I am in fact going to call the Aruba sisters. And he's trying to suggest that the defense has somehow, caused this, opened the door. No, not buying it. It's still a terrible theory. It was because Aruba came out in the text messages with Brian Higgins, but the text messages weren't offered for their truth. He's trying to argue I need to rebut that now. No, you don't. It's not in front of the jury for its truth, and they were specifically told that. They were given that cautionary instruction. This is just to show what information was available to them, to the investigators, not that anything that was said was true. So there's nothing to rebut. But that was the lifeline he clung to. His justification for changing his mind. No, I do in fact want to call the Aruba sisters. We don't have a ruling on it, so I don't know. I see no reason why this motion should not be argued and decided in open court. There's nothing confidential about it. Like, for example, when we had the argument on whether Mr. Alessi was going to be able to cross-examine Jessica Hyde on that Maryland case where she was found, her methodology was found to be unreliable. We do that right in open court. There's no need to do that at sidebar. So I expect that. I think we should know when that decision is made and what it's based on, what the arguments are. So I don't think this is really a given, but maybe that's just Hank's way of trying to slide something in, open his own door. Really not sure. ASMR Kitten, born and raised in Norfolk County. It's hard to watch this case again as a taxpayer. Love the commentary, AB. Appreciate your daily insight. My condolences to you as a taxpayer in this community. I would be horrified. I really would. I would be horrified, not just because here we are spending all of these resources a second time on this prosecution based on this evidence. For what? For what exactly? But then everything that it reveals as well, everything just about the rot, all does seem to emanate, linger around this prosecuting attorney's office, that detective unit, that prosecutor, a lot of stench. So appreciate you joining us, and hopefully things may take a turnaround. Maybe eyes have been opened as a result of all of this, and great tradition of overthrowing tyrannical governments in the state of Massachusetts. Everage, sorry if asked, do you know if the call records of BA and BH have been disclosed? Can they use them to see who was calling and to whom? They came out in the first trial because that's how they know about the butt dials. The butt dials between Brian Albert and Brian Higgins at like 2 something in the morning on January the 29th. They had both claimed they went to bed, didn't talk to anybody else. After that, Brian Higgins, of course, says he went to the Canton PD first. Then he went home and drank more on his couch before he fell asleep. Didn't talk to anybody, didn't call anybody. Brian Albert went to bed with his wife, had some intimate time, didn't talk to anybody. So their explanation for why there's phone calls to and from each other during those time frames, butt dials. So that is how we know about that. Nick Starrow, Mr. Brent testifies so rarely he has to dust off his funeral coat. I didn't notice it being particularly bad. It seemed like, frankly, one of the better fitting coats that we've seen on a lot of these guys. Yeah, I'm too big of a fan of the menswear guy. I get a little snobby now about that fit. I'm gonna be checking your fit if you're gonna be out there in something resembling a suit. Oh gosh, if you're gonna wear a suit with the wrong color or type of shoes, yeah. If you're wearing the wrong kind of suit with a t-shirt underneath, you're gonna get brutalized. I thought he had a pretty decent fit, but I didn't notice if there was something especially funereal about it. Tanya Garrett with a $49.99 super sticker. My goodness, thank you so much for that, Tanya. Really appreciate that. Appreciate your support. Thanks for being here with us. Josh H., why was John O'Keefe's car moved from where it was parked on 129 before it was documented on 23? Good question. Who moved it? When did they move it? Where did they move it? Why did they move it? Were they using it to run errands? What's the story of the 5 days of John's traverse between January 29th and February the 3rd? We don't know. As far as I know, I don't recall this coming up in the first trial. We did see these photographs, but I don't think there was a lot of communication about any of that. So, good question. Don't think we're going to find out because the Commonwealth isn't calling any of those people, as far as I know. Maybe Paul O'Keefe. Didn't ask Peggy. Don't know who else would know. James Stunn, paintless dent removal services can show up to your house and be done in an hour. Well, we know the car repair guy was there at 34 Fairview on the 30th, don't we? One of the guys who was there at the house when Carrie and Jen took that trip over there before going over to Lank's driveway, forgetting that they went by 34 Fairview and Jen McCabe's house on the way. Yeah, but the car repair guy was there. What a strange comment that was from her, wasn't it? Yeah, I didn't know they could do it this fast. I would, yeah, if it's a small dent, small scratch, something like that, I believe it. I don't really know. I've never done, I don't like the idea of doing auto body work, dent repair. I've tried to pull dents before, marginal success with it. I don't have the right tools. They do things like you get it hot, you like pour hot water over it and then you use like the toilet plunger to pull it out, something like that. Just never had much luck with anything like that. And then as far as paint itself, I don't want to mess with it. I don't want to mess with it. There's too much complexity with auto finishing. You got the clear coat, you've got the paint underneath, you got the metal. Some things you can buff out, some things you got to get down and sand it, and you got to prime it, and you got to redo all that. I don't really know where the dividing line is. I let somebody else deal with that. So I don't really know what can be done. But what I do know is that when I backed into my husband's truck and broke my taillight, it left not a mark anywhere on his vehicle. I do know that. Stormy, no solo cups? You don't collect DNA that way? No, you mean you use a sterile swab that you moisten with water? No kidding. Tell us more. Tell us more about this strange, exotic method. We're only familiar with the solo cups. But you gotta make sure to use those high wind leaf blowers first to really prepare that sample well. Everage, they are trying to bury B with a sympathetic witness and with very boring ones. And there was no snow anymore on February 3rd, if I saw the pictures correctly. If it's warm and if it's raining, yeah, the snow should be pretty well on the way out. Rain will get rid of snow really quickly. Really quickly. Wonder if the defense is going to have photos. I don't know. I did go, somebody had photos posted on X of, here, I can just share this. This is the outside the Canton PD Sallyport when they were doing that testing that they were talking about, the acceleration testing. And you can't see super well. This is being raised. This particular image is questioning whether these tests took place on the same day. Again, could be a bad camera issue, but it sure does look like there's still snow on the ground down here. But then up here, there's nothing on the driveway. Looks like there's just a little bit of residual snow around, some snow still on the grass. But if this is supposed to be February 1st, you know, this is roughly the state of the snow then. I wonder if they've got other photos from the time frame that they can use. That would be a good thing to collect and introduce if that's going to support the theory. This taillight would have revealed itself quite a bit before these witnesses are claiming that it in fact did so. So Barry B, I don't know who B is. Barry B. Bukhenik? Oh, trying to forget about Bukhenik now. Maybe. I could see that being possible. Guys, I am actually going to pause real quickly here just so that I can refill my tea because we do have still quite a few comments in the queue. I don't want to be slurping on my straw all gross into the mic. Not trying to be disgusting over here, but it does happen sometimes. Humans are gross in general. Yeah, biological stuff, man, it's just kind of gross. And yet here we are, these biological beings, we're sort of stuck with it. Anyway, I don't want to get super dehydrated and I don't want to slurp into the mic if I don't have to. So I will be back in just a couple of moments. All right, guys. Thanks so much for your patience. Hanging tight while I take care of those irritating old biological needs. So frustrating being a bio entity sometimes. Perhaps one day the glorious future will liberate us from this shell of cells and strange chemicals and so forth. No, I'm not looking forward to that, but that day might be nigh. I don't know. We'll see. This isn't the time to talk about transhumanism. Let's talk about KIU, aka Kirstine. My son earned his PhD last Friday and he was roasted by 4 professors, and he handled himself with more grace and humility than these corrupt cops. Congratulations to your son. Yeah, thesis defense, PhD thesis defense. Never done it myself. Never had to go through it. Had some friends go through it. It does sound like almost a hazing kind of ritual. Like some of it is it is designed to challenge you. Not knock you off your feet. A little bit of a combat sport. Ask you questions that you're perhaps not prepared for, and some professors do that with a little more enthusiasm for their roles than others. So it's not an easy thing to pass by any means, and congratulations to him for doing that. Frankly, the bar to clear, to handle yourself with more grace and humility with these corrupt cops, I'm sure it's easier to clear that bar than making it through thesis defense. I think you can probably clear this bar if somebody gets your order wrong at McDonald's, and you need to bring it back in and show them, hey, this is what I ordered. This is not what I got. Please. I bet you probably handle that with more grace and humility than we saw from these officers. Lock Hong Express. Higgins had a motive to break a taillight. He might have. Higgins was there. He was there before the car got there, of course. But he had generally unrestricted access to Canton Police Department, as we heard, just from his job. So anytime after it came to Canton Police Department, we have no idea. We have no idea if he was kept away from that car. And it's in his interest for the investigation to look elsewhere, isn't it? Greg, I have this funny theory that Brennan planned to sideline Lally the whole trial until Carrie said, I misunderstood the question. Now he's got to show the jury what it's like to be questioned by Lally. I buy it. I said it. In fairness to Carrie, I get it. Listen to this man's questions. Oh, man. Okay. Even better than his questions. I went back to my notes from the first trial and my notes from the opening statement, and I specifically wrote down the very first words that Mr. Lally delivered to the jury in trial number 1. Hold on, guys, because remember, primacy recency, you're telling the theory of the case, and this is your chance to make a mark. Karen Reed was framed. Remember how that landed? From Mr. Lally. So as your honor was telling you, this is one of the 2 opportunities I will get to address you. What an orator. Yeah, his questions can be an absolute nightmare. So I get it. I mean, I could buy this theory. I really could. Lally's been on, he's like improved his game since the last trial. His questions haven't been haven't been quite as bad. I mean, not today. Not today. They can be, you need like advanced wilderness navigation capabilities to be able to find your way to the end of some of his questions sometimes. Josh H., I don't get, even in snow, how pieces of glass stayed there with all the movement of the vehicle. Karen Reed driving it, her dad driving it, the tow, etc. Yeah, and then the hair, the glass and the hair, it all clung there heroically through all of that. Very difficult to believe, isn't it? A 40, well, okay, what, 37? They said 37 was the maximum gust of wind. A wind speed of 37 miles per hour falls under the near gale category on the Beaufort wind scale. So it's a strong wind, but it is strong enough to cause whole trees to sway, and walking into it can be difficult. It's hard to walk in 37-mile-an-hour wind. And so consider the size and weight of your body. And it's difficult for you to resist the force of that wind. And now this little piece of glass sitting on the bumper, that little hair on the side of the truck. Yeah, it's hard to believe. It's definitely hard to believe. Because these are very small things. They are above, you know, the surface of the bumper. So they're not like protected from the wind. Get a cross gust. Surely all that glass would be gone. It's hard to believe that it went on that journey. John Beattybot, be in troubles, 0 water spots inside housing. That hasn't come up yet. I do wonder if it will. I wonder if that's a detail that Mr. Alessi has spotted and is going to point out. You can see from the photographs, water spotting all over the back of the car. All over the bumper. That's that salt residue. But there isn't any of that on this taillight, is there? You don't even have to ask her what that means. You can just point out, it's all over the back of this truck, but it's nowhere on this taillight. It's not inside the taillight. It's not on the outside pieces. It's nowhere. This taillight is pretty pristine. Yep, that was a good observation that Be in Trouble made. Made some great videos about that taillight. He's like the taillight expert, the taillight whisperer. Nicole Kelly, Duty Ron on YouTube zoomed in another Sallyport vid where you can see Berkowitz touching the car. Could they introduce with a timestamp showing before Maureen H arrived? Absolutely. If the video is in evidence, if the Sallyport video is in evidence, then they can show any part of it that they want to the jury. So I don't know which view it was or which camera or what, but at least ostensibly all that video is in. So yeah, they should be able to. Duty Ron is one of the good guys, and being one of the good guys is not pleased with the behavior of these law enforcement officers. These are the guys that make the good guys look bad. They're the reason why people don't like police, and then you take that mentality to the people who really don't deserve it, who really are trying to protect and deserve. Worst enemy of a bad cop is a good cop. Andrea McBurnett, I sure hope Alessi mentions how far the vehicle traveled and how the evidence magically held on. He sure did. I would love for him to drop a Thermopylae in there. The air of Thermopylae. It just stood firm to the last possible minute, and then couldn't resist any further. Maybe that's just my sense of humor, but yeah, he sure did, didn't he? Went on a great journey. Lawyer Nurse, did you notice how it has no salt residue, yet everything else on the lights, car, windows do? This shows it was not broken outside of Sallyport. Yep, it's all over that car. The photographs show it all over that car. Even in these extremely poor quality, low detail photos that we get because it's a black SUV. When we do get detail, yeah, you can see it very loud and clear, but not anywhere on the taillight or inside the taillight housing. A, appreciate your commentary. Thanks, Andrea. Well, thank you, A. Thank you, AA. Appreciate you being here with us. Appreciate your kind words. OCD Shaggy, the expert seemed concerned with the extra evidence in the box. She had to say it twice to get that point across. Unbelievable. She should be concerned. We had this bag in the last trial. The bag was opened in the last trial. The stuff was put back in the bag after the last trial. Who's moving stuff around the bags and not putting it back in the right bag? If only there were some sort of technique to be able to identify who has access to a particular piece of item and when they return it. If only there were some way to do that. Chain of custody? What's that? It's like this part of the case has gotten so much worse the second time around. Like, we didn't have mysterious extra pieces in bags that aren't supposed to be there. We didn't have that the first time. Now, we had confusion about what was collected when and on what date, and different reports. Like, this report says you found 3 pieces. This report says you have 5. Look in the bag. How many are there? It's something different. We had some of that stuff, but not literally open the bag and there's stuff in there that's not supposed to be there. And it's like permeated different levels of the case. Okay, originally it was the stuff that Tully or O'Hara collected. It was the search stuff. And is it 2? Is it 3? Is it 5? Is it 6? We don't know. It's recorded differently in different places, and then what's in the bag doesn't really correspond with any of that. But now it's like seeped over into the lab. It's seeped over into Connor Keefe. That poor guy now is having to deal with extra plastic in his bag that doesn't belong there. Who's putting stuff in the wrong bags? Who's getting into the bags? If only there were some way to know. Yeah, I mean, she should be concerned because it should be obvious that this is Keystone Cops stuff. This is a disaster. And yeah, it makes you look bad too. You're part of this. You can't explain where it's been or why it's in this condition. Yeah, it makes everybody look bad. Not a good situation. Michael Mud Dragon, Thompson twins. Proctor, can't you see him? Berman. Proctor, is this glove I'm feeling? You're still on the glove. You're still on the glove and the Birming. That's pretty good. Proctor. Haven't thought about that song in about 1,000,000 years. That's a good one. Yeah. Man, the glove. I still like Glove Hurts. I really like Glove Hurts. Very good, very clever chat we have here. Starry Dust is gifted 10 memberships. Thank you so much for the Starry Dust. I happen to know this is not the only time you were gifting memberships. Very generous of you. Thank you so much. Appreciate your support for the channel and appreciate your generosity. And thank you on behalf of everybody who got one of those. Anna Long, did that gal look surprised at more in the bag? Well, it's not supposed to be there, is it? Wonder how often that happens. Maybe we can ask her that on Cross. So you seem surprised. You recognize you knew that stuff wasn't supposed to be in there, and you knew that because the bag tells you what's supposed to be in there, and the bag doesn't say anything about that. And you're extra surprised because you, in fact, bagged that tail light housing yourself, and you know what you put in that bag. So these other items that caught you by surprise. Does that happen often in your experience? You testify in court a lot. You're often called in to describe your testing, identify items that you analyzed, and so forth. Does that happen to you a lot? Did you find extra things in your evidence bags? They won't. I don't think you will, but it would be kind of fun, wouldn't it? Kate, mix up with the shoes and the tail light. Not a good look. Yeah, I forgot about the shoes even. Which shoe are we dealing with here? And why couldn't you tell? Does the bag say that the shoe that they got from the hospital, does the bag say they got it from 34 Fairview? And that's why he was confused about which one came from 34 Fairview and which one came to the hospital? That's my working theory. The problem is the bag, because it looks like he's reading the bag, trying to identify, what he got, where did he recover it from? He's saying this came from 34 Fairview. I'm guessing that's because that's what the bag says. So you just, wrote the wrong thing on the bag, I guess. Just one more really inexplicable own goal when it comes to the sloppiness, the lack of organization, the lack of proper evidence handling. Yeah, I forgot about the shoes. I remembered the extra piece of taillight in Connor Keefe's bag. Alex, could Higgins' low profile this time be because he made a deal with the feds? I mean, the feds must have seen the same footage we have seen. I'm sure they have, but it just comes back to the question, did they know this before? I mean, did the feds know this before? I don't know. I mean, I'm assuming not, because if the whole issue was Canton Police Department was sitting on this footage, they don't want anybody to see it. And it only starts leaking out when I guess it's inevitable that the defense is going to find out it exists, and everybody kind of gambles on the first trial getting some resolution. Nobody's anticipating a second trial. And now that being an issue, it gets explored. People might have to answer questions about. I guess if Canton sat on it, then the FBI might not have known about it, because if the FBI had it, they probably would have produced it as part of the TUI disclosure. Maybe not. I mean, we don't know. We don't know what they chose to disclose and what they chose not to disclose. But I'm not real bullish on anybody making deals with the feds at this point in time, because I'm just not sure that there's been anything really since the first trial that would have changed the feds' view of the situation. I think that the first trial seemed like it was an opportunity to present the evidence that the feds had uncovered and kind of vet that. They didn't get a result from it. So we don't know at this point if they did anything further after that. We really don't know. And the fact that there aren't any charges at this point is also kind of cuts against there being some kind of a deal, because a deal is usually in exchange for something. And what's in exchange for? It's in exchange for being able to get somebody better for a more serious crime, So it requires typically some kind of cooperation. And so if nobody's been charged, what's the deal? What would the deal be for? So, I mean, you can't say it's impossible. We just don't know. So I'd be hesitant to think that this is probably an explanation. I wouldn't go that far, but we can't say it's not. It's possible. CNO, what can defense bring up during Higgins's direct? Anything he's got personal knowledge of. Anything he's got personal knowledge of. All of his prior testimony, all of his prior accounts, his phone, what he was doing with it, the video, what it shows, the video at the waterfall, what it shows. anything he has personal knowledge of or anything that he did or said or whatever that they can independently prove. If they have his location data, he may not have personal knowledge of his location data, but they can ask him about his locations, and then they can potentially use location data. They have a way to get it in to, impeach or refresh him or whatever. So anything that they have that he has personal knowledge of or that they can prove, and of course, subject to all the standard rules of evidence, got to be relevant. It's got to be more, not substantially more prejudicial than probative. Got to be not hearsay, all that type of stuff. But all of it, they can bring up all of it. Lally's superhero is a pickle. Still would like to ask BA about the basement concrete, who ripped it up, where it went, some investigation about this. Yeah, I've heard this a few times now that at some point between this time and then when the Albert sold the house, they did a apparently not even the first basement remodel, like they had done a basement remodel already, but then after this case and before they sold the house, did like another basement remodel, and as part of that, like replaced the whole concrete floor. Seems pretty unusual. Must have been really cracked or really stained, really bad condition. I think the whole reason you get a concrete floor most of the time is because it is so durable. So you don't have to replace it. I don't know if any of that's true because none of that has come out in court. This has just been, information that has been kind of out there. But there, people have sent photographs and stuff like that. Seems to be legit, but it hasn't come out in court. Maybe they would go down that road. Not sure. D Brown 83. Isn't it funny? No one that heard her say I hit him. No one there heard her say I hit him, and they didn't automatically think with her hands, fists. Yeah, why'd they jump to car? I hit him. She's not even there, like in her car. She's just there. I hit him. I mean, I can see how the sort of gendered aspect of it, right? People just generally assume women don't hit, men hit, women don't hit. Certainly not universal. General tendency to be true, probably. I mean, you see that kind of thing in play. This is one of those sex-based differences that you see very, very early in childhood development. The rough and tumble play, I think is what they call it in the studies. Boys like to rough and tumble play with each other. They like to hit. They like to chase. They like to throw. They like to wrestle. They like to grapple. Girls, not so much. Just naturally, nobody's forcing them to do one thing or the other. So that might be part of it. People just don't automatically mentally jump to, a woman hitting with her fists. But they did jump to that car pretty fast. Really not clear. With Jen, we can understand. I mean, at least the theory of it we can understand, because Jen is claiming, she told me she cracked her taillight on the phone, and then she told me that, then she pointed it out to me in the driveway, and I saw it with my own eyes that it was cracked, but I just hadn't put any of it together. Even though she's saying, did I hit him? Could I have hit him? Didn't put any of that together. Just thought she was crazy until she said I hit him, and then it struck me like lightning. I was shocked. That was the explanation that we got. So at least with Jen, it makes sense because she's already got some kind of connection with Karen's car and Karen's taillight, according to her story. But Nuttall? McLaughlin? How are you jumping to her car? How are the investigators jumping to her car? It's a good question. Marie V. Sands, the evidence keeps revealing itself. Now it's materialized inside an evidence bag. Laugh my ass off. It did. Yes, it's just another apparition. We do have strange anomalies in the space-time continuum over here in Canton. That's why we capture them on this very authentic video of inside the Sallyport. Also here in the evidence bags as well, these strange anomalies. Doesn't mean none of it's authentic, guys. Bachelor Junior, I'm way behind, but it's called Parent Alienation Syndrome, and I'm actually in a book about it. Oh, interesting. Yeah, parental alienation, very much a thing. Very common, like more than it should be, unfortunately, in family court. You know, see it a lot. Yeah, parent tries to use the children to punish the other parent. Get the children to withhold affection and so forth from the other parent. I push back slightly on the parent alienation syndrome. The idea of it being a syndrome is largely out of favor. This was this is kind of in the early days when a guy was I can't remember his name now, but he was the one who was kind of first studying this pattern that he was seeing in, family cases primarily, where an angry spouse would try to turn the children against the other parent. He was trying to find a way to kind of make it an objective and systematic diagnosis of a person, but it doesn't really fit well as like a mental health type of category. So that is largely out of favor. It's not really regarded as a syndrome anymore. However, it is regarded as a pattern of behavior, a very dysfunctional pattern of behavior. And it contains, things that are abusive, psychological abuse of a child, lack of caregiving, proper caregiving of a child and stuff like that. So it's not conventionally, looked at as a syndrome anymore, but the phenomenon itself, yeah, anybody who spent time in family court will have seen this. It's unfortunately not uncommon. Josh H., wasn't the taillight evidence in trial 1? Was all this extra stuff in the bag during that trial? No, it was not. If not, how did it get there? We'd love to know, wouldn't we? If only there were some sort of document with people's names on it that we could identify who accessed this piece of evidence. If only. Yeah, who knows? Who knows? One of the interesting little things about all that, as far as the chain of custody goes, yeah, this was all in evidence in the first trial. And so who has custody when it's in evidence? Typically, that's going to be the court clerk. The court clerk is typically in charge of securing the evidence during a trial, maintaining it if it is needed for an appeal. If there's a conviction and there's an appeal and evidence is designated for the appeal, it's the clerk's job to find it, send it up to the Court of Appeals, track it. Normally, it's in the court clerk's possession. So probably it's been in the court clerk's possession, at least at some point between the last trial and this trial. Anybody else have it in the interim? Great question. Great question. 4 knots to nowhere. It's Rocky the Flying Squirrel pulling random crap out of a bag. It did kind of look like that, didn't it? Yeah, just pulling out a little bit of everything. Oh, look, it's a rabbit. Lawyer nurse, duty Ron CSI guy, Ed Wallace, that's Ed, said the plastic taillight parts can be tested to determine if they were broken inward or pulled out looking at the edges. Thoughts on this? Ed would know. He's a smart dude. He is, as you pointed out, a CSI guy. I would expect, as a matter of logic, the pattern of how a thing breaks is going to differ depending on how force is applied to it. It might just depend on, I would expect it would depend on the nature of the material, exactly how it's, it's going to break and what the pattern of breaking is going to be. So I would trust him to know that. You can like look at the edge and the shape of the edge and you can see, I mean, common sense, you look at a window, probably most people have seen like a bullet hole in a window. And you can see the pattern of the break, and you can see like how the glass moves so that you can tell like this is the outside part, this is the inside part. So you can see, okay, this is where the bullet traveled. It came in on this side, it left on that side. You can typically see stuff like that. So yeah, this makes sense to me. I believe that this is feasible. I mean, I don't know anything about the qualities of this material, but just from a common sense standpoint, it seems to make sense to me. So if Ed says it, he's far more of an expert on that type of thing than I am. I would believe it from him. Michelle, in Baldwin trial, the firearm was examined by everyone and their mother. This taillight is supposedly the murder weapon, and they're just tossing the taillight in paper bags. Insane. But who's tossing it in paper bags? We don't even know who's tossing it in the paper bags. It's just being tossed. Very carefully resealed afterwards. You notice that all these things, Trooper Bukhenik had to go carefully cut them open with his scissor technique that makes it look like he's going to put the scissors like through his palm or something. Stabby scissor technique. They've been carefully resecured. It's all part of the theater. This is the giveaway. These are the tells right here. They're putting on this theater of the careful handling of the gloves and the reopening each and every piece of evidence that's been securely taped and there's initials on it and so forth. Yeah, and then you get to the bag, and what the hell is going to be in it this time? It's like Christmas. It's a surprise what's in each and every bag. Giving away the whole drama. How are we supposed to suspend our disbelief when you're putting it in our faces like this? That all of this evidence handling performance you're putting on, it's a bunch of theater. James Casatelli, can a juror ask to have something repeated? I'm having a difficult time understanding this particular witness. She's speaking too fast for my bad ears. Yeah, they can. Typically, you would alert, or they would let the bailiff know, like during the break, hey, any way she could slow down. Somebody put in a word to her or something like that. They can. That's not unheard of, because they do need to understand the testimony. That's your job. That's what you're there to do is understand it. And so it's not doing anybody any good if they can't tell what she's actually saying. So yeah, they could. Now, will they have the assertiveness to do that? That's a who knows. That's a who knows. A lot of times, like kind of we saw with the double jeopardy stuff, they sort of put it back on the jury. Well, you never said we had this other. Well, no, it's not typical that jurors are going to assert, push the process. They defer to the court. So if the court says, okay, we're done, thanks for your service, they're not going to be like, but about these verdicts we did return. So will they is a different question, but can they? Yes, they can. Texas Sister 2, were there fibers on any of the PlayStation-ic lens pieces from the clothes? Great question. There's been no testimony about any of that. No testimony about fibers on any of the plastic. Don't know if there's hooked pieces, sharp pieces of plastic that might, be expected to be receptacles for something like that. But no, we haven't heard anything about fiber retrieval like this. That's a good observation. Good point. Michelle Johans 1, I am so glad I can have your stream in the background today as I am polishing silver on my national costume, and it is not as easy as I hoped. Polishing silver is not easy. There's a way to do it with electricity. I'm trying to remember what that is. Trying to remember the technique. Put it in, I don't think it's water. Is it vinegar? Or is that what you do with the cast iron? I forget. There's a technique you can make it a lot easier, like almost automatic. It's just with electricity. But if electricity makes you a little nervous, then maybe don't try it. But I'm pretty sure I've seen demos of doing it with like a 12-volt battery. Nothing real serious. Not like major, household voltage or anything like that. But anyway, yes, thank you for joining us. That is a onerous task. I don't envy you. Polishing silver is one of my least favorite things to do ever. So appreciate you sharing your day with us. Herbert Whittard, theory, dog ripped pants pocket, phone fell out, Jen butt dials looking for phone. That's a good theory. It seems to fit. We did see when they showed the back of the photos, back of the pants today in that photo, there was a rip. It didn't look like it was a rip all the way down to the bottom. It looked like maybe the first, couple of inches, but it's hard to tell but from where the cloth was placed, you could see a little bit of that rip from that photograph. I think this is a pretty good theory. That's why they need to go looking for the phone. It fell out in the yard somewhere. We could follow that theory for a little bit, and then what did they do with it? And then what? Did it get put in the basement? Did it get left in the bulkhead? Did it stay in the yard? I don't know. Good theory here. A cool breeze. Today's thumbnail had me waiting for Alessi time. I'm always waiting I'm ready for Alessi time. Anytime is Alessi time. Okay. It was wishful thinking on my part, but sometimes you just have to put these things out into the universe and Jaw will provide. Jaw gave us some Alessi today. And I mean, possibly the greatest blessing of all, we get to start off tomorrow with more of an Alessi cross. So that means, oh my gosh, I get to go to sleep excited about what the day brings. Get that stream started. I'm going to be waiting. I'm going to just be waiting for my Alessi time. Yeah, sometimes life is real good. Can't help you, Rhonda. AB in Vallow trial, Lori would repeat the answer received from a witness and judge would sustain the objection. Why is that not happening with Hank Brennan? They aren't objecting much to Hank, I think is just part of the issue. This was kind of the same thing that happened a lot in trial 1. Lally just objected a lot more than the defense did. And so sometimes it could kind of look like, oh, she's interfering with the defense presentation more than she's interfering with Lally's. And he's doing a lot of the same stuff that, that Jackson, for example, was doing or Yanetti was doing. But the problem was the defense just wasn't objecting to it. So it wasn't really the same playing field because it's not the judge's job to interject and say, hey, you need to do something differently. It's her job to rule on the objections that are made. So if they aren't objecting, it doesn't get sustained. With Brennan, they are objecting to a lot of his leading of the witnesses. That is largely being sustained when that happens. But when he just is repetitive and asks the same question, a second time and stuff like that, or like you said, just repeats back what they say, I haven't seen him object to that. So if they do, yeah, it should be sustained. That's not a question. But it's just not happening. Melinderp, Aussie Insider, had a firefighter on that explained they can cut the pocket to get the wallet out without moving the body. Okay, so that's another possible theory. It was cut to get the wallet out. We haven't seen it closely enough, I think, to be able to see if it looks like it was cut or looks like it was torn. I mean, you can see just in the clothing, the photographs that we've seen when they shear it, that looks a certain way. And I think common sense, if you tear it, it looks a little bit different. It's more frayed. It's not so linear. So I don't know if we've had a close enough look to really be able to see definitively, is this torn or is this cut? As far as getting the wallet out, Possibly, but remember now that video from CF McCarthy's where he's stuffing his phone into that pocket. I mean, yeah, he might change what pocket he keeps stuff in, but isn't that, I mean, guys, tell me, isn't that sort of a habit? Do you normally like move your wallet from your back pocket to your front pocket to the other side and stuff like that? Or do you have a consistent place you typically put your wallet? Typical place you put your keys? I just kind of assume you probably have a typical place where you keep that stuff. And so if he didn't keep his wallet in his back pocket, and it doesn't look like he did because he stuffs his phone in and out of that pocket, then yeah, don't think his wallet would be back there. That's my only kind of hesitation with this. His wallet wasn't back there when we saw him on the CF McCarthy's video. So definitely possible. And I think it would help a lot if we could just see those pants more clearly. See that pocket and satisfy ourselves. Is this a tear or is this a cut? Because it's pretty easy to visually tell the difference. Nick TTT, when I saw the Canton PD dash cam during the check on the kids at John's, I was concerned about the taillight looking very broken. However, seeing these pics at the Sally Port looks nothing like the dash cam. It really doesn't, does it? It's much larger in area than what is shown on the dash cam. What's shown on the dash cam, in my opinion, looks an awful lot like what is left. If you didn't watch trial 1, you probably didn't see this, but somebody went through and actually reconstructed the taillight from all of these pieces that they collected. They say outside of 34 Fairview, went and reconstructed the taillight, and nearly all of it is there except for this rectangular spot that's kind of at the top and towards the middle. Oh, do we have a photo of the taillight somewhere? If we did, I might be able to pull it up and show you guys what I'm thinking about. Here we go. Let me just share that with you guys. Right here. This is the reconstructed taillight. So you can see all of this is missing, right? Except for like the little chunk down here that we saw. And there's like a little piece up here that's still there that we saw. But this is never recovered. And that is what looks to me like what is shown, you know, as having some kind of issue in that dash cam video. Not all the rest of this stuff. Just like the one little like rectangular piece at the top. So what makes sense to me is like, yeah, she hit her taillight on John's car and broke this part. That's why they never got those pieces. Because that was the part that was legitimately busted before it landed in the Sally Port, the Canton Police Department Sally Port. All the rest of this, they're able to bust that off and then find it and reconstruct it, because that was all after it was in their possession. But this here, they never got any of that because they didn't have it. It preceded them getting a hold of the car. So that's just my view on it. We'll see what the jury thinks of it, I'm sure. James Stone, just to remind everyone, the Commonwealth is on the side of facts, science, and data. That's what he said. That's what he said this case is all about. And it just happens to be corroborated by Karen's statements. That's what he told us this case was about. Yet we haven't heard a single bit of it yet. All we've heard is I hit him over and over again. Interspersed with clips of Karen giving interviews. And somehow that's, I guess, supposed to be persuasive. Alyssa Ramirez can't stand the Honorable Bev and her Bruce Villainch having head. I don't know who this is. I'm going to have to look that up. Bruce Villainch. Oh, gosh. Cold. That was cold. Oh my goodness. I wasn't familiar with this person, that reference. I'm not going to share that. That might be a little too mean almost for me, but I see the hair. I definitely see the hair. Oh, poor Bev. Poor Bev. You know, women get to a certain age and your hair starts not being nearly as nice as it was. I gotta give her credit. She's still got some thick hair, even with all that bleach that seems to go on it. Still got a decent thick head of hair. PT Glover became a YouTube member. Are you a part-time Glover? Is that you? Good name. Good name. Amy G, no fibers from jumper found on taillight pieces. Not that we have ever heard about. Probably it would be trace that would make that determination. But I would think, you know, Maureen Hartnett would have analyzed it, would have you know, inspected it and seen that it's there and known to send it to trace. So we've never heard anything like this. That leads me to think the answer is no. None was found. Hunter's Moon. Thank you, Andrea. Well, you're very welcome. And thank you for being here with us. Thank you for your support. Kathy Madsen, 5:10 a.m. in Australia. Is that dust on Bev's bookcase? If so, it reflects everything wrong in her court. No respect for her courtroom or us that see it. I didn't notice, but now I'll have to check. Let me guess, like over there where the law books are, a little dusty, undisturbed, no sign of human interaction for significant length of time. How long does it take for things to get dusty over there in Massachusetts? We get dust really quickly over here where I am, but that's because we're a very arid climate. We have a lot of wind. We are, it's not technically a desert. Okay. It's a shrub steppe ecology, shrub steppe. But, you know, a lot of sand, dust, and stuff like that in the air. I'll tell you stories about the termination winds sometimes. It's too long to get into right now, but just major dust storms that would come up back in the 40s and 50s, that kind of era. Dust bowl kinds of things sometimes. So we get a lot of dust around here pretty regularly. Got to dust like once a week or so. It will come right back. But I always imagined on the East Coast it wouldn't be nearly that bad because you have a more humid climate, and you have more. You have a different ecology. You have more, you know, organic soils and stuff. I mean, it's more of a late succession forest. You live on top of you know, ancient mountain residue over there. They're not. I can't really call them a mountain, guys. I'm sorry. I know this is a touchy point at home when it comes to you know, the Blue Ridge and the Appalachian, so forth. Like I know you guys call them. Well, we all know you call them heels. Them thar heels. But yeah, they're mountains, not to a West Coaster. Okay. The Rockies are mountains. The Sierras are mountains. Those things over there, they were mountains millions of years ago, but not so much today. But I don't want to push that too hard because that is a little bit of a soft spot around the Burkhart household. Anyway, it's a different, very different ecology. We have a much more early succession type of environment over here. And so not as much like organic material in the soils, things that tend to hold the soil in place. So I've always wondered about that. Does it take a while for things to get dusty over there in Massachusetts? Makes it look that much worse if it's the case, right? It just goes to the length of time of neglect. Seeing dust on the shelf over here just means you probably haven't pulled anything off the shelf in, I don't know, 5 days, a week or so. But Massachusetts, seems like it could potentially be a lot longer. Lula Bella, Alessi is brilliant. Indeed, he is. He's so skilled. I really enjoy watching him. He's so skilled. He's a step ahead of everybody. He knows where he's going. I can't believe he walked her into inviting the side by side. That was so compelling to me. Because I'm expecting it to be photos from opposite sides of the car. If it's like this and then like that, I'm expecting like the opposite angle. And it wasn't. It was like one step to the right is the only difference between the vantage point of the camera. He just walked her right into it. That was a thing of beauty. I loved it. The rural juror, B as in Bob, like Bob Alessi, your new daddy. Yeah, he's the cross daddy. Bob Alessi is the cross daddy. Hospice Jess, we finally got our cousin Vinny moment with the sticker reflection. Yeah, we did. Would you check that out? Would you check that out? Oh my Lord, how embarrassing. How embarrassing. Your whole testimony to be blown up because you mistook a reflection on a photograph for something completely different. Oh, that's embarrassing. Micheline McWilliams, yes, love Alessi way of recognizing the smallest detail. He is an amazing lawyer. He prepares, man. He prepares. He has looked over everything. I have no doubt he knows every single photo that was taken by any of these people that he's cross-examining. He knows every bit of evidence that's available to ask her about. He has studied it. That's why I won't be surprised at all if we get into water spotting. It's all over those photographs, except for the taillight. Except for that, what's left of the taillight. Andrea McBurnett. Andrea did, I think this is Proctor, blindside her, or is she complicit? I don't think she's complicit in the sense of she's intentionally participating in the frame job. She's just complicit in the sense that she is the state's witness. She's an MSP lab employee. She's on law enforcement side. She does their investigations. She does it at their request. She works with them. She hangs out with them. She talks to them. She's affiliated with them. So she's protecting her side. She's complicit in that sense. A lot of people, typically do that. Dan Greenwood, as defense, doing a cross this brutal, are you just dancing inside? I am buzzing, but if I had to deliver, I'd be high-fiving people. Nothing feels better than a good cross. It really does. It is some of the most satisfying experience that you'll ever have when you're able to just devastate somebody. It really does. Yeah, it feels just as good as you think it does. But you got to keep your court face on, right? Got to keep your game face on. Celebrate after. And then you have a great time. D London 1144. It looks like it's sticking out from the car. Very vulnerable to wind. Yeah, that hair just sat there for 60 miles and then suddenly shifted position right there in the Sally port. Not buying it. Not buying that at all. D Pat, will we see Bev have a light bulb moment when she realizes Karen is not guilty? I doubt it. She's already seen this trial. She already knows the problems with the case. She already knows the problems with the law enforcement activity. She's the one who said, not really a problem. Not really a problem. All this withholding of the Sally port evidence. All the Sally port video trickling out, the multiple competing and not particularly consistent explanations for it. Completely incurious about, so when exactly did the 30-day overwrite start? Because that's your explanation for why the defense expert wasn't able to get it. But yet, peculiarly, there's all this other stuff available from a lot longer than 30 days ago. Not remotely curious about any of that. She knows all that. So no, I don't think she's going to have a light bulb moment. I don't think so at all. Sentient Dreamer, only two things intimidate Bev, the feds and Alessi. Alessi should intimidate her. He handed her whole ass when she came at him. When he had the information, the studies, and she's like, is this a Google search? No, as a matter of fact, this is from my consult with the National Academy of the Sciences head of geology. Judge, just because you do your research on Google doesn't mean that's the game I play. Oh, Oh, put her right in her place. And she has been extremely cautious of Mr. Alessi ever since. As she should. As she should. He is a very dangerous, dangerous man. My dog is my ears. She's just splitting hairs now. Good pun. I think she lost her credibility. Trying to come up with excuses for everything. Definitely lost her credibility when she wouldn't just acknowledge, oh yeah, look at that. That is a reflection. How ridiculous. How funny. I must have just made that mistake. Totally my bad. I think she lost her credibility with that. Jenny Thomas, I've always thought the 6 blood stains could have been dripped from who put John there. No investigative curiosity, should have DNA tested each one. That would have required, proper handling and documentation. They don't even know what blood went into what cup. I don't think they even know if they tested different samples at this point. I have to go back through my notes and see what they said about it. Maybe I can find it real quick in my little recap I've been taking. Let me look for solo cup. Paul Gallagher. No evidence log for the solo cups. Yeah, I don't remember if he got into specifically what he sampled. If these all came from the same spot, if they were like one spot per cup. I don't know. There's no record of any of it. So yeah, I think this is a good point. It really hadn't crossed my mind before that this was from who put John there and not John himself. But it is a viable theory, and yeah, they should have ruled it out. Obviously didn't do that. John Beattybot, note, Ms. Hartnett, did you say you did not swab inside the taillight? If so, the lack of salt spray is not your doing. What might explain that lack? Interesting. Yeah, good point. If she didn't swab the inside, that could be an explanation, right? She's explained her method. You take the swab and you make it moist, and then you rub it all over the thing. So if you're rubbing a taillight with a wet Q-tip, essentially what it is, their whole point is you're removing whatever is on the surface. And so if that's, salt, dirt, whatever, calcium, whatever the deposit is that's causing the discoloration, it would be on your swab and it would not be on the taillight anymore. So possible explanation, except she didn't do any of that swabbing. So they could highlight that. I don't even think they need to ask the last question. They don't need to ask her to explain it. They just need to point out, hey, there's salt spray all over this car, including the back of this car. But there's none inside this taillight housing. Look, it's in evidence. We can inspect it very closely and see nothing there. And you didn't swab it, so you didn't remove any salt spray from the inside of this taillight. Thank you. Nothing further. Jury can make a lot of these connections themselves. You don't necessarily have to, put it right under their nose. Starry Dust. My first husband died 2004 in a pedestrian auto accident in a parking lot. His injuries were massive, broken bones and bruises on most of his body. This case breaks my heart for Karen Reed. Very sorry that you went through that. I'm sure that was not a pleasant thing to see and have to experience. Very sorry for your loss, and it's definitely a traumatic way to lose somebody. Sudden and unexpected, and just unpleasant. Normally you would expect, if somebody is dying from a car collision, you would normally expect massive injuries. You would not expect not a bruise. Not normally what you'd expect for sure. Jenny Thomas, can defense order DNA tests on 6 blood spots? They probably could have, if the blood is even still in evidence. That's $1 million question, isn't it? We've just gotten Maureen Hartnett to tell us what did she do with it. She gave it back to Canton Police. So where is it now? Did they even keep it? Does it exist anywhere? If it doesn't exist anywhere, no, they can't test it. If they just dumped it in the dumpster, then we can't test it. We could only test whatever swab she took. If they still have the solo cups sitting in the fridge over at Canton PD, then they could file a motion to get access to it, do independent testing on it. Probably would have done that already if they were going to pursue that type of avenue. But I have a sneaking suspicion that those solo cups don't exist anymore. It's all gone. Skippy one, salt residue inside the taillight after the road trip. Yeah, the whole time it's been up on the back of that. I mean, the whole trip to Dighton, and then the whole trip back on the tow. It's elevated on the tow, so not exactly sure how the road muck pattern is going to look. But when you're driving on wet road, I mean, doesn't the whole back of your car, you'll get some protection from your taillights, but there's so much mist and disturbance happening. The other cars going by, I mean, stuff is being thrown all over. It's a humid environment. Seems like there should be salt residue there, doesn't it? Dana McGrew, Andrea, you use your left index finger to make the crooked hair and then rotate your finger counterclockwise. C. So for me, it's going to be the right, I think. It was like this. It had the hook on the end, and then now it's a C. And that was the basic shape. And we're supposed to believe that's all because of the camera angle, but the camera is literally like a step to the right. I really thought this photo is going to be from the other side of the car. And so that'll explain it. We're looking at the hair from opposite sides. Of course, it's in opposite positions. No, not even close. And Mr. Alessi was more than happy to show us that side by side. I can't get over it. That was just so brilliant. Walked her right into it. Stacy LeBruno, do you think the jury is going to be plucking out hairs and blowing them around tonight? Like nobody's ever blown a hair before? You know, how many times do you even get a hair stuck to a vertical surface? Like a smooth, enameled type of surface? I can't remember ever having a hair stuck to my car. Get other things stuck to the car. You get, bugs mostly. Hit bugs, you get that bug tar. It's all gross. Can't remember ever having a hair stuck to my car in any way. But it wasn't even affixed there. That's the thing that's weird. Like I could see it if, there's like some bug guts here and the hair just happens to be there and the bug guts dry. And so there's like something that's holding the hair to the car. That would explain this to me a lot better than just a hair is there and it is precariously balanced in this vertical, resisting gravity in this position, and did so for 60 miles through blizzards and snow. And there's nothing whatsoever sticking it to that car. It's so hard to believe. Matthew Madu, hair didn't rotate. It's a receding hairline. Oh. No explanation for that hair. They have no explanation for it. My Mini 67, the heroic hair. The photos of John O'Keefe's car weren't taken by the CSI team. Far too clear. They were taken by the body shop as proof of repairs. Could be. course, he's going to take credit for those photos. They were some of the best photos that we've seen to date, aren't they? Those photos of John O'Keefe's car that means absolutely nothing on February the 3rd. Particularly that driver's side quarter panel that we made a point to get up and look at very closely down there by the bumper. Made sure to get a close-up shot of that. Not relevant to anything whatsoever having to do to this case, but it is some of the best documentation that they have done. Christy, pediatrician here, and I don't order head CT unless indicated. Thank you. That will come as great relief to the ER doc relative who has not very nice things to say about the intrusion of law into medical practice. And understandably, I mean, I get it. Sally Morgan is a new member. Welcome, Sally, to the channel. Thanks for joining us. Meatball Morrissey's Sketty Stain. Our conversations are a lot like our driving. Keep it moving. Take no prisoners. We got to get to the packy. Keep it moving. Take no prisoners. It's a fun chat here, guys. We have a good time. Love when I get to catch up and pay attention. Unfortunately, it's not all the time. Stephanie H., do you think Higgins will testify or Proctor? Will they plead the 5th? I think the defense is probably going to call both of them. And no, I don't think they will. They didn't the first time. I think they're kind of all in at this point. If you change, if you plead the 5th now, I mean, you're basically saying what you said the first time was a lie, because otherwise you could just repeat it and you wouldn't be in jeopardy. Of course, nobody's allowed to draw that inference formally, but that makes sense, doesn't it? If you can't just get on the stand and repeat your testimony, it's because your testimony that you gave before puts you in jeopardy. So it seems like it would be a real giveaway. I think they're too far in it at this point. They've really gambled on nobody's been charged so far. So expectation perhaps that nobody's going to. So why rock the boat? You know, go all in. You're already all in on this. I don't think anybody's going to plead the 5th. We wondered about that the first time, and nobody did. So seems unlikely. Ian Thomas is gifted 5 memberships. Thanks for that, Ian. Very generous of you. Appreciate you sharing the love. Greg Cagle, should he have drilled more about this video she watched this Thursday? Brady violation, maybe? Maybe it's Brady if it's exonerating or exculpatory, and it's also potentially if it's impeachment, that counts for Brady Giglio purposes. I don't know if he needs to investigate it further or not. I don't know if they've seen it, if it's been produced to them. If they haven't seen it, I expect them to do probably something about it, even if it's just as simple as demanding that it be produced to them now so that they can watch it before they finish the cross, and making a record of the fact that it wasn't produced previously, despite apparently being shown to a witness, informing her that it existed, and then showing it to her without ever giving it to the defense. You would make a record of that if that's the situation. But I can't tell if that's what it is or if he's just highlighting how peculiar that you watched a video to prepare yourself for your testimony. I don't know. It's not really that unusual. So it did kind of seem like he was, you're so there's a video. So there's a video, you say. Maybe. See if anything shows up in writing. Jenny Thomas, Alessi is proving evidence planting by cross-exam. He is sure making that the logical conclusion to draw, isn't he? The hair, the bumper sprinkles, they survived this heroic journey. It's awfully hard to believe. Plus, he's laying the seeds for the other pieces of the puzzle that aren't fully in evidence yet, haven't totally been put together yet. But no glass inside that taillight, no exogenous glass inside the taillight, no blood on the car. Didn't investigate the lift gate. They're coming up with that on the fly right before this trial. 3.5 years after the incident, they finally come up with something having to do with the lift gate. And yeah, just all of those hints about how you have no idea when any of this evidence was deposited, do you? No, she doesn't. It's a very, very effective cross. Kelly, prosecution witness amnesia support group. So John O'Keefe had hair made from Spider-Man's web. He's Mrs. Incredible Stretchy to reach the side taillight and tailgate, leaving scratches and dents. Oh, and photo angles change way ends of hair point at away from sticker. Yeah, I mean, I'm willing to give it because it is a black surface and the quality is very bad, and I'm willing to give it the possibility that if it was on opposite sides, that's why the hair would show opposite positions, but it's not opposite sides, not even close, not even close. So it should be pretty recognizable in the same position if it hadn't moved, but it moved between photos after clinging like Spider-Man's web to the vertical side of the car for 60 miles through the worst storm in January in Massachusetts state history. They really do think they're stupid, don't we? Don't they? They think we're going to believe anything just because they say it. Just Because has gifted 5 memberships. Thank you so much for that. Margaret Williams has gifted 1. And Yuri's math teacher has gifted 5 also. You guys are extremely generous. Thank you very much for sharing that with other folks that are here with us in the chat. Amy G, would John O'Keefe width of arm cut both sides of light? I don't know. I'd like to see that in a reconstruction. Surely that's going to be part of this fact, science, and data reconstructing, showing us how John's arm interfaced with the taillight. I have a hard time seeing how, if his arm is, it's long. It's from like here to, midway through his forearm. It looks like it's at least, a foot long, maybe 16 inches long. Is the taillight even that big? Doesn't look like it. Doesn't look like it from this, piece that's been removed here. So I don't have an explanation for this theory. It doesn't make any sense to me, but yeah, the size of his arm compared to the taillight, the placement of the injuries, it's something the Commonwealth better be prepared to explain if they expect people to believe those injuries were caused by that taillight. Buzzcat, AB recovery addict slowed down the DY cross where he asked for a sidebar. You can hear Judge C call him an asshole. Well, that wouldn't be good. That would not be a good hot mic moment to be caught up. Happens sometimes. Haven't seen it. Can't really say anything else about that. I'm sure it'll probably end up in my inbox at some point. Texas Sister 2. The hair could have been transferred to the outside from inside when it was pulled into the Sally port. Maybe. I mean, you have the kind of vacuum change when the car opens and closes, change the wind. Wind movement could change. I mean, I don't know. This hair being there at all just doesn't really make a lot of sense to me. On a very slippery vertical surface, but affixed to nothing, affixed with nothing, just there. It's like a careful balancing act, it seems like. So for that to be achieved coincidentally by nature, I mean, can't say it's impossible, but it just seems very improbable to me. Cad Monkey FPV. So the clerk put the shirt in plexiglass. Nobody took responsibility for that, did they? No, I mean, at some point the evidence seems to have gone back, at least those items, to Bukhenik and Proctor, right? To the MSP, to probably their evidence room, but we don't know. We don't know if only there was some way to document where the evidence was at any particular point in time and who had access to it. No, the clerk just likely had it while it was evidence in the first trial, while the first trial was ongoing. So that is part of the chain of custody. I just point that out because that's like the one piece that you would expect the police not to have documented. It's not in their custody, so they can't document what the clerk of the court has done with it while it's evidence in court. In wings, this is facts, science, and data, baby. Amazing coverage, Andrea. Thank you. This is it, guys. This is it. Oh, hey, I got something from the first trial. I remember. I had to go and specifically clip it because it was just so memorable. So I'm going to go ahead and share that with you guys. Let me get it up here. It was just a classic, very classic moment from the first trial. This is the facts, science, and data, everybody. Got it up. This was the scientific case in the first trial. This is Trooper Paul. If you weren't here with us, this is the scientific case from the first trial.
What do you mean by scientific evidence?
Mm-hmm. Yeah. I just had to clip that. It was too good, too classic. Really the case in a nutshell. Indeed, what is scientific evidence? It was not clear at the conclusion of Trooper Paul's examination, the conclusion of his testimony, that he would be able to answer that question. But that's what the Commonwealth is offering us. Lawyer's daughter, was that Sally Port video today? Was it mirrored? Also, Karen Reed parked in John O'Keefe's garage after she left 34 Fairview. Wouldn't it have thawed, hair fallen off, or when she left to look for him, blown off? Same with glass. Love your coverage and insight. Good point. Good point. Forgot about that. She was in the garage. And so when she opened up that garage door and began to back out into those near gale winds that we've heard so much about, yeah, wouldn't a hair stuck to the side of the car? Not even stuck. A hair somehow attached, clinging to the vertical panel of the car. Wouldn't it have been disturbed by that sudden change in conditions? It's a very good point. Today, what we saw was the photographs. So we haven't seen Sally Port video. She has referenced what sounds like it is probably Sally Port video that exists, showing everybody's actions in the Sally Port with the car that day. So it sounds like it's probably Sally Port video, but they haven't identified specifically. It could also be somebody who is present decided to pull out their phone and record the whole thing. That does actually happen sometimes. You'd never know it from this case where, nobody can be bothered to take a photo of anything that they see. But it does happen sometimes. They'll document searches or things like that with like a cell phone. So we don't know for sure. This is just a guess. Just a guess in part based on Mr. Alessi's reaction to the information. Oh, there's a video of this. You don't say. You don't say. Sounds like it was a surprise to the defense. So we haven't seen it. Don't know if it's mirrored. But very good insight here. I agree about the change. Hadn't thought about that. The fact she did park in that garage overnight. So yeah, she would have gone from a stormy environment into a still one, into a at least partially heated one. I mean, maybe the garage isn't like actually heated, but usually even an unheated garage, you get some bleed of the heat from the house. It's warmer in the garage than it is outside. I mean, I don't think the garage usually freezes most of the time for people. It's more in like that, 50 degree, 55 degree kind of ballpark. I think if the inside of your garage freezes, it's probably a bad thing. So, yeah, very good point. Very good point. Snow on it should have melted. Anything on it fallen off. Back out into that windy storm. And somehow this evidence remained clinging for dear life for the wild, adventurous ride it took throughout the course of that day. Seems a little hard to believe, doesn't it? Very excellent observation. John O'Neill. Glass would have blown off. Proctor broke light with glass, cleaned up, missed shards in snow, on taillight, melted into bumper next day. Sorry if repeat. So I don't think there is a light. I don't think there is a light that got broken. I think this was an effort to try to make it look like it was the cocktail glass. It's fairly thick, clear glass from what we can see. That's what they compared it to when it went to the lab. They compared it to the cocktail glass, but lo and behold, it doesn't match. And it doesn't match any of the other glass that they collected from the scene. It only matches itself. So to me, my theory on this, he just was trying to make it look like it was the cocktail glass, didn't realize they were going to go through and do this, materials comparison that they did and be able to rule it out. I think he was trying to make it look like the cocktail glass. Simple as that. Just spread a little bit around to, build the case. Hospice Jess, off topic. Did you see Andy Baldwin got an acquittal for his client charged with murder in front of Gull? Case ran semi-concurrent with Delphi. I did indeed. And it looked like it was an uphill battle for him in that case, just as much as it was in Richard Allen's case. Exculpatory evidence that he's not allowed to present. If I remember what I read, I think it was Kara Weinecke was, but it might have been Michael Osbrook. One of them had mentioned this victory, and there's health data that would have exonerated her, but he wasn't allowed to present that. Still got the acquittal. Nothing, it's always good when you have a client that you think is not guilty and you get the right verdict. It always feels good, but it's particularly good when, you've had to fight two adversaries. You had to fight not only the prosecutor, but you also had to fight the judge to get that done. Very good work by Andy Baldwin. Z, why John O'Keefe phone and condition not in evidence with clothes? Well, it wasn't with his clothes, right? We have this mysterious chain of custody with John's phone where ostensibly Carrie Roberts picked it up when the first responders lifted John onto the backboard at about 6:15, gave it to an unidentified first responder, somebody who has never been named and who has never stepped forward to say, I'm the person Carrie Roberts gave that phone to, and then ended up in the hands of, I think, Trooper Proctor and then Nicholas Guarino to do the extraction. So there's this mystery gap in there of who had the phone. And then there's the problem with the movement of the phone doesn't correspond with Carrie's story. The phone starts moving at 6:04, which is right when they get to the scene, long before the first responders are there. So that phone starts walking away while Jen and Carrie are down there with John's body, trying to give John CPR. The phone is walking away. Who could have been walking away with the phone at that time? Possibly the same person who mentioned in the group chat, we handed the phone to Carrie. No, the phone is not in evidence. The phone wasn't in evidence the first trial. It's not in evidence this trial. I don't know if anybody will try to introduce it. They got an issue with the chain of custody of the phone. But maybe the jury is going to ask this, and it's a very legitimate question to ask. Phone seems like pretty critical evidence. It's not in evidence. You know, you can examine a phone to see if it's got water damage. If it was lying underneath all of these wet clothes, lying on that cat's track of snow, perhaps a little bit more than a cat's track by this time, underneath John's body, melted by the heat of John's body. TB85, does John's right sleeve reflect the dog being latched on at all? Also, how is there blood all over his front being incapacitated upon being hit? Quite an excellent question, one I've been waiting to have answered myself. Not received an answer that satisfies me on that. I could potentially buy, it was during the moving him from the scene. He's not supposed to be actively bleeding at this point, and if he's been out there since 12:30, blood should be frozen. But I can entertain a hypothetical series of events where John is critically injured and thrown, but doesn't actually die until like moments before Jen and Carrie and Karen arrive at the scene. So there would still be active bleeding up to that point. That blood would be liquid. And then in the course of moving him, some of that blood perhaps spills down some of his front. I could possibly entertain this. I don't think it works. I don't think it matches for a whole bunch of reasons. First of all, just the volume of it, and then the different patterns on the undershirt and the sweatshirt doesn't work for me as an explanation. But just hypothetically, I could potentially see something like that, but not on the shoe. No, the shoe is his head is over his foot. You did not put his head over his foot by trying to like lift him up out of the snow. It didn't happen. That happened while he was upright. So as far as the right sleeve, I don't know what it would necessarily look like if the dog latched on. Like, would that be worse? I don't know. Maybe Garrett Wing will know. Maybe we'll hear. What exactly does a dog attack do to clothing? That could be helpful. We only saw the close-up of the one hole. It looks like a puncture. It does not look like a slice, like a cut. The threads are intact, more or less. They're just, it's been punctured and then pulled out. It looks like a snag. When you snag your sweater on something, that's exactly what it looks like. Lazy L, sorry if already asked, but if an arm broke a taillight, wouldn't you want to swab for DNA on non-exposed parts? Well, that was my question too. I don't know what I mean, this whole explanation that the taillight is what cut John's arm, it seems so implausible anyway that it's hard for me to even try to visualize, like, what are you seeing? How are you envisioning this happening to cause these injuries? I mean, I don't know. Yeah, it kind of seems like maybe you would look at the interior, right? Typically, like if you break something, you break through it. And so there would be some kind of intrusion onto the other side of that plastic. Seems logical, right? So, I mean, yeah, I would think that would make sense. But I can't, I'm not the one to ask to try to make sense out of the Commonwealth's theory. I am just not the one. I don't see it. Yes, I would expect the internal parts of the taillight to be swabbed if the theory is that John's body broke the taillight. But clearly that didn't happen. Daniela POL, is the phone screen broken because water damage or screen as he got hit? I don't know. Good question. We've never seen the phone. We've never seen the actual phone, as I recall. I don't think we've even seen a photo of the phone. Trying to remember back to the first trial. Let me check Sleuthy's spreadsheet. She might have something in there in the exhibits. Phone, there's phone calls. Nope. Cell. Celebrate extraction. Yeah, no. There's nothing obvious that stands out in the exhibits from the last trial. That would be John's phone. I really don't think we've seen it. So I don't think we can answer this. Possible, but not clear. Prime Finder, is it appropriate for judge to call for multiple sidebars on her own? Very frustrating when this happens so often. Let the lawyers do their job. I mean, nothing about this is kind of ordinary, because the ordinary thing is to do what we heard, for example, Mr. Yanetti do earlier this morning. You object and you state in very simple terms, what is the basis for your foundation? We heard Mr. Yanetti say objection, scope. During the redirect of, I forget which one of the law enforcement witnesses, Mr. Lally was exceeding the scope of what was raised on cross-examination. Your redirect is limited to responding to the cross. So it was beyond the scope. He was essentially going back to do more direct examination, and that objection was sustained. That's how you normally do it. Objection scope, objection hearsay, objection foundation, objection argumentative. I mean, whatever. And everybody's on the same page about what the issue is and what needs to be done, if anything can be done, to address it. So none of this is really normal anyway, having to guess. And then, if the attorneys aren't reading her mind, then somebody has to call for a sidebar. It's not inappropriate per se for the judge to call for a sidebar. Like in and of itself, that's not inherently problematic. It's just that in this particular case, it's a factor of so many other strange decisions and just patterns of decision making that are very questionable. I don't know why we don't let the attorneys make their record of what the objection is. It's just bizarre. Just bizarre. Why would we not state the objection? I've never heard of anything like that in another court. So very, very peculiar state of affairs, but it's just the way she does it. I would like to know, Massachusetts attorney out there that's been in trial with Judge Cannoni before in another matter. Were you able to state the basis for your objection? Is this her routine practice, or has she made it up for this trial? I'd love to know that. Certainly isn't the only trial that she's presided over. I don't care if it's a civil trial. I don't care if it's a criminal trial. Any other trial, did she have this rule? I would love to know. If anybody's got a resource out there, put a bug in somebody's ear, I would love to know the answer to that question. Is this routine for her, or has she made it up for this case? Guys, nothing makes me happier than wrapping up a day knowing I get to come back tomorrow for Robert Alessi cross-examination. What a great way to finish. What a great way to finish a day. I'm going to be so excited to wake up in the morning and know that that's what I have to look forward to. We have stipulated exhibits that haven't even been addressed yet. I know that Mr. Alessi knows about primacy and recency. So we haven't even got the good stuff yet. The mirror image humiliation, that wasn't even the good stuff. Oh, I can't wait to see what he have. Plus, I have high hopes. High hopes. Now we are finally actually getting into that. What is scientific? What do you mean by scientific evidence? Yeah, that technical case that the Commonwealth has promised us. I'm very, very eager to see. How have you improved on the absurdity that you presented in the first trial? The strange fever dream scenario with the pirouettes and the arm outstretched and the body being thrown despite not being struck at the center of mass. The inability to count key cycles, all of that. I'm really, really interested to see how they improve on that from the first trial. What have they come up with now? And I'm also curious to see, is Judge Bev going to allow the defense to point out? You didn't raise any of this the first time. We're 3.5 years in, and this is your brand new theory. You're only just now telling the jury pay close attention to that, little protruding piece at the top of the lift gate. Never asked Maureen Hartnett to pay attention to that. And Trooper Paul never noted anything significant about that either. This is a brand new theory. You've changed the entire mechanism of how this accident is supposed to have taken place. Curious to see if the defense gets to elicit that. I would think they should be able to. Doesn't that go to Bowden and the law enforcement investigation? If you're just now saying that the accident occurred in a certain way that has something to do with the upper part of the lift gate, does that speak to your failure to having to investigate that for the last 2.5 years? Seems to me like it does. Seems to me like your failure to investigate that until after a first trial and now going into a second one. Yeah, seems to me like that speaks to Bowden. So I think they should be able to raise it, but is she going to allow them to do that? That's, of course, a whole other question. Whole different question. Is she going to allow them to do it? So it looks like we are finally getting into the goods of that kind of stuff, guys. I'm excited to see where this all leads. So with that, not a bad day today, a little over 10 hours back on our routine schedule. Glad that we have trial again. I did enjoy the day off, not gonna lie. Who doesn't enjoy a surprise day off? Able to get some things done that have been backburnered, but still out there. Chores and tasks don't just disappear because you don't pay attention to them. One of those things you learn. Perhaps it takes a little age and maturity to figure that out, but you know what? Procrastinating doesn't actually make the problem go away. So good to have a little bit of a chance to just go and take care of some of those things that are maybe lurking in the back of your mind, little anxieties, those little things that I'm not, I've said many times, I'm not really a worrier, not a particularly neurotic person, not a lot of anxiety, but everybody has those nights where you just lay awake and there's something tickling the back of your mind, some worry. And for some people it's extensive, lots of things that they worry about, mistakes from the past and decisions that they could have made differently, and things that they did that they regret from back when they were children, stuff like that. Me, it's more things like, shit, did I remember to close the door to the chicken house? That's the kind of worry that I might have late at night. Did I remember to change the sprinkler schedule? Those tasks that just lie out there demanding your attention. They don't go away just because you don't do them. So it's a blessing, really, a gift to have this opportunity of time that wasn't expected. And one of the best things I think you can do with that gift is use it as the opportunity to lighten yourself, some of those worries, some of those anxieties, just go ahead, put your nose to the grindstone, get it done. Starts with a single step. I'm a big believer in the no 0 days philosophy. Lots of times, tasks and chores and stuff like that, they can just seem very overwhelming. There's never enough time. Another thing maybe you learn with a little bit of age, there's never enough time. You always want more than you have. You would always do more than you can. There's never enough time, and it gets shorter and shorter all the time. But you can serve yourself with how you choose to use the gift of time that you're given every single day. So got a nice reminder of that yesterday. Got to alleviate some worries, and now I just get to look forward to a nice Alessi Cross tomorrow. Guys, life is good. Life is good. Jah will provide. Just keep putting it out into the universe, and you might be surprised. You might be surprised what comes your way. So with that, guys, I do want to thank all of you once again. Thank you for being here. Thanks for hanging out. Thanks for your great chats. Still getting glove songs, glove lyrics, guys. Just very, very clever and amusing folks to hang out with. Appreciate when I get to participate in that. Share some of the clever comments and quips that catch my attention. Appreciate the mods so much. Thank you for what you do to help make this a fun place, a good place for everybody. Not an echo chamber. Nobody's trying to have an echo chamber here. We are very open to all perspectives and points of view. All we ask for is respect. Just treat people with respect. Don't be an asshole. Respect the vibe we have going on here. But vigorous debate is something that is valued. You got a different read on the facts? Hey, that's part of what helps us all be better thinkers, be critical thinkers, is entertaining points of view that we may not have thought of initially or that we may not even necessarily agree with. So in many ways, disagreement can be a blessing. Can make you be more critical of your own position, examine it a little bit more closely, and give you a little bit better insight into, is this a strong opinion? Is this a weak opinion? Is this well-founded? So lots of times that disagreement can be a blessing. Appreciate all of you. Thank you so much. Look forward to seeing you guys here tomorrow. Hope you're looking forward to an Alessi Cross just as much as I am. Bright and early, guys, 5:45 our time. Look forward to seeing you then. Take care, everybody.